Your Lordships, kindly, my lord. The matter, your Lordships, refer for mediation has been resolved. Could it be taken tomorrow?
Which one, that party in person one?
That 14% used to appear, that matter, my lord.
But will it be able to, what about him? Is it
Tomorrow, my
convenient?
lords.
Inform him.
I'll send a message to him. Now I given, I'll send a message to him, my lord. So
because-
inform the mediator also.
Or that they have to
Yeah.
appear.
Please, I'll inform both.
No, otherwise it's unnecessary.
Please.
This thing. Tell the court officer, we'll have day after tomorrow better.
Please.
Instead of tomorrow, day after tomorrow.
Day after
Serial
tomorrow.
number 16, this petition.
1 minute, out of the list mentions if any.
List 2, Milord.
Huh?
List 2, serial number 20.
List 2 is also listed. I said out of list.
So you want us to.
Huh.
I am for the respondent. The respondent is the claimant. He is a senior citizen.
Last week he gave one.
I had next week I will be assigning on Thursday. So let it be payment. More matters are there under trial. Ask the board to split up to next
Thursday.
Thursday and Friday.
Page wise.
Page wise adjournment. List number 1. Page number 8. Serial number 35. Page number 9.
My lords,
30.
in that serial number 16, the writ petition has become infractious and filing.
Number 30,
Take that.
number 36, my lords.
1 minute, let her call page wise.
Serial number 16.
A memo is filed stating that the main MC, that's 566 of 2020 itself is disposed of, hence nothing suffices for consultation. Memo is taken on record and dismissed as infraction.
6 months.
He's calling page wise.
Serial number 25 also, my lord. 25 also becoming.
Serial number
Where is the memo? Give the memo.
25 memo.
25.
Memo ಕೊಡ್ತೀರಾ?
Then council submits that the, what is MC or Mr. MC is disposed of, the petition has become infractious, same, like in the other.
34 memo is there on the.
Which one? 34.
34 memo is there.
Page number 8. Serial number.
Memo for withdrawal, 34.
Huh.
Say, whatever the reasons that are stated, look at it.
My lord, serial number 11, my lord, memo for withdrawal,
11.
11, ma'am.
11, sir.
11, RPFC 1, memo will be
It is there in the man.
There is no, nothing. 11. 11 in the second list or the first list? Now you are giving the memo.
RPFC 1, my lord.
Yes.
36.
Matter settled outside.
Oh, see. Next.
Yeah, serial number 39, madam.
Much obliged.
Pray for 2 weeks. Donation of 20.
No, she has to call the list.
I will call, sir.
She'll be calling.
Ah,
Yes.
Page number 9, serial number 36 to 40.
36, my lords.
Ah.
I pray for 2 weeks' time, my lord, because in MFA, maintenance has been awarded.
If it is awarded, why it should be 2 weeks?
Yeah, that's, I want to put to my client whether it survives or not, that's the reason.
Not 2 weeks, 1 week.
Please,
This is matter
please.
after we. have
I'll
you
inform the other side, my lord.
It is submitted that the council has informed to the respondent council. This is matter after a week. Give a date, look at the matters.
39. 39.
Yes.
Serial number 39.
39.
I pray for 2 weeks. Here on condonation of.
No, I think why are you seeking time? You are for the petitioner.
No, I am for this.
So they have to file their objection.
I am for the respondent objections and file.
Ready?
Ready.
Filed?
I have it in the file. So I have served the copy via mail. I'll file it today.
Yes. This is matter next week, same date in the earlier matter.
100.
Yes.
Page number 10. Serial number 41 to 47. Page number 11, 48 to 55.
Who appears for the respondent?
That is Viranga Tigri.
They are also agree. No, they are also ready for mediation. Both the council, the petitioner submits that the matter may be referred to the Lok Adalat. It is even for the council for the respondent also. So agreed for the same. Yes. Shall appear before the mediation. Give a date, time.
7A.
Hmm.
Serial
Next.
number, page number 12, serial number 56 to 61. Page
Yes.
number 13, 62 to 68.
67, my lord.
Hmm.
2 weeks time I will get.
Why?
Personal inconvenience. I am not keeping.
Not well. Liz is smarter on 19th of August.
Interim order my candidate.
Have you informed the other side?
I'll inform. First time
Pratima
I.
SK.
2 weeks we can't grant without informing the other side.
Weeks time.
Liz is smarter
On 13/8.
on 11th of August.
11.
Published.
It is submitted that the council is not feeling well.
Yes.
Yes.
Serial number
Please
4.
inform now itself. Yes.
Page number 14, serial number 69 to 73.
70, my lord,
Hmm.
appearing for petitioner. I informed the respondent side, madam. Kindly taken up on next week, my lord. Senior is still in hospital, still not recovered from the hospital, madam.
Next week, at the request name, inform to the other council, 13th of August.
Much obliged. Interim order may be extended, madam.
Serial number 67, interim order is there, madam.
Wherever interim order is there, it will be extended.
Much
Yes.
obliged.
Serial number
Page-
71,
Hmm.
parties are in mediation. It is listed today for mediation. May I request for any other date convenient? to the
When
court?
is it? When?
Today, mediation is today.
No, that I understand. When do you want?
If 7th of August is convenient,
Yes, 7th of August, it is submitted that the parties are appearing before the mediator. Yes.
Page number 15, serial number 74, 75. Page number 16, 76, 77. Page number 17, 78, 79. Page number 8. 18, serial number 80, 81, 80.
List number 2, all the matters are referred
My
to
lord.
mediation.
Serial number 8 in list number 2, my lord. Matter was already referred to Lok Adalat. It has failed, my lord. Matter has to be
Delete-
heard.
Delete 8 from the
Serial
list.
number 8, my lord.
Yes, deleted. Yes.
That's 25 minutes, serial, list to serial number 25 minutes.
Hmm.
It was referred to Lok Adalat,
Hmm.
whereas the parties did not.
Yes,
it has
25 delete from the list. Yes.
obliged.
Serial number 2, your lordship. That matter, there is a settlement already. We have to move the MFA, so no mediation is required.
Serial number 2.
So then RPFC itself can be closed.
Pardon?
RPFC itself can be closed.
Yes, we will first move the MFA
Yes.
and then.
To delete. Yes, next.
My lord, serial number 28
Ah.
for mediation in Shumaga, my lord.
Serial number 3, I'm sorry.
Serial number 3, not 2. Yes.
28, my lord. Can
Which
you-
one?
Serial number 28, list 2.
Uh,
You refer to mediation in Shumaga.
uh. It should be on?
That is on 14/8.
Yes.
Your ladyship, serial number 33 of list 2.
Hmm.
It's an RPFC matter.
Hmm.
The respondent has filed an execution under section 125 clause 1, which is listed tomorrow, your ladyship. Pending mediation, if they may not precipitate the same, I will continue paying the maintenance, your ladyship.
No, that is like you have to get it in a regular list.
I
should
had,
have
I had
come.
moved it for regular listing itself.
The list
However,
is smarter. List is smarter
Execution is listed
No, no,
tomorrow.
list
I'm
is
ready
matter
for,
tomorrow.
I'm ready for hearing on merits today, your ladyship.
tomorrow. List is smarter tomorrow. Yes.
Serial number, which number?
Let's call the list.
Which number?
Pending matter, your lordship. Memo I'm moving for tomorrow, your lordship.
What is that matter? Why is it
Your
tomorrow?
lordship, it is with respect to the increase of maintenance.
We will list it when the court has the list permits. Take it.
In fact, previous occasion, last week, I.
But there are matters. It's not possible for the court to hear all the old matters. Yes.
But now for posting for a MFA, my lord, the parents are filed the appeal for death of his son. Only authentic.
Listed on Thursday. Yes.
List number 1, for being spoken to serial.
I'm
number-
appealing to the petitioner in this
My
matter, my
lords.
lords. The matter got disposed of before your
My
lordships
lords, I
on
have moved the
15
memo, my
July.
lords, to be
So
spoken
it's a
to.
specific direction in respect of IA number.
We understand. She
Yeah,
is the
I
one
moved
who
the-
has moved it. What is your objection? You can tell later. Let us leave.
Sure,
Listen
my
to what
lords.
she's
Let her,
saying.
yes, my lords.
My lords, I have moved the memo to be spoken to, my lords. This case came to be disposed on 1st of July, my lords, with the direction that IA number 22, which is challenged in this writ petition, needs to be heard fresh by the trial court. So the matter was sent back with a duration that it has to be disposed during 2 months period. Now, my lords, before the trial court, the objections for IA number 22, we had filed on 17th December 2024, my lords. Subsequently, the order came to be passed in the month of April 21st.
Before going into any of it, In this order, what is that for being spoken to? That you tell.
My lords, in the paragraph, so the question that raised was by the trial court, we wanted to file additional objections to this application because after order has been passed, there were subsequent events that took place because the child had gone with the father to Hyderabad and spent 50% of the vacation. During vacation, lot of incidents had happened, which we wanted to bring to the notice of the trial court, and we went to file additional objections, which was opposed by the respondent counsel and which is the petitioner here, by stating that they have highlighted paragraph number 9 of this honorable court's judgment, my lords. May I read, my lords?
Yes.
My lords, here,
Pictures before this court, I
bef-
said it is not.
exactly, my lords, before this court,
But you have to understand one thing. If the order of the court is interpreted by a party and it is understood by the court, for that, the court will not clarify it. I have stated it, it is very much clear. You wanted to file objections here. I have referred to Article 227. This is the petition filed before the court. No objections are required. If the understanding or interpretation by the advocate is something else, for that I need not clarify the order.
my lords, the same thing was conveyed to the court and court is also understanding
But
it
I
in the
can
same.
do. What is
My
that
lords,
I
a
can do?
direction that we can, because that
that
is not been accepted by the trial court, my
The
lords.
way if the understanding of the advocates and the judges have to be clarified from the order. If I say that you cannot file any objections, I can understand. I said in a writ petition filed under 227, no objections are required. Court is only looking at it. The present petition is filed about the
My
matter
lords,
is-
one submission. My lords, they are misrepresenting the facts, my lord, which is clearly
No,
being
is
heard.
is it the duty of the court?
No, my lords, a direction may be given
Why
for
should I
not,
give? Why should I give? Is it a scope of for being spoken to?
my lords, there,
You tell the court why a for being spoken to petition can be moved.
if there is any clarification, my lords.
What is the clarification? It is
There
for
is
being
no
spoken-
mentioning about us not being able to file an
Then I
objection.
have not said so. If
Yes,
somebody
my
is
lords.
understanding, I don't have to clarify. This court has disposed of the matter in the said order. This court had, at paragraph number 9, when the counsel appearing for the mother wants to file objections in the writ petition, court had clarified it. This is a petition under 227, and whatever is the material before this court, that would be considered, which is filed before the court, and no objections are required. Now it is a case of the respondent that the counsel for the husband is interpreting the said order in a different manner, and the court is understanding it in a different way. If that is so, that is not the concern of the court, and for that, the court will not clarify the order. Yes, accordingly ordered.
Cell number 2,
Much obliged.
Much obliged.
Leeladhar HP, petitioner. Latif B.
I'm filing a reply to the memo of calculation filed by the respondent to your worship. As per my claim, your worship, he has to pay totally 6,27,000 rupees towards the maintenance charges and also education charges of the second petitioner. That has not been paid.
Where is your statement? You
I filed it along with that one. Your Honor. I have stated in para number 3 and 4. Your Honor. I have
It should be.
No, bank statement.
Tabular
Yes,
form.
I will file.
Do
In
it, we
tabular
can't-
manner, I will file it.
Now it is served, I have take instructions.
Tabular form, I will file it.
And
File.
Much.
To the calculation memo that is filed, to the land counsel for the petitioner wife has filed a calculation in the form of paragraph. It should be in the tabular form, and land counsel for the respondent submits that now it is served on him. He shall also get instructions in this regard. This is a matter on.
further, one more. Lord, we are remitted the amount to their accounts. Lord, let them place the statement of account
That
of,
has been explained in the objection.
let them place that bank statement, Lord, because Lord,
From when you are remitting the amount,
the dates where I have mentioned it in my memo.
it is.
He simply mentioned he has not produced any document in
Yes,
support of
yes.
his claim, Your Honor.
There's a bond is cleared.
In the memo, the petitioner, the
Respond.
husband has stated on what dates the amount is remitted to the account of the wife. If the
Wife and
is
daughter.
wife and daughter. If the wife and daughter are disputing that the particular amount is transferred, they should place before the court the bank, so the statement for that particular dates and periods which the husband is referring. When do you want?
15 days time, because I want to obtain certified copy of the order sheet. Thereafter, I will please before the honorable court that also.
This matter on 22nd of August,
Much obliged. Great.
delete from Butthard.
Total three cases.
Hmm?
Three cases.
Yes.
Cell number 3. Manohar for petitioner.
Yes,
Here for
Lordship,
respondent.
Mr. Manohar is for the petitioner. Compromise talking is taking place today itself also.
No, Your
along
Honor,
with-
no
along with
such,
the respondents.
Please argue.
Therefore, kindly have it on next week, my Lordship, it is.
He is saying
If the
that.
writ petition is dismissed, nothing will happen, my lordship.
uh,
15,000 is awarded in the year 2023. That has been stated by the honorable court and making the petitioner.
Let him argue,
Yes.
let him argue,
Yes,
come to the order,
Yes, lordship.
come to the impugned order.
Pass over, madam. Brother Manohar,
Pass
Manohar will
over.
come.
Cell number 4.
Yes,
Kalro for petitioner.
I am for the respondent husband on
Your Lordship, it is for the enhancement of the petition. The trial court has ordered 5,000 rupees. The income of the petitioner is 1 lakh per month. And he shows his expenses at 1,20,000, which is a fact which, you
come to
know,
the impugned order straight away. It would save your time and the court's time both.
yes, Your Lordship.
Yes. Where is the impugned order?
Page 25, 5,000 has been ordered, Your Lordship. We've asked for 80,000 rupees for the mother and the child.
1 minute. 5,000 to petitioner number 2 daughter. Why if it is
Not ordered.
rejected?
It is rejected.
Where is the finding? Come to the finding. I think yesterday I heard
Yes,
this
my lord.
matter.
Yes.
Yesterday,
Instructions.
my lord, the respondent husband said he has been paying insurance to the, he has taken the policy in the name of the daughter. He has been paying 4,300 per month towards the premium of the LIC.
Yes.
And
let us
also,
take
he-
it 4,300.
Yeah, ma'am.
No, this is 5,000 that is awarded.
yes, ma'am.
Still it becomes 9,300.
Yes, ma'am. If against 5,000, if it is enhanced to 7,000 also, he can accommodate.
We will enhance this to 15,000.
Sorry, madam.
Your Lordship,
He
there
has
is
take-
no education expenses ordered at all, Your Lordship. We had asked for education expense from the last 3
They're
years.
also working.
She's also working, Your Lordship. But there is not even
What is the salary?
1 lakh rupees, Your Lordship.
Hmm.
My client is earning 84,000, Your Lordship.
Hmm.
So she's from the last 3.5 years, from the year 2023, there is no education expenses paid up. It's almost 2,30,000 per year.
So what we will do is 5,000 is already paying towards
Yes.
the insurance.
Yes.
We'll make it 20,000.
Sorry, my lord. My lord, the respondent, she is also working and the school, the child is admitted is of a high class, which respondent can't accommodate because
Anyhow, that's why we are not granting educational expenses.
Normally,
I'm
that's-
only saying 20,000. 20,000 per month.
Sorry, my lord, it's a little bit higher.
I'll record that.
My lord, it may be made as, against 5,000, it can be 10,000. please.
Agreed
Your
with the
Lordship,
orders passed in I number 3 in Criminal Miscellaneous 633 of 2022 dated 18th November 2023, whereby the court had rejected the application of the wife for maintenance. Where is, I think she has not filed it. The application filed by the wife is rejected and an amount of 5,000 maintenance is granted to the daughter. The agreed thereby, the wife is before this court seeking enhancement as well as seeking maintenance for herself. The wife had filed a petition seeking monthly maintenance of 80,000 to herself and to the daughter and also litigation expenses of rupees 1 lakh. It is a case that the income of is earning an amount of rupees 1 lakh. That the husband is well educated working as a technical consultant at Sonata Software. And and his monthly income is 1 lakh. Though she has been working, it's a duty of the husband to take care of his family.
Daughter. She's a daughter.
No, it's a duty of the father to take care of the family. That's what she said.
One submission, madam. The respondent only left the matrimonial home. So that fact I want to bring to your lordship's notice
That's
because.
what I'm saying, when I'm not granting maintenance to the wife, that is not at all relevant. Whether she left, deserted.
No, my lord. Again, this 20,000 per.
To the child.
Sorry,
He's to the child,
child,
to the mother.
even if,
How
even
much would be the school expense in a year?
2,30,000 is what she's
My lord.
saying. Other than that, the child goes to daycare, your lordship, because the 2 o'clock the child.
What is the age of the girl?
It is 7 years old, your lordship. 7 years old.
6-year-old, my lord.
6-year-old. She.
What is the school fees?
2,30,000. She goes to Victor.
Please come.
My lord, that school is not the
That's why
standard
we're not
of
asking
the
you to- we're
respondent
not-
petitioner.
Court is not asking you to pay the court fee, the school
madam.
fees, that's why.
The school is of her choice, which she is supported by her father and.
It is right. Take care of the family, which she has failed to do so. In spite of the fact that she's working, she's still not able to meet both the ends. And she has sought for maintenance of 80,000. The husband has filed his objection, stating that her salary is more than 1,50,000. And her father is also financially capable. It is also stated that
That
he has.
Submission during the cross-examination now, which I couldn't submit the copy. He has accepted that he earns 1,30,000. 1 lakh was in
That,
2023, now he's earning 1,30,000.
And wife is also getting more than the whatever husband gets now. madam.
Then we'll do one thing, we'll set aside this order and send both of you to the court. That's
No,
better.
your lordship, I just made a
Yes.
submission with.
Financially, what is that? How financially capable. And as she's earning, she's not entitled for any maintenance. The husband, in a statement of assets and liabilities, he has stated that his parents as his dependents require 1,16,000 to 499 to visit maintenance. The court, considering the fact that the income of the wife is 84,000, the income of the husband is 1 lakh, had directed the husband to pay now an amount of rupees 5,000 towards the maintenance of the daughter and litigation expenses of 10,000. Next paragraph. When counsel appearing for the petitioner mother submits that even if the wife is the wife, not mother, then counsel appearing for the wife submits that even though the wife is earning, is a responsibility of the husband to take care of the family. When the husband's salary is 1 lakh and the wife's salary is 8,000, court had refused the case of the wife and granted maintenance of a meager amount of 5,000. It is submitted that the court ought to have considered the requirements of the child and the financial capacity of the husband. It is submitted that the wife is entitled for maintenance, and the maintenance of an amount of rupees 5,000 that is granted needs to be enhanced. Next paragraph. Then counsel appearing for the respondent father submits that though he's earning an amount of rupees 1 lakh, he has other responsibilities. He has to take care of his elderly parents, and also he is paying an amount of rupees 4,300 towards medical insurance of the child.
This is life insurance.
Huh?
Life insurance.
Life insurance.
Please, ma'am.
Life insurance of the child. And already court had granted 5,000 it is submitted that the wife has joined the child in a school where the fees runs into lakhs, and it is not the husband's financial capacity to pay such a huge amount. It is submitted that the amount of 5,000 that is granted by the court is a reasonable maintenance and no interference is called for. Next, having heard the counsels on either side, produce the material on the court. The undisputed facts are the husband's income is 1 lakh, the wife's income is about 80,000. The child is taken care of by the mother. According to the husband, is paying 4,300 as a premium towards the insurance, and 5,000 is already granted. And as mother is earning, that amount is sufficient. And it is the case that she has deserted the husband. None of the submissions of the then counsel for the husband can be considered by this court. If the wife has deserted and if she is not staying, if the court deserted the husband, then if the maintenance is awarded to the wife, then all these aspects the court will consider. Now, when the maintenance is to the daughter, that cannot be the consideration for determining the maintenance. When he's earning 1 lakh rupees towards the child, he has an obligation which he has failed to discharge. The submission that she's earning and her father is financially sound are not the reasons for the court to consider in those circumstances. And as far as the wife's maintenance is concerned, court had rightly held that she is not entitled for maintenance. This court do not find any reasons to interfere. Accordingly, the court is passing the following order. The amount of maintenance that is granted to the daughter is enhanced from 5,000 to 20,000. Accordingly, the petition is partly allowed.
My lord, on submission, the order can come into force from today till disposal of the criminal petition, criminal miscellaneous, whatever they have filed.
From the date of application, right?
My lord,
Next.
my lord, one more point. My lord.
Cannot.
The trial court should not be influenced by this order file passing, disposing.
Of the court shall not be, any of the observations that are made by this court are only for the purpose of deciding this interlocutory application, and the court shall decide the main petition uninfluenced by any of the observations passed by this court. Yes.
Much of it.
Next.
Chair number 5, Summa for petitioner, Krishna S. Vyas.
Appearing for the respondent in this matter. Let's, the asset and liability statement of both the parties have not been brought on record. I had also not been given appropriate instructions, my lord, so it has to be brought on record for appropriate consideration. Even otherwise, as it
The
is for.
petition, you have not chosen to do it from 20.
Yes, please, my
While
lord.
it is before
Yes,
the
please, my
court.
lord. I concede with it. I would draw the attention of this honorable court to page number 50, my lords.
Is the petitioner, yes, to argue?
Yes, please, my lords.
Yes.
My lord,
Where is the order? Page number?
53, my lord,
Page number?
53.
$7,000.
Yes, my lord.
Where is the discussion with regard to the husband's income?
At page number 50, 51 and 52, my lords, starting from paragraph number 10. That is all I wanted to know before this.
Please read that from paragraph number 10.
But in that case, like, I like to produce the salary slip, my lord, of a respondent.
Where? Before the trial court?
No, my lord, I thought of
You
filing.
will not look into any
No,
of the documents here. Yes, please read paragraph number 10.
Yes, my lord. The petitioner wife has filed an assessment liability stating that she is a BCom graduate, 35 years old, lady, and their marriage performed on 17/6/17, date of separation 25/6/21. Further, she stated that she has been making general expenses of rupees 15,000 for.
What is your salary according to you?
My lords, I have a take home of 49,000, my lords, which has been absorbed by
No,
the
no,
court.
not take home. What is your, the net salary?
My lords, net salary have not been informed, but 75,000 is what the party has
What is
informed.
the,
me.
what is the
lakh-
salary certificate issue?
1,13,000,
That is what
my
is
lord.
his instruction, then we will say, then you
1,13,000.
give it to him.
The asset and liability statement also has not been brought to my notice.
Other assets and liabilities will not, at least the salary, there should be clarity.
And plus 70,000 as a rental income, my
But,
lord.
net income is 49,610.
What is happening, 1,16,000 to?
My lords, there have
Purposeful
been
deduction,
loans
my
which
lord.
have incurred
All
in the
those
interregnum.
deductions court will not consider unless they are the statutory deductions.
My lords, statutory deductions also to a
10,000
largest
maintenance that
extent
is
are there,
granted
my
to the
lords.
wife with an income of 1 lakh.
My lords, the outstanding loan is only to an extent of about 10 lakhs, my lords, out of which there is an amount which has been deducted from him, which is about 15,000 rupees per month. All others are statutory.
A total deduction,
Can
what
be
they're
seen
saying
from
is
this
63, my lord.
copy itself, my lords.
They have taken the loan
All others are
purposefully, my
statutory
lord.
issues.
What are the statutory deductions?
My lords, statutory income tax, my lords, 13,000 and odd. Professional tax of 200 rupees. Rent recovery quarters of 319. Furniture recovery 63. Then festival advance you would have taken, my lords, for that hardly about 10,000 has been debited. Then outstanding liabilities, my lords, 5,840 has been debited, which is again by the department themselves. Then demand promissory 1, my lords. 2,250, demand promissory 2, 5,661. Loan 15,000. It is a substantial part. Then staff welfare fund, my lords, 500. CBOA 125. CBOA benevolent fund 175. Defined contributory pension is 9,551, my lords. So everything put together, what he is receiving on a hand is 49,610. Even as per the record, what is being provided to this court by the other side. My lords, he also has his own house to take care of. And he was in the intention of taking care of the petitioner, my lords, but the petitioner had deserted him. Therefore, he was pushed to now face
False
the
allegation,
difficulties before this honorable court. But however, these are not material part of the consideration for this honorable court. He has parents to take care of, which also he has brought before the court. And my lords, the petitioner herself is employed, who has been gaining about 35,000 rupees per month, which has been camouflaged from the notice of the lower court. So asset and liability may be required to decide this, my lord.
What material you're saying that she's working?
My lords, from reliable sources, he has been received information that, my lords, 35,000 she has been drawing, my lords.
She's an unemployed, my lord.
I will try to gain the documents for that.
That
But
we do
however,
it before the trial court, not in this.
but however, my lords, this is all the meager the amount that is left out with. 7,000 has been gained, and your lordships may kindly see, my lords. At paragraph number 11 and 12, there has been an elaborate description as to why this decision was taken. On the other hand, the respondent also filed an affidavit of assets and liability statement, in which he disclosed that he is also 38 years old, so MTech graduate and residing in his father's residence situated at so-and-so. He also stated regarding the general expenses of 15,000 for household
15,000.
expenses.
We'll increase it to 15,000.
15, my lords.
My lord, in the same paragraph number 57, my lord, or page number, the respondent state that he is an old age, look after the mother and the father and the sister and the nephew. He doesn't want to look after the wife. He want to look after the sister and sister nephew, though they are married.
Please come. Agreed with orders passed in I number 5 in MC number 5300 of 2019 dated 17 January 2023, whereby the court has granted an amount of rupees 7,000 towards the maintenance.
And there is a rental income of 17,000, my lord, he is getting, my lord, for which I have, I'll produce the deposit of title deed which has been deposited in the bank, and he has got the 70,000 rental, my lord. And he is earning, because that is total comes to 1,93,000, 93,000, my lord. The total, because he's getting because he's a sole and he's residing in the residence plus
Deny
commercial.
that you don't get the rental income.
My lords, this is a new contention that they are raising
No, my
before
lord,
this court.
that's
My lords.
why
I
I'm
am
putting the
completely
document, my
unaware
lord.
of it.
The respondent shall file before this court an affidavit to. it is
Asset
a
and liability statement, I will produce. my
Not
lords.
all that we don't want. The land counsel for the petition submits that apart from the salary, the respondent is having a house, and from that he is deriving an amount of rupees 70,000 towards the rental income. The respondent shall file an affidavit before this court in that regard. Let's this matter on 14th of August.
Cell number 6.
May it be, my lords, on 13th if it is not difficult for this honorable court.
13th.
13th. Much
Serial number 6.
My lords were pleased to hear this matter on yesterday.
Respondent, kindly await for Monday, my lord. Senior having eye inspection.
My lords, they've been doing this for a very long time, my lord.
Monday.
I'll pass over it. If he wants to come,
The hospital is my lord.
then I'll pass orders.
Monday you can do it, I will only do if it is not.
I'll not grant time.
If it is not unwell, I
Third
will only do
learned
my
counsel
lord.
for the petitioner, there is no representation on behalf of the.
Monday I will only my lord.
respondent.
I will only do my lord.
Why you do it today?
He has given not instruction.
At the request of learned counsel for the respondent, list this matter on 25/7. How many times you'll ask adjournment?
Oh, this is the last time.
Lords, this has been a,
Monday I will only do if unwell.
my lords, this has been a trend. Yesterday, they took a Passover.
I don't want to waste time on this. List this matter on Monday finally. This matter has been adjourned on several occasions at the request of respondent. On Monday, if there is no representation, this petition will be allowed with costs of rupees 50,000. Yes, next.
Grateful,
For
ma'am.
dismissal, serial number 6, 7. Serial number 7.
Huh? On 21/7/2025, a memo of retirement filed with the land counsel of the petitioner that the client is not completely in contact with them. A notice dated 31/30/10/2024, 12/30/12/2024 was sent to the client that he would be retiring from the case, and the same was returned on. The same was served on 33/1/2025. Accordingly, this court has permitted the counsel to retire, directed to print the name of the parties. Accordingly, the parties' names were printed on 29/7/2025. Huh?
Respondent.
The parties' names. So there is no representation. Accordingly, dismissed for non-prosecution. Yes, next.
Serial number 8.
I appear for the petition.
Patel Srinivas.
No more is fine. Same, let's have, this next.
Serial number 9. Serial number 9. Raghavendra N.
Petitioner, my lord. The petitioner has complied with the order passed by the honorable.
Then please argue on the merits.
Please.
Argue on the merits of it. We will dispose it of 2021 RPFC.
Please, my lord. Senior is out of session, my lord.
It is submitted that the order of this court, interim order of this court is complied with. List this matter on 12th of August. No further adjournments will be granted. It will be heard on the day finally. Yes, 10.
Serial number 10.
Delete from the caption for dismissal.
Serial number 10. Gadilingappa.
See that file. On 23/7/2025, the matter is listed before this court as no representation. Directed the matter to be listed today. Today also there is no representation. Accordingly, dismissed for non-prosecution. Next.
Serial number 11 disposed. Serial number 12. Narayan Reddy.
Yes.
12. Let seal number 12, my lord.
12 is called.
12.
Uh.
Let in this matter, my lord, that is settled before the trial court. I may be permitted to withdraw the petition.
Then counsel appearing for the petition submitted the matter is before the court. Accordingly, dismissed as withdrawn. Yes,
Serial number 13. Mahesh M.
ask him to give a memo. Yeah.
Memo. For withdrawal.
Yes, 13.
Serial number 13. Mahesh M.
Same, so on 23/7/2025. No. On, when the matter listed on 21/4/2022, there is no representation. Again, when the matter is listed After that, on 23/7, also there is no representation. Hence, the matter is listed today under the caption participation. Same. Yes, next, 14.
Number 14. Serial number 14. Pradeep M.
Petition in this matter. The respondent number one has initiated 125 proceedings after lapse of 13 years desertion and without having jurisdiction before court, your lordship.
Please
And
come
this
to the
case-
order, we'll see.
Please.
Why the court has no jurisdiction?
Please, your lordship. In the petition, in the judgment, cause title, your lordship, the petitioner's address is mentioned as presently residing at industrial area, Srirampura, Sriramanagara, Davangere. To that extent, she has not produced any initial records before the trial court. Only after the cross-examination to the PW1, she has changed the Aadhaar card to the police quarters address and led the evidence, your lordship. The petitioner's father is the public service in police department having
All these grounds
Please.
should be raised before the court.
we
By
have
way of-
raised before that.
By way of your objection. Now, at this stage, we will not go into those.
Please, your
aspects.
lordship, I have raised and the honorable trial court was mentioned in paragraph number 8.
Please read that.
With your lordship and permission, at page number
Let's read the
8.
the entire order from the reasoning part.
Please, I'm directly going to the reasoning part at page number 8, your lordship.
Yes.
Immediately after 7th line, your lordship. PWN has stated that she is residing in the address given in the cause title and denied that she has not produced any document to show that she is residing in the address given in the cause
Where
title.
are you reading?
Please, please.
PWN has admitted.
PWN has admitted that she has not produced the document.
Please read.
Please. PWN has admitted that exhibit P3, her address shown as Bandhati. This Bandhati is presently, she has been residing in Chalkere, your lordship, for past 13 years.
We'll complete.
That come to
reading
the
it.
Chitradurga district, your lordship. In exhibit P5, in her address is shown as Chitradurga, but stated that said documents are old documents.
You better read from page 8 from the starting. I'm not able to find out where you're reading.
Please.
PWN has admitted that one Netramma. That's how.
I will read from that. PWN has admitted that one Netramma, the daughter of the father, born through second wife, and he is also given marriage to the brother of the respondent. PWN has stated that now she is residing in the address shown in the cause title. She has said in the cause title address she is residing. PWN denied that her father giving education to her children. Further, PW1 has stated that she is residing in the address given in the cause title and denied that she has not produced any documents to show that she is residing in the address given in the cause title. PW has admitted that in exhibit P3, her address shown as Budnahatti, sorry. In exhibit P5, her address is shown as Chitradurga, but stated that said document are old documents. PWN has denied that in order to avoid the responsibility of performing the marriage of the respondent's 5 sisters, she is residing in the paternal house. PWN has denied that she has filed this petition under section 125 CRPC. The civil suit is not maintainable. PWN has stated that exhibit P9 not produced at the time of filing of the petition, as no one has insisted for the same. PW1, so kindly see that while filing of the petition without having jurisdiction, the petition, the respondent P9 is recently created document. PW1 has stated that since 13 years, she is residing separately as the respondent has deserted her. Per contra, the respondent himself is exempt as RW1, who in his affidavit.
Paragraph number 12, paragraph 12.
Please, on careful perusal of the entire order, entire oral and documentary evidence on record, it is clear that the petitioner number 1 is the wife and petitioner number 2 to 3 are the children of the respondent, and now they are residing away. Now they are residing away from the respondent. The allegation of the respondent that the petitioner are not residing within the jurisdiction of this court is falsified by the petitioner by producing the Aadhaar card at exhibit number P9. Of course, in exhibit P5, the address of the petitioner number 1 is shown as Chelkere, but it appears that thereafter she has shifted that residence to the address shown in exhibit P9. Therefore, the major contention of the respondent that the petitioners are not at all residing in the address shown in the cast title holds no water. While filing of the petition, Your Lordship, she has not produced only after cross-examination.
That contention I have seen.
Please, please.
Come forward.
The fact that the petitioner and the respondent are residing away from each other is not seriously disputed by the respondent, and he also not produced any document to show that he has made arrangements for maintenance of the petitioner. The RW1 has stated that he used to pay money in the hands of her father once in 2 months. When it is the case of the respondent that mother and father of the petitioner number 1 are residing separately, giving some money in the hands of the mother of the petitioner number 1 is of no avail to the respondent. The learned counsel for the petitioner tried to elicit through the respondent RW1 that there are marital disputes.
I've seen the order, you can make your submission.
Please.
I've seen the order, you can make your submissions.
Please, Your Lordship. In this case, prior to filing of this desertion, Your Lordship, there is a matrimonial disputes in respect of the petitioner's brother and the respondent's sisters, own sisters. Subsequently, they have married and their matrimonial dispute filed matrimonial case before the Ballari court, Your Lordship. There, the petitioner sister has sent the respondent brother to the jail for
In this.
non-payment of
in
maintenance
125 CRPC
matrimonially.
125 CRPC proceedings, you cannot say that there is desertion and all unless and until you have filed a petition for restitution or any order is passed in that regard. No, there is nothing of that sort in this. Jurisdiction, that issue I've seen, the order of the court is perfect on that. We don't have to go into it.
Obliged
Court
that.
has granted 3,000, 2,000, that is 5,000 maintenance. Please tell the court how you cannot pay 5,000. That's the only issue.
While filing of the petition itself, Your Lordship, petition number 2 has
I will
measured.
record that is.
Petition
everything
number
is there.
was measured, but in spite of that, she has represented as minor.
Number?
2.
What is her age according to you?
According to me, now his age is 19 years.
Petition number 2 is a boy.
Boy,
Aged?
age earlier she has mentioned 16 years, Your Lordship, Ajit Kumar. But as on the date of filing of the case itself, he was 18 years. That
That
is
ground you have not taken before the court.
that we have taken and we have produced the Aadhaar card and we have also cross-examination to that extent.
There is no finding on that.
Here,
So that is.
please, page number 14 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
Yes, yes. Working in a petrol bunk.
In a petrol bunk, during the course of RWN has stated that first petition number 2 is working in petrol bunk. The petition, in order to eke out their livelihood, the petition maybe attended some.
Aadhaar card you have filed.
I have filed.
Recorded
She himself has filed, Your Lordship,
Huh?
as exhibits. She himself has filed.
As per that, he is already, on the day, he is already major.
Yes, Your Lordship.
You have the record?
Here,
Record is there.
records are not called for.
You have there, do you have the document?
Yes, Your Lordship.
Pass on.
I have.
Please pass on. That Aadhaar card.
His admission school extract is with me, Lordship. While filing of the case, Your Lordship, he 17 years, 3 months he's been.
But he is not major as of that day.
While conducting the case, he was major.
After that, he has become
He
major.
major. That contention he has taken.
When the petition was filed,
Petition is filed on 17/11/2021, Your Lordship.
he was 15 years old as on the day. How can he be 17?
Ajit Kumar, age, as in filing of the case, he was,
14/9/2006.
as on filing of the case, he was 17 years, 3 months, Your Lordship, as per the data. Now he is 19 years, 6 months to 24.
10 to 21, how many years? 11 years.
21/7/2004 is her birth.
No, 10 to 21, how many years?
10 to
21,
10,
11 years.
11 years.
11 years. 2006 he has born, another 4 years there. It is 14 years as on that day. Or 14 years and some months.
That, sorry, that is Vijay Kumar, Your Honor. R2 is Ajit Kumar. R2
What
is
you have given me is that.
Ajit Kumar is here. Sorry.
Give it to him. His date of birth is 2004.
Please.
17 years old.
17 years, 3 months, as on the date of filing of petition, and he was major. While passing,
What is that the wife has filed? This is what you are having.
please.
But this is filed by her.
Only Aadhaar card she has produced.
Where is that Aadhaar card? Aadhaar card same date of birth is there?
Um, 2004 year only mentioned, Your Lordship.
4 is mentioned.
4 is mentioned.
The Aadhaar card.
Aadhaar card in month and.
No, there are 2 children.
Please.
So the court had granted.
3 children, Your
3
Lordship.
children. So according to you, only Ajit Kumar is not entitled for maintenance.
Yes, Your Lordship.
Vinay Kumar is entitled. Darshan is entitled.
entitled.
Court has granted to whom? Petitioner number 2 to 4 are entitled for 2,000.
2,000 and petitioner.
No, 2 plus 2, 4,000.
Please.
And the wife, 3,000.
3,000.
7,000. We'll grant that. Please come. Agreed with the word passed in. Criminal miscellaneous number 331 of 20.
Regarding the jurisdiction, Your Lordship.
That also
she has.
I'll record the reason.
Please.
Criminal miscellaneous 331 of 2021 dated 2nd September 2023, whereby the court had granted maintenance of 3,000 to the wife and 2,000 each to the 3 children. The husband is before this court. Let counsel for the appearing for the husband submits that the courts at Davangere has no jurisdiction as the wife was not residing within the jurisdiction of the court. It is a case of the husband that Earlier, she was residing at Buddha, what is it?
Budnahatti.
She was residing at
Chalkere
Buddha, that's in Chitradurga. And only for the purpose of jurisdiction, this particular document, as she has created this document. That particular aspect is not considered by the court, and this order is passed by a court which has no jurisdiction. Further, it is submitted that petitioner number 2, the date of birth is 21/7/2024. As on the day the order is passed, he is 18 months, 17, as on the day the petition itself is passed, he is 17 months, 17 years, 3 months old. And he is not entitled for any maintenance. It is submitted that the wife had deserted the husband and she is staying away from the matrimonial home without a reasonable cause. In those circumstances, she is not entitled for maintenance. This aspect was also not considered by the court. Next para. So notice is on the respondent. No wakalat is filed. Within this, no notice is ordered.
Notice is ordered and I have served the copy on
Where is
the
that?
trial court advocates, Your Lordship.
Where is that? Where is where the
Land Council, on 18/4/2024, Land Council for the petition is permitted to take notice.
where is the
Acknowledgement I have here, Your Lordship.
you should have filed it. This court on 18/4/2024 has permitted the petition to take out handsomens and then
The endorsement is on the end of the page. ಅಲ್ಲೇ ಇದೆ. ಅಲ್ಲ, don't open that. ಹಿಂದ್ಗಡೆನೆ ಹಾಕಿದ್ದಾರೆ. ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಸಹಿ ಮಾಡಿದ್ದಾರೆ ಸಮಯ ಅವರ ಕೌನ್ಸಿಲ್ ಆನ್ ರೆಕಾರ್ಡ್ ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಹಿಂದ್ಗಡೆ.
what's his name?
Initial is mentioned. His initial GM or something.
There should be some name to the advocate.
I have informed the trial court advocate to serve the same, but he has only mentioned initial
Then counts for the, as per the order passed by this court.
with care number.
2024, the respondent, the petitioner has taken out handsomens on the counsel appearing to the respondent and filed a memo to that effect. Hence, the notice to the respondent is held sufficient. Next, having heard the counsel of the petitioner, what is the material on record? The issue that the Aadhaar card that is filed is a document that is produced to show that came into existence only for the purpose of jurisdiction. That document has no legs to stand. And the exhibit P9 is a copy of the Aadhaar card. And earlier, she was residing in Chalkere. Just because earlier also it's not Chikbalapur, Chalkere. And just because the earlier address is Chalkere and the present address is shown, that itself cannot be a ground for the court. It cannot be a ground to say that the court where she is, that the Davangere courts have no jurisdiction. Court has rightly dealt with it and rightly dismissed the petition. This court finds no reasons to interfere with the said finding. Then coming to the entitlement of the children, it is stated that as on that day, the boy is 17 years, 3 months old. He is entitled for maintenance till he becomes major. So he is entitled for till he attains the age of 18. And the amount of maintenance that is granted is 3,000 to the wife, 2,000 each to the children, which this court is not inclined to interfere. Accordingly, the petition is partly allowed. Yes, give it to him. Mega.
Cell number 15. Hanmantappa Haravi.
Lok Adalat, Shivamogga, my lord, it is. These two matters, Lok Adalat, my lord.
Give that.
No comment.
I am the petitioner, my lord. The referred this matter to the Lok Adalat of Shumaga law regarding. There are likely to be a settlement before the parties.
There is no representation before this court on several
Sure,
occasions.
madam. It's true, madam.
This is matter along with, earlier you said this
Please,
matter has to be
please,
listed
please,
with.
please, madam.
Now, when the
No.
matter has come for argument, you say that the matter has to be referred. We will
please.
not refer, you have to argue the matter. This is matter tomorrow.
Next week,
No, tomorrow it has to be heard.
Friday,
Yes.
Friday. Please.
No, tomorrow. Yes.
Thursday, my lord.
How many
Please,
times
please.
you'll ask
I'll
for
prove it.
adjournments in all the matters?
There are likely to settlement with parties, madam.
No, there is no likelihood that we know how the adjournments are sought. We'll hear the matter tomorrow. Yes, 16.
Cell number 16 disposed. Cell number 17. Pratik Extra.
Yes.
Complying with the interim order granted by this court, my lord.
We'll argue
Please,
the matter. Hold on the respondent.
Please, members. Now, the impugned order is at my lord, page number 24.
Yes.
24. Wherein, my lord, in a section 9 petition, my lord, the respondent filed application under section 24 of Hindu Marriage Act.
15,000 is granted.
Please, my lord, 15,000.
Yes, what is wrong with the order?
My lord,
What is wrong with the order?
my lord, says, respondent is also working at a, my lord, as a consultant at my lord, Maruti Suzuki showroom. And also, my lord, petitioner is a, my lord, CRPF soldier. And also is suffering from cancer. And also, my lord, he has purchased one property in the name of wife, my lord, and also paying loan to that property. He has obtained 11 lakh loan. That is also observed in the order.
Let's see that.
Please, my lord.
Small order, read from the reasoning part.
Lord, page number 29, para number 10, my lord.
From 28 we'll read.
Please. May I read, my lord? In the case on hand, evidence has commenced. The petitioner has examined himself as PW1. In the cross-examination, he has stated that he is getting around 58,000 salary per month and that he is working as a police constable at Matagam police station in Andhra Pradesh. Further, he has stated that after deductions, he is getting around 48,000 per month as a net salary. He has also admitted that there are ancestral properties, but he has stated that those properties are not divided. Further, he has stated in his cross-examination that on 5/5/2022, there was a settlement made before the police station between the petitioner and the respondent. And it was agreed that 15,000 maintenance should be paid to the respondent and for the child together. Further, he has stated that the police asked him to pay 20,000 per month to the respondent. He also stated that as per the said settlement, he has paid rupees 20,000 per month for 2 months. She has stated that thereafter FIR was registered against him in the women police station in crime number so-and-so for the offense punishable under section so-and-so. She has stated that after that there were settlement talks and he has agreed to look after the respondent properly. IA number 3 is filed for interim maintenance. The cross-examination of PW1 has not been completed. The oral and documentary materials placed in this case shows that the petitioner is having sufficient earnings. The petitioner has produced a copy of sale deed dated 18/1/2019 to show that property has been purchased in the name of the respondent. However, there is nothing to show that a respondent is getting any income from the said land or that she is in actual possession of the said property. Yes, also produced the medical bills and discharge summary in respect of.
There is nothing on record about the wife's income.
Please, minutes. I will place minutes. She is working in a private Maruti Suzuki showroom.
Maybe you are not placed before the trial court.
Minutes, at that time, where they are not possessed
There
with
is
that
nothing
records.
with regard to your cancer and all. There is nothing.
Please,
mentioned
minutes.
here.
That is placed. Discharge summary is there, minutes. That is observed.
It's only a fracture of femur bone.
Even minutes.
Page number 20.
I'll place the records, minutes. Even minutes. Now I'm getting the further treatment with respect to the cancer treatment is concerned, minutes, before the CRPF hospital.
You have to pay some amount.
Please. To the tune of 10,000 maybe.
You have a daughter also.
Please, minutes.
Who will take care of her?
I'm continuously, my lord, I'm complying with the interim order. I'm continuously paying.
Property you purchase in the name of wife.
That is a 5 guntas of agricultural property, minutes. Even my lords, initially, my lords, for 7 years, they both lived together. Without any plausible explanation, she herself deserted from the matrimonial house.
Please come. Agreed with orders passed in IA number 3 and MC number 102/2022. It's 7th August 2023. Whereby the court had granted an amount of 15,000 maintenance to the wife.
Please.
To the wife. The husband is before this court. It is stated that the wife is earning and she's getting salary of
That salary around 15,000 minutes she's getting.
around 15,000, and that aspect was not considered, was not disclosed by the wife. It is submitted that he's working as a constable in CRPF and now he's suffering with cancer and is taking treatment in CRPF hospital. It is submitted that in fact, he has purchased 5 guntas of land in the name of the wife, and 5 guntas of land in the name of the wife, and even for that, he is paying the loan. The court has failed to consider all these aspects. Next para, though notice is served on the respondent, no wakalat is filed. This court has perused the order, and particularly considering the fact that the petitioner is suffering with cancer, this court deems it appropriate to reduce the maintenance amount from 15,000 to 10,000. Accordingly, the court is passing the following order. The order dated so and so is modified, and the amount of maintenance is reduced from so and so to so and so. Yes,
Number
next.
18,
Mobilize.
Kartik Yadav, you.
For the respondent in this case, my lord.
Referring to the petitioner.
On the last date, my learned friend has made an incorrect submission that I have not complied the order, my lord. So I have been complying. These are the payments which I have made.
Give it to him also.
Please, my lord.
My lords, as per the order passed by this honorable court,
Look at it, what he's saying. You should look at those calculations.
please, my lords, I have.
The learned counsel petitioner has filed a calculation memo to show that he is complying with the order of the court. Learned counsel for the respondent shall get instructions in this regard. This is a matter on 12th.
Obliged.
One submission, my lords.
Interim order
As
may
per this
kindly
thing,
be-
my lords, I have received only 6,92,000, my lords. 11,70,000 has to be paid as per the interim order granted by this honorable court, my lords. I have made calculations.
No, I have.
My lords,
I have-
yesterday night, because of the matter listed today, 50,000 has been transferred, my lords. The petitioner is hospitalized. Respondent is hospitalized. My lords, even till today, the respondent left to the Muscat.
What is the entire amount as per the interim order?
As per, I will file a memo of calculation to that extent, my lord. So
That
I
is
will
what is
calculate.
directed to be filed.
No, I will file.
Give that order. What is the order?
My lords, 50,000 has been
1 minute.
granted by the family court, my lords.
On 8/1/2024, a coordinate bench of this court had granted stay as far as maintenance of an amount of 50,000 is concerned, on the condition that he shall pay maintenance of an amount of 30,000 during the pendency of the petition. Learned counsel appearing for the respondent submitted the order passed for the court is not complied with. There is no representation on behalf of the petitioner. On 22/2024, so and so, ask the DSJ to find out whether the petitioner is having 1 passport or 2 passports.
My lords, your worship may kindly come to order passed by this.
Matter on the caption for dismissal on 37/2025. So when is the date of petition?
Petition is dated 25/7/2019, my lords.
The application was filed in 2022.
That's
The
what I'm
interim-
asking, application for interim maintenance.
Please, my lords, for 19/4/2022, my lords.
19/4.
2022, my lords. Now it is 39 months, my lords.
25.
3 years, 3 months, my lords.
3 years?
3 months, my lords.
3 months.
Please, 39 months, my lords.
36.
39 months.
3 months.
39 months.
So 39 into 30, how
30,
much?
11,70,000, my lords.
11,70,000 and including the school fees. Even I am paying the school fees.
My lords, that is
Order is not that.
that is separate, my
No,
lords.
even,
See the order.
no, not this order, my lords.
My lords, interim,
Different aspect. We are only concerned with what is the interim order, what is the complaints.
So far I have paid 7,32,000, my
You're
lord.
still not complied with. The order of the court is 11,70,000. You should have paid by this time. You have not paid, we will
No, no,
vacate this.
there is some difficulty, my lords.
If there
His
is a
earning,
difficulty-
his earning is lesser than what is
If there is a
claimed, my lord.
difficulty, what you should do, you kept quiet when an interim order is passed.
No, my lords. I have not kept quiet. I have made the payment.
Kept quiet in the sense, you have not said any difficulties. You accepted the interim order, you have not questioned it.
No. So at the time of final disposal, so we thought, so it could be addressed.
Nothing to thought, nothing that, you can't say that you thought, you
No,
shouldn't
my
think
lords.
something.
Even I have made a submission that I have difficulty in paying so much of amount. This honorable court coordinate bench has
I can't-
ordered to
I
pay so
can't
much
help it.
for
As
time
per the
being, my
interim
lords.
order dated so and so, the petitioner has failed to
No,
pay the amount.
my lords, 4 weeks may kindly be granted. I will ensure that certain
The petitioner
substantial
has not
amount will be
complied
paid, my
with the
lords.
order. By 18th of August, if the entire amount is not deposited as per the order, interim order passed by this court, the stay granted by this court will be vacated and the matter will be listed. Next day, give the list date. On that day, the writ petition will be dismissed alone on that ground.
If the order is complied, my lords, the matter may kindly be taken up for disposal on that day, my lords.
Yes, if the amount is paid on the day, the next day date, on that day that your court will dispose of the matter.
Grateful, ma'am.
Yes, next. Yes,
Cell
next.
number 19. Muniappa for petitioner.
This writ petition of 2024. And so far, the notices are not served on the respondent. On the last occasion, the matter came up for orders. On that day, there was no representation on 23/7. And the matter is directed to be listed today. Today also, there is no representation. Dismissed. Next, 21.
Cell number 20. 20.
My lords, appearing on behalf of the petitioners.
Yes.
My lords, am I audible?
Yes, which is 121 or 20? Yes.
20, my lords. My lords, in
Yes.
this matter, respondent has been imprisoned for life in Cork County, Ireland in the month of July of this year. So we have asked for the judgment copy. We would require 4 weeks to submit it before the court.
Delete from the caption dismissal. List this matter after 4 weeks. Yes, next.
Cell number 21.
My lord, for the petition, we have
Delete from the
taken steps,
caption
my lord.
From dismissal. Yes.
I have taken steps, my lord.
It is submitted that the
Yes, my
needful is done. List this matter to service of notice. Delete from the
Cell number
caption
22.
for dismissal. Yes, 22.
Baburao M.
Two, my lord, the trial court case has become attained finality, maybe.
When is the date? Memo is filed stating that the main MC itself is disposed of. MC or miscellaneous?
Criminal miscellaneous.
The criminal miscellaneous has been disposed of and this petition has become infructuous. And the memo is taken on record and dismissed as a. Yes, next.
Cell number 23. 23.
Give it. The petition of 2024. So far, even for the first time also, process is not paid for issuance of notice to the respondents. When the matter is listed before the court on 31/12/2024, even on that day, there is no representation for the petitioner. Then on 6/2/2025, 2 weeks time is granted for complaints. Then on 23/7, again no representation and the matter is directed to be listed today for dismissal. Today also no representation. Dismissed. for
Cell number
non-prosecution.
24. Krishna BJ.
Yes.
Petitioner in this case, my lordship. Objection on the statement of objection filed by the respondents on complaints.
I'll comply.
When did you file? What are these objections in this? First of all.
They filed the
I
objections. to
came across this, I came to know, no, my lord. I'll file.
Why you didn't come?
No, I have to rectify it, my lord, I'll rectify it. The lordship will kindly out on Monday.
Finally, the list is matter on Monday. By the time if the office objections are not complied with, the objections filed before this court will be treated as nil. And the court will proceed with the matter. Interim order is there? You have an interim
No.
order?
Yes, my lordship.
You extend the interim order.
Please.
Yes, next.
Cell number 25 disposed. 26. H. Manjunath. Samir
The
S. M. for
petitioners, my
respondent.
The respondent is
Respondent.
served. Why, what?
Lords, it's a meaningless objections, my lords. By hand, we have gone and we have served our summons to them.
Dismissal for furnishing PF, issue notice to the respondent for the first time.
And we have also given our memos, my lords, regarding the same.
Respondent is already served. Yes, argue the matter.
My lord, we have also filed a writ petition challenging the very same order.
What is the number?
Writ petition 19,000.
This along with so and so on.
Monday, my lords, if possible.
On
Kindly
11th.
request.
Yes, next.
Cell number 27. For orders matter, cell number 27.
For the petition. For order, we have.
Memo is filed seeking this. Who appears for R2? Divisional Manager, United India. Where is The divisional manager, United India Limited. Mr. P.B. Raju is directed to take notice on behalf of the respondent number 2, and the petition is permitted to serve notice on the counsel for the respondent. The a memo is filed seeking dispensation of notice to R1, dispensed with at the risk of appellant, admit course of final hearing, call for the TCR. Yes, next.
Cell number 28. 28, Sidmalappa PM for petitioner.
I appear for petitioner, my lord. I had filed, I thought we have filed a memo for retirement, my lord, but we have asked the party to come to the office, but he's not keeping well and he has not yet signed the memo for retirement, my lord. I seek for a 1 week time, my lord.
No, for filing a memo of retirement, why should the client come and sign? You have to send a notice to.
He has the consent.
No, you have to send a notice to him that.
My lord, already he has taken the NOC. We thought he has already engaged a new counsel by filing the NOC.
So that you can state when he has
Yes, my
taken
lord. That is why on the last date of hearing,
We will not wait till your client comes.
No, my lord. 3 days time may be granted.
Yes, list of this matter after 3 days. Yes, next.
Cell
At
number,
the request of non-counsel the petitioner.
cell number 29.
List this matter after the TCR is received. What is this? What happened to this? 29? Let's see. Is this the one the other day I passed an order? List the matter immediately after the TCR is received.
Cell number 30. Devendra N for petitioner. Non-filing of translated copy of the order.
Lord, I represent the respondent and one in another matter petition. Lord, in this case.
Your
Husband petition.
respondent in the first matter.
No, first matter.
You are a respondent or the petitioner?
Petitioner in the Lord 232 of 2024.
Then what about this translated copy?
No, not on 232, my lord, in maybe other.
In spite of an order passed by this court,
No,
the
no,
translated
is in
copy of
first.
the order is not filed. List the matter finally on 20th of August.
Published.
Then 31st,
Cell number 31. Uday Kumar G.
no representation for dismissal. Tomorrow.
Cell number 32.
Respondent.
Copy is served on you.
Please, my lord.
Where is the counsel?
Allah
No
Baksham.
representation for dismissal. List the matter. Do you have any urgency?
My lord,
Any urgency for you?
please, my lord, please. They are not paying any
Yeah,
maintenance.
this is matter on 12th of August.
Cell number 33. Yes, sir.
On that day for dismissal.
Counsel for petitioner, my lordship.
33, yes.
2 weeks time, my lordship.
No, so 2 weeks, a week's time default order.
No, my lordship, what has happened is, the counsel for respondent or petitioner before the trial court is not available, my lordship. To receive
Forget
the
about
hand
it.
summons.
You have to pay the process. For the process, a week's time default order.
Sure.
Yes.
34 dispose 35 hearing on interlocutory application.
For the
So date-
Vijay Kumar.
For the respondent here,
All G.
the respondent number 1 has died here. The legal heirs are the respondent number 2 to 5 are the legal heirs. They are already party in the petition. And further, the amount has been released in the
Where
in
is
favor of
that-
the respondent.
No, when did you inform and where did you file a memo that already the LRs are on record?
30th June 2025, I
Is it
have
ordered?
filed the memo for that stating that the legal heir, respondent number 2 to 5 are the legal heirs. They were already on record.
Any order is passed in that?
No,
Having accounts for the appellant submitted except respondent number 2 to 4, there are no other legal heirs to respondent number 1. May be treated as legal representatives of having considered the submission, considered to be the legal heirs of deceased respondent number. Appellant to carry out required amendment in the cost title. Have you carried out?
no, I will carry out the amendment.
The
The
amendment shall be carried out. When can you carry out? Then we will list it. Then we will pass.
Within
on.
1 week, next week.
That shall carry out the amendment within a week. List after that.
Cell number 36. 36 adjourned. 37. 37. Bhargav G. for petitioner.
The final order passed in the criminal miscellaneous petition
awarding the maintenance of rupees.
So this delay, the council submission with
Yes,
respect to delay kept to open. What is that?
That is that it may be considered at later stage since the interim order is very urgent. They are already filed.
No, other side is already
Served.
served. We will dispose it of
Please,
now.
please.
So what is that? We have to consider that also first.
Now, I have furnished the assets and liabilities before the trial court.
No. What I am saying is, this delay aspect, we have to consider right now.
Yes.
And I will dispose of the petition also now.
Please.
So where is the delay? What is the delay?
121 days delay, my lord. This is parents, old parents of 7 years, 80 years and 85 years.
Where is that IA?
Your lordship may kindly see page.
Huh?
Page 120, my lord. Affidavit.
Delay is 23 days.
Please.
23 days.
Yes, ma'am. 23 days. 121 days, my lord.
No, 121 page you see, you say that it is.
30, thereafter it is rectified. Ma'am. Page 119, sworn to the accompanying affidavit, the petition above prays that this honorable group please to condone the delay of 121 days.
He said 21 because 30 days some order copy procured till the order copy is granted, that's a concession. Even for the ads for the
Please,
officer
please,
is 54.
please, madam.
To condone the delay of 21 days. Delay of 23 days in filing the petition. Considering the reasons stated in the accompanying affidavit, the delay is condoned. He has come to the main order. Where is the order?
Your lordship may kindly see the page. It is about 48 page order says nothing is discussed with regard to the income of the parties.
How much is granted?
And finding is 46, page number 46.
12,000
To the,
10,000
yes, ma'am.
comes to 22,000.
Yes, ma'am. His income itself is annual, monthly income is 22,000. Assets and liabilities we have filed.
The doctor.
Is Ayurvedic doctor filed the return since from the year 2015, madam.
Where is it discussed?
Your lordship may, it has not been discussed. Page 46, para 30, your lordship can see. Discussion.
Then we'll do one thing. Then you pay first 10,000 per month, 10,000 and arrears and all you deposit. On that we'll grant stay. Then we will see once amount is paid.
Your lordship could be disposed of. I will giving an undertaking before that. Earlier, this honorable court has passed an order to the effect that 10,000 altogether to the maintenance and so far as wife and child. And the matter was remanded back. Again, by considering the annual income itself is 2,50,000. It comes to 22,000.
Where is the earlier order?
Earlier order, your lordship may kindly see.
No, you are continuing to pay 10,000 even till now.
Not only 10,000, my lord, more than 10,000 we are paying.
Where is the earlier order?
Earlier order, your lordship may kindly 107 page number. Operative portion is at page 115. In view of the above impugned order dated so and so, the family court is modified, and the petition husband is directed to pay interim maintenance of rupees 10,000 instead of 25,000 per month to both wife and child from the date of application till today within a period of 2 months from the date of receipt of law. There is no reasons are given by the courts below so far as awarding 22,000 towards maintenance. She is a BCA graduate. She is working. That has not been disclosed.
No, please come to the impugned order. Where is, we'll see the discussion.
Your Lordship may kindly see page 46, para 30. Hence, taking into consideration the findings in the above referred cases, last enough to respondent had produced his income tax returns, which makes to his annual income is rupees 2,50,000 to 2,70,000, having varied in the course of the year during the pendency of the present petition. There is chances of respondent disclosing less income. When income tax itself is told, even returns filed much prior to the litigations. Even for taking for consideration this amount which is disclosed, all his income is monthly is 22,000. He has to maintain parents, and his clinic is at village. And throughout our contention is not working properly. He's an Ayurvedic doctor. He's not working. He's a vagabond, etc. Contrary to the same, she is pleaded here that his income is so and so. No materials are produced.
In support of your case, what you have filed to show what is your
Income tax returns we have filed, my lord, along with the, before the trial court, we have produced the records. Now I've got one copy to that effect. Your lordship, can I pass this one?
Take that. (2020, 21).
Your lordship, may kindly say 2016 is also there at first page, second page. That was 12,000 as on that such date.
Please come. Agreed with orders passed on criminal miscellaneous number 360. Agreed with orders passed on criminal miscellaneous number 369 of 2016 dated 30th August 2023. Husband is before this court questioning the maintenance of an amount of 12,000 per month granted to the petitioner and 10,000 to the main child, and also litigation expenses of rupees 25,000. It is a case of the wife had filed the instant petition seeking maintenance of an amount of rupees 50,000 per month and 3 lakh towards maintenance, and the sum of rupees 3 lakh to set up a leased house, and also sought for the litigation expenses. It is a case that the husband is a doctor. He's earning an amount of rupees. He's earning lakhs of rupees, and also is having other landed properties. Earlier, when an IA is filed seeking interim maintenance, the court had granted an amount of rupees. That time, how much was it? 22,000.
10,000 together. Both.
No.
25,000.
Trial court.
25,000.
The court had granted interim maintenance of 25,000. Against that, when the husband has filed a writ petition before this court, a coordinate bench of this court. You said where is the order copy?
Your Lordship, may kindly see the page 108,
This court, the coordinate
107.
bench of this court in WP number 41103 of 2018 dated 11th October 2019 has granted an amount of rupees 10,000. Now now a final order is passed whereby the court has granted 22,000. Next, Land Counsel appearing for the Land Senior Counsel appearing for the petitioner submits that the petitioner has filed his income tax returns and also placed before the court that his income is 22,000.
22,000.
22,000. The court, having perused the income tax returns, gives a finding that even a driver is earning much more than that amount, and the said amount, as stated by him, cannot be believed. It is submitted that he is working as a Ayurvedic doctor, homeopathy or Ayurvedic?
Ayurvedic.
Ayurvedic doctor, and he's practicing in a village. And when the material is placed before the court with regard to the income, the court ought not to have done any guesswork and ought not to have granted an amount which is then after an amount of 22,000. Now he is left with only 3,000. It is submitted that the court had failed to consider the evidence on record and had granted the exorbitant amount as maintenance, which the petitioner is not in a position to pay. In this matter, notice is served to the respondent and no wakalat is filed on their behalf. Having heard the senior counsel for the petitioner, peruse the entire material on record. As per the judgment of Rajesh vs. Sneha, when the statement of assets and liabilities are filed by the parties, and when the income tax returns that are placed before the court discloses what is the income of the husband, the court ought not to have given a finding that even a driver is earning 25,000 a month, and it cannot be believed that a homeopathic doctor is earning 25,000 per month. Here, there is no requirement for the court to do any guesswork when there is evidence on record in that view of the matter and balancing the interest of both the parties. The amount of 10,000, this court is following the court is passing the following order. The order dated so and so, passed by so and so is modified, and the amount of maintenance from an amount of rupees so and so is reduced to 10,000. And as far as the litigation expenses are concerned, this court is not interfering. Yes.
One submission, my lord.
Posed off.
There are other two petitions are pending. One is domestic violence and another is maintenance interim order of maintenance passed in divorce petition. If at all there is any amount paid in the spot is given by.
But how can we consider all that in this petition?
No, my lord. The writ petitions of.
You have to move an application in the pending petition. This is a final order.
Please.
Yes.
Till number 38. Asha Sarup P for petitioner.
Appearing
Appeal
for
for the respondent, my lords.
petitioner, my lord. My lord, the family court has gone ahead and issued a salary attachment warrant in this case. Just to brief you on the facts, the impugned order is in Annexure A, wherein the family court had ordered an amount of 18,000 rupees to be given to the mother and the daughter. Now,
Was it question? Was this order question?
my lord, sorry.
Was this order of the family court questioned by the petitioner?
Yes, my lord. We had filed a modification of the challenging that order in the High Court here.
Where is that petition?
My lord, the order was given in that on 23/01/2025 by Justice Pradeep Yeriur in the same court, whereby he had modified that to 10,000 rupees plus arrears to be paid. Now, the background to this is, my lord,
It is pending.
application is pending.
Writ petition is pending here.
Writ petition is pending. Yes. So now the background to this is he had borrowed money for his mother's cancer treatment, which the bills have already submitted. Now his income from the bank where he's working is 27,000 rupees. After he has taken some hand loans because amounting 25 lakhs, he has taken money for the cancer treatment. And now the take home for him is around 18 to 19,000 rupees per month. My only submission is if we can modify that order wherein we can.
The very same judge You are seeking modification of the order.
My lord,
When council seeks modification of
my
the
lord,
order
my humble
passed by a
submission,
coordinate bench
one more
of this
submission,
court.
my lord. If he is not, if he has already made a payment of 39,000 rupees as against this
I'll
order.
not modify that order.
My lord, salary is also attached now. He has no,
Go before the very same court on dated so and so. When is the date of the order?
my lord, this was 23/01/2025, my
The petitioner seeks modification of the order dated 23/1/2025. The petitioner can file the modification, seek the modification from the very same court.
My lord, in the interim,
My
if there
lord.
can be a stay ordered on the, at least the salary warrant, at least he can pay the amount. Otherwise, there's no source of income for him at all.
You should have done it when the order is passed in the month of January, not wait till August, till the salary attachment is ordered.
That is not the case, my lord. We have also tried to make the payment. He made a payment of 39,000 rupees with the limited salary he has.
Many times the court will not interfere. Yes.
Sale number 39 urgent, sale number 40.
Yes.
Keshav Dr.
Yes. What is the amount granted?
My lordship, 6,000, my lordship. 6,000 was
What-
granted,
What is your income?
my lordship, I'm doing a cooling, my lordship. 400 for a day, my lordship.
How much it comes to month?
My lordship. 14,000 something is. My lordship, the trial court is filed to consider my cross-examination, my lordship. While doing my cross,
No, you say that you get 14,000 or 15,000 a month.
Yes, my lord. I suffering a epilepsy diseases, my lord. And my father also suffering a neurology trophy, my lords. I produce the documents.
Counsel for the petition submits that the petition is suffering with epilepsy and is a
And I-
daily wage laborer and court granted 6,000, say 50,000, 5,000, 3,000 by 5th of every succeeding month, and the arrears within 8 weeks. That there is a standard order for this. There is a standard order for this. So either the amount is not paid or the arrears are not paid, the stay granted by this court stands vacated. Notice to the respondent.
Sale number 41. 41.
For the petitioner, my lord.
Yes.
Shubha, yes.
I
for
represent the respondent.
My lord, in the last date of visitation, there was a development, my lord. The parties have initiated talks towards settlement in the best interest of the minor child.
There were no talks between the parties.
There was, my lord, there was. Otherwise, I wouldn't have made
My
this
party is
submission at
before
all.
the- My party is also.
Then
before
I will
the court.
instruct my petitioner also, the petitioner wife, not to.
There are no talks between.
There
the
was
parties.
definitely talks.
No, what you will instruct your petitioner wife?
There was instructions, specific instructions from the petitioner wife, my lord, that the child has initiated talks in his best interest. The child is already 14 years and he's in 9th standard. So,
No, please tell the court what is that, what is terms of settlement that your client wants. He's here.
there was an interim order, my lord, modified interim order. Visitation is being exercised every week between 10:30 to 1:30 every Saturday, my lord. So last time also I made a submission that on these lines, the petition can be disposed of. My learned friend was not in favor of it. So they went back on Saturday. There was a visitation,
What
my
has
lord.
happened to the visitation on the last occasion?
Lord, family court has granted the.
I'm saying, what is your client's instruction?
Lord,
How the visitation has went on?
Lord, it was good. Lord, the petitioner has tutored the child to the effect that he had come to the father and he had informed him to withdraw this withdraw the GNWC petition, which is adjudication before the family court.
But that is a negotiation.
That was negotiation.
That is not true, my lord. Now we are before this
Child is
court
talking about
only
the court
in.
cases.
We do not want any overnight custody, my lord. Visitation continuously is being exercised. Only to that extent we want it, my lord. Overnight custody is not we want it. And the child only has initiated talks, my lord. Last time also I had made a submission that on the lines.
Talks not about withdrawing the GNWC.
No, my lord. Withdrawing and all, how can it be withdrawn here, my lord? We have to go back to the family court.
Here, wherever it is, the negotiation is asking the father to withdraw.
That is not true, my lord. That is not true.
What do you say? Why should we keep it pending here?
Lord, let this petition be disposed of. Matter may kindly be
Let this-
remitted
let
back
the-
to the
whatever that's
family
what-
court, my lord.
No, no,
Let the
whatever is
family
the
court
interim-
decide.
No, whatever is the interim order, That will make it,
No, my lord,
pending disposal.
that can't be, my lord, for the
Then in
simple,
that case, why would it go to the family court now?
my lord, matter is
Family
still
court
pending.
will decide about the final,
Please,
about the GNWC.
please.
So this is an interim arrangement made. No, why should we, this court again send back? Why another litigation for that? So there should be an order now with.
Family court
Yes,
had
my lord.
granted visitation over the child to the father on every weekend from Saturday till Sunday, my lord, against which they had approached this honorable court. But since, my lord,
Is the boy inclined to meet the father between that time?
please, my lord, he was meeting.
It's a boy.
Please, my lord. he's a
What
boy.
is your difficulty for not?
My lord, the child is comfortable with the father as of now, my lord. I'm sorry, I'm not well, my lord. The child is comfortable with the father. He is meeting every Saturday, 10:30 to 1:30. They are spending time, my lord. Only difficulty is because he is in 9th standard, there are some tuitions and extra classes over the weekend. The child is even ready to go to the house of the father. That is also expressed by the child himself. Only difficulty is he is not interested in spending overnight, my lord. That is all as of now. Maybe in future the child will be ready, my lord. All these years the child was not ready to meet the father. Now they are very comfortable. From 2023, the father is here. 2023 till date, even last Saturday also, they have even had talks that day after tomorrow Saturday, the child will be visiting the father in his house also, my lord. That instructions also I have got.
Come to the impugned order. Where do the respondents stay and what is the distance between both the houses?
They are very close by, my lord, less than a
They are
kilometer,
close by,
very
my lord.
close by.
There is no problem.
The child can go by himself also.
On Saturday and Sunday, if he has any other classes, even when he is with the father also.
He will
can
take and,
take.
please, my lord, he will take care. He
My
will
lord,
take
my
care of all
only
those
submission
things.
is no orders may be passed, my lord, because after all these years, according to me, that there is some movement for say settlement, my lord. If it is amicably settled, then there will be end of all litigations,
Where
my
is
lord.
that? Where is the-
22, my lord, page number 22 is the order of the family court, my lord, which is
Agreed to the orders passed in IA number 2 in GNWC number 39 of 2021 dated 12/11/2022.
yes,
Please,
2021.
not only
my
that
lord.
order, my lord, but the petitioner did not comply the order passed by the honorable family court, against which, my lord, a contempt application was moved by the
My lord,
father.
my submission
I'm not
also may be
concerned with
noted.
that.
I am not making any submissions towards non-payment of the maintenance, my lord. Because petitioner
Whereby
has
the court had granted visitation to the father and the father was permitted to exercise the visitation on second Saturday and fourth Saturday at 10 a.m. at the mother's place. And the father is permitted to have, where is the overnight custody?
it is there, my
Is
lord.
there,
Kindly
but
come to
last
page
paragraph,
number.
my lord, of page number 22, last paragraph. The respondent shall hand over the child on second and fourth Saturday at 10 a.m. at her residence, and in turn, the petitioner shall return the child on both the Sundays.
Somehow it doesn't make any sense.
No, my lord, Saturday 10 a.m. the mother has to give the custody to the father.
No,
Then
but
father
come
will
to-
drop the child at 6 p.m. on the next Sunday, my lord. That is the order.
Overnight, my lord. Saturday and Sunday.
1 minute. You read page number 22. First it says,
Please, my lord.
the father shall exercise the visitation right of his son on second and fourth Saturday with following Sundays between 10 a.m. 10 a.m.
Please.
Saturday to 6 p.m. on Sunday. That's fine.
Please,
Then bottom, the respondent shall hand over the child.
please, my lord. On every second and fourth Saturday.
Struck that off. Strike everything. The present petition is filed. Agreed with orders passed in I number 2 in JNWC number 13 of 2021 dated 12/11/2022. Whereby the court had granted overnight custody to the father on second and fourth Saturday to the Sunday. That is between 10 a.m. of Saturday to 6 p.m. of Sunday. The mother is before this court. When counsel appearing for the mother submits that the mother has no difficulty, and the mother and the child, both of them have no difficulty to meet the father. And in fact, earlier the child was reluctant to meet the father. Now he is going to the father, but on Saturdays and Sundays, he has some classes and other activities. The boy is not comfortable for an overnight stay. As per the order passed by this court, he is exercising the visitation between 10:30 and 1:30
Please,
on a Saturday
please.
and Sunday also.
No, my lord, only
On a
answer.
Saturday between 10:30 and 1:30, and that visitation is going on, and the boy is comfortable. Land Council submits that the same arrangement shall continue, and if and the matter may be disposed of the trial and all, and with that direction, making the interim order absolute, the matter may be disposed of. Next para. Land counsel appearing for the respondent, no, the petitioner submits that there is a likelihood of settlement. In fact, the minor himself has initiated the negotiation. Next para. Land counsel appearing for the respondent further submits that even submits that the boy is comfortable. Even the contention of the land counsel for the mother supports the case of the father. It is submitted that now the boy is aged 14 years and there cannot be any difficulty to the mother to give the overnight custody. And both the father and the mother are residing close by. Even if the boy has any other classes or any other activities, the boy can go, and if necessary, the father will take him. It is submitted that the court, considering all the aspects, had rightly granted overnight custody to the father, and no interference is called for. Next for hunger the counsels on either side. There is a material on record. The reasons that are stated by the land counsel for the mother why the overnight custody is not permissible is one, that the boy has activities, and for the overnight custody, the boy and the mother are not comfortable. Without stating any reason, just saying that the mother and daughter or the son are not comfortable for overnight custody cannot be a ground for this court to consider the said request. Both the parties are staying nearby, and it is stated that the boy goes on his own. If there are any activities to the boy, the father is ready to support him on the weekends. In that case, the mother and the child cannot, that objection, that not comfortable, cannot be considered. And in the considered opinion of this court, the family court had rightly passed an order and requires no interference from this court, accordingly dismissed.
Channel number 42.
My lord, I had two more submissions, my lord. This order of the family court was an ad interim order. We were not heard, my lord. And also there is about 3 lakhs of maintenance to be paid, my lord. Since 23, they have not paid any amount.
That's what I've already indicated to all. If something, one order father is having for visitation, the other order for maintenance, if he is not paying, file an application before the court under 151.
Please.
Court will take care
Please.
of it. Say that the proceedings.
My
shall
lord,
be
that
stalled.
interim order was granted only on an undertaking given by the respondent that he will pay regularly rupees 10,000, my lord. That has not been made.
Give that order.
My lord, the only reason why I did not argue. Yes, my lord,
Look
my
at it.
lord,
Where is
my
that
submission,
order?
my lord. I'm sorry, my lord. My submission is I did not want any order to be passed because there was some settlement, my lord. Otherwise, I wouldn't
Not
have.
go into all that.
Otherwise, I
Please
would
tell
have.
the court where is the 10,000 in this order.
Yes, my lord. Yes.
Please come to that page number.
If your lordships can peruse the memo of documents which is furnished by my learned
No,
friend.
first of all, come to the order. Where is that
My
mention
lord,
about?
kindly come to page
No
number
order is
18.
passed in the present case. No order
Kindly
is passed in the
come to
GND.
page number 18, my lord. 18 of the writ petition. There is an order on 26/10/2021 to file memo of undertaking to pay maintenance to the respondent by 27/10/2021 at 3 p.m. The next page, my lord, petitioner is present. filed memo undertaking to pay rupees 10,000 per month as per the court order. There was an order, my lord, to pay 10,000, which was confirmed by this honorable court in the MC petition also. So continuously he had to pay rupees 10,000, which was not paid. What the respondent does is, whenever the petition comes before the High Court, they make some lump sum payment and obtain an order, my lord.
It is in her contentions. When counsel for the petitioner mother submits that there was an order by the family court to pay an amount of rupees 10,000 to the child, and also an undertaking by the father that he will pay the amount of 10,000, which he has failed to pay. And so far, the arrears are,
Well, there is 3 lakhs of arrears, my lord,
according
around.
to the mother, there are 3 lakhs and odd arrears. Next, in the discussion part.
May I make a submission with regard to that? An interim order was passed in MC case. My lord, that order was operating till disposal of that MC case.
But what about your undertaking?
My lord, that undertaking was during pendency of that MC case. My lord, that undertaking was
You
given.
have no obligation to take care of.
My lord, we will pay the amount. My lord. We will pay the amount. But let them. My lord, my submission is, let them file necessary application before the family court. Let family court
How
decide.
many orders should be passed?
But there was only one order.
Amount of
There was
10,000
only
you were
one
ready-
order, my lord, directing me to pay a sum of rupees
What I'm saying,
10,000,
Mr.
which I
Counsel.
have paid, my lord, which I have
Then
paid.
we will also see sometime disorder. Disorder also we will see after some time.
But
Let it go on for the next 5
But
years.
as on
like
today,
this.
my lord, as on today, my
Not- that's
lord,
not the submission.
we will pay the school fees of the child
Not-
directly to the school.
not required, my lord.
Directly to the school, not to the mother.
Pay to the school.
Lord, my
Oh, no,
name
my
is
lord.
removed in the school
school.
records.
Pay
My
to
lord,
the
the father's name is removed in the school records as per the instructions given by the mother. Lord, if a direction is given by this honorable court to the father to meet the child, to make the payment in the school directly, my lord, he will make the payment.
Already
He will
all
make the payment.
this academic year is also paid,
Pay
my
the-
lord.
he will pay the school
Direction
fees.
is rupees 10,000 per month maintenance, my lord. Why is he telling? Last time also when it had come before the other
Because
court,
when, the land counsel for the petitioner has drawn the attention of the, you record the 3 lakhs, 3 lakh, the is and odd. Next, in the operative portion, but before the operative portion. No, when.
Around 4
when
lakhs,
the-
I think,
When the
my lord, I'm not sure.
GNWC is filed by the father seeking custody and also seeking visitation. Court has granted visitation. The father, apart from fighting for his rights, has also the duty to take care of the child. When there is an order, when there is an undertaking before the court that he would pay 10,000, if he is not paying the amount as per the order of the court, and at the same time he wants orders from the court, this kind of an approach from the litigant, the court cannot appreciate. The mother is at liberty to file an application under 151 CPC, and the court shall consider the same and pass appropriate orders.
But my undertaking may kindly also be noted.
What undertaking?
But that, my lord, that the father will
And the
directly
court,
pay. my
when
lord,
this application comes to,
Please.
because you should have asked it before the court long time, not when she's acting before this court. When you
But when
you have.
interim order was passed by this honorable court, my lord, we had paid a sum of rupees 3,05,000 before this
I
honorable
didn't,
court.
that is a contention I've recorded. Now they will file an application.
Please,
You,
please.
whatever you say, but the court will stay the proceedings.
Please,
And whatever interim order is there, that will be vacated.
Please.
Till number 42.
much obliged.
Your Lordship, may
Perez for petitioner.
kindly pass over the matter, Your Lordship.
In this
Why?
matter,
We need to have some discussion. We could not do that because of paucity of
we are trying
time.
to arrive at a settlement in this matter. Now, we have given the proposition to the mother. However, there's been a stalemate in these talks. Been a stalemate with regard to these talks. Now, before my lords, we had decided that he will pay the school fees. He will take care of the medical expenses of the child, and he will pay maintenance. And we have agreed to that. Then we had requested them to kindly give us the bills of the schools, and we will reimburse them. However, the mother is refusing to give the bills. She's demanding a straight out fee of 8 lakhs. And she's stating that that money has to be paid before signing this memo before this honorable court. We have asked for the bills. Number one, first thing. Second thing is, most important is the name of the child. In the birth certificate, the name of the child is Krisha Savalsa. Now the mother is not agreeable to that. She's removed the surname of the child from all records. And she has stated that she will not put the father's name in any records of the child, which we are not agreeable to. Father's name has to be there in all official records. Removing the father's name, she's already removed the father's name, cannot be allowed for my minor daughter. Third thing is, we had agreed to pay maintenance for the daughter and to take care of her education and undergraduation. The mother wants maintenance to be paid till she gets married in this matter. Now, if she gets married at the age of 30, am I to pay maintenance to my daughter till the age of 30 when I'm paying for her graduation? That is where the talks have stalemated. Next, Your Honor, we have stated that we will pay the school fees for the child and we'll pay the college fees. Let them decide what the school and college is, and it has to be reasonable. Now, tomorrow she cannot put the child in management quota in any college and put the burden on me to pay 15, 20 lakhs worth of fees for the father. We have stated, put it in a reasonable school. Let the father and mother decide what is for the child.
Because ultimately father is the paymaster. Whatever capacity he has, accordingly that has to be. Why a clause for that?
Because the thing is,
No, already like it has to be in consultation with the father, whichever school or college that she's going to join. And one more thing, I will, whatever that she wants to, you want to negotiate or whatever you're saying, do it. Today I will not adjourn this matter, and today I'll not adjourn this matter. 2:30 I will take it up, and as I've already told you, I will pass an order. There is only two things. One is settlement, second is not to leave Bangalore. Only two orders will be passed. That you tell them. Yes, pass over.
Cell number 43.
Petitioner in this matter, I'm filing an NOC wakalat. I may be given a week's time to file my objections to the matter.
My lords, I appear for the respondent. We filed an application seeking to modify the judgment that was passed by this honorable court. If I may just point out the judgment on page 18, my lords.
My lord, let me please be kindly taken after my objections are.
Let's see what it is. Whether if the court is considering, then you can file your objection.
My lords, page 18.
Everything here only. Why can't you file in the section? Yes.
Well, it's page number 18 is the judgment that was passed on
Page number?
18 of the compilation. This is the judgment dated 25th of July 2024, my lords.
Where is page number 18? When did you file this? When was this application?
My lords, the application was filed on 23/7/2025.
Yes, page number?
18, my lords. Is the judgment. Page number 23 is the operative portion.
Page number?
23 is the operative portion, my lords. My lords, this judgment is dated 25/7/2024. I was given 1 year's time to sell a jointly owned matrimonial property that both the parties own. So I was given 1 year's time to sell the property, and a price point of 3.5 crores was mentioned in the operative order. If you look at page 23, para 2 says, 11 subclause 2 says, as far as IA number 6 is concerned, the husband within a period.
Page number of the order, the operative portion starts at 47.
No, well, it's 23. There are two orders that have been attached. 23, Manoj.
This order you're seeking, 25th July 2024.
Yes, yes.
WP 19102.
Yes, correct. So page 23 has the operative portion. Para 11 subclause 2 says, as far as IA number 6 is concerned, the husband within a period of 1 year shall sell the property at 3.5 crores, and after clearing the bank loan, the amount is to be distributed between the both of them. The remaining amount shall be shared equally. Well, as I am asking for an extension of this 1 year period because we were unable to sell the property within that time limit.
My lords, I may just interrupt to say that this particular direction was given on the respondent's undertaking that he has a ready buyer. It was meant to simply consummate an already existing buyer situation, my lords.
Passed on 25th July 2024.
That's correct.
How much time you are seeking?
Malas, we've asked for 2 years extension.
Oh, year has passed.
Malas,
my
I've
lords.
also put forward the efforts that I have put in selling this property. I'm also saying that there is non-cooperation on the part of the petitioner because all the sellers that we bring.
The outer limit, the time is given 1 year.
My lords, yes.
Anybody asks for an extension, I can understand in months. You cannot ask for 2 years.
My lords, I'll submit that there is absolutely no lack of cooperation from me. I may be please allowed to file my objections within the
For
week.
that-
my lords.
for this small application, we don't require some that elaborate objection.
I have been the petitioner wife has been paying the EMIs consistently since that time, my lords.
My lords,
The
the
husband has
husband-
not made a single rupees contribution
My
since
lords, that
then.
is not correct. The maintenance was increased, accommodating the fact that EMI was also to be paid. So I now pay 75,000 per month. I'm only asking for an extension
only
of
for
the
the
period,
children?
any reasonable time, because I am also keen to sell this property and be done with it.
Time will not be granted.
My lords, if a year's time may also be,
Because it's unreasonable. Why year also not be granted?
My lords, many
Because it is-
apartments have been sold in the same.
my lords, may I point out a few things in my application as to why I have been unable to sell this property, my lords?
Who asked you
Yes.
to ask for that? Did the court impose that condition on?
My lords, there were both parties.
When you wanted a matter to be disposed of, you will come.
No, my lords, I
very-
understand. There were two applications before this court at that point in time. They were asking me to pay EMI, which is now included in the maintenance that I pay her. I was saying, please sell the
Not my
property
lords.
because you're
I humbly
sitting on
submit that the
you are
main-
sitting on a 4 BHK property, which I was also willing to give them a alternate accommodation of a 3 BHK. My lords, it's the husband, it's the wife and 2 kids who now currently reside in this property. I have tried. I have brought a broker in. I have put out flyers. I have put out all information. I'm on all reputed websites saying that this property is available for sale. Sometimes when potential purchasers come, either there is a coordination difficulty or there have been instances where the petitioner has not even been able to show the house. I have not got proper photographs because the house is in an unsaleable condition. She's not willing to clean it up for me to take photographs of the house. So I'm having these difficulties on my end. And the minute, I mean, this undertaking is
Why not she make some effort to sell the house?
My lords,
No
the
efforts
undertaking
till
was
date.
taken up by the
There was no
respondent,
undertaking,
my
my
lords.
lords.
The undertaking was
There was
given
no
before this
undertaking.
court that I already have a ready buyer. I will complete the sale and we will dispose of the property in that manner.
Please
I am
see the
not-
order on page 22. It says both the parties who are present before the court submit that
agreed
it is
to it, my
agreeable
lords.
for them, and the
If-
husband will
if-
take further steps to sell the
If
property.
the respondent
There is
was
no
able
undertaking.
to command a
That is a
price of
false submission. I'm
3.5
sorry.
crores, which is a highly exaggerated.
Both the advocates at a time. You
Now,
should
I
want any
apologize.
Order from the court, either one at a time. One at a time.
Well, I'm just pointing out to the order itself, where it says that both parties were present before this court and both parties were agreeable that the property would be
Guarantee
sold.
that you will complete it another 1 year.
Well, this is how it's stated, my lords.
Why did you say that?
Well,
When
at
you
that
wanted
point
an
in
order-
time.
I object to this extension sought, my lords.
I am not granting. Why don't you please understand?
My lords, what is
The
Certainly,
whole
my lords.
difficulty is advocates are not understanding what the court is.
Certainly, my lords.
I'm only
I
listening to
apologize,
her.
my lords.
I'm listening to what she's saying. Yes.
My lords, there is also a BBMP notification that has come out that says that this property where the apartment unit is located is possibly under notification, my lords, acquisition, my lords. That notification has come out. It has been difficult to get a buyer in this market.
Court on the order dated so and so. What is the order dated?
25/7/2024, my lords.
That's passed an order. The respondent has filed a petition seeking extension of time. Land counsel for the petitioner seeks time to file objections. When can you file?
Within a week, my lords.
List this matter on 13th of August. Yes, next.
Cell number 44.
Much obliged, my lords, deeply grateful.
Geeta
Yes.
Devi MP for petitioner. Sita Ramesh.
For the respondent, my lords.
Point that arises for consideration, my lord, is that whether a major daughter can she maintain a petition under 125 before the family court? That is a question we raised on maintainability. You know, the daughter at that point of time was 17-year-old and she was studying engineering and her father was taking care of
I
all
think
of
there is a judgment of the Supreme Court on this.
There is a judgment, my lord.
Supreme Court.
Supreme Court
Saying
judgment.
that she can maintain. Saying that she can maintain a petition, what the court says there is, like the unmarried daughter, instead of again going before the application filing at the Guardians and Wards Act, instead of relegating the parties from here to
But if your
there.
lordship is referring to Abhilasha's case, my lord?
My lord, I have the,
I remember somewhere I argued as an advocate.
Paragraph 32 onward specifically, the Supreme Court makes the distinction that 125 can be.
No, not only this one, there's a much older judgment in this regard. They must have been referred into this.
Yes, my lord, it's That is Jagdish Juktawat.
Ah, Lord, I will distinguish those matters,
Yes.
my lord. Now the question.
First of all, let's
I
see.
will pass on this judgment, reported judgment, what this council has granted to me.
Now let's see what is the ratio in this Abhilasha's case.
Please, my lord. Lord, what we'll have to see, my lord, is that the daughter has now completed her education and she's working gainfully employed now. She's 26-year-old.
Is
She's
so?
an engineer.
My lord, yes.
Yes, she is.
Then why she
My
wants
lord, it was
maintenance?
the maintenance was for the period of when she was in college, my lord.
What is the period?
The application was the suit was filed in 2017, my lord.
20?
17.
Huh.
Uh,
At that point of time, what was her
she
age?
had just joined engineering.
Engineering.
Second year student she was, my lord, at that
Then?
time, according to her own.
And the matter went on. The maintainability, the question of maintainability came only in the year of 2023, my lord, when it was pending for petitioner's evidence. And post that, the matter has been.
So 2023, her age is?
My lord, she
She was 18 when she
she was
filed the
8
petition.
Yeah.
Today she is 26, my lord.
And when, according to
1999
you,
she's
when
old.
she is employed?
She's employed more than 4 years ago, my lord. 26 years. She's completed her graduation and she's employed, my lord.
No,
Even when I filed,
2017, she's studying engineering second year.
She has
She might have completed probably in 2020.
2020, 2021, my lord. She would have completed around
Completed her-
2020 or 2021.
more than 4 years, 5
2020,
years
she might have
she's
completed. So right from 2020, she's employed.
employed.
Yes, my lord.
So from 20, then what about 2017 to 2020?
But those period, my lord. Now your lordship is looking into that aspect only. Now let us look into it whether she's maintained.
Yes. Now please come to this judgment of
Please, ma'am.
Abhilasha.
Para 34. Lord, the whole question is, you have the same copy, no?
Okay. I think paras would be the same.
Yeah, yes, ma'am.
No? 34.
The 34. Lord, Jagdish versus Juktava judgment has been distinguished in para 25, my lord.
First, we'll go to that judgment of Jagdish versus Juktala.
Please, my lord.
Where is it discussed?
24, my lord. And para 23.
Yes, please read.
Even para 22.
21, my lord.
We'll read from there.
There only. Now we come to the three judge bench judgment of this relied on so and so judgment. In the above case, respondent number 3 was a minor unmarried girl of the petitioner. The wife of the petitioner is the mother of the respondent number 3 filed an application section 125 claiming maintenance at rupees 500 at each of the applicant, which was granted by the family court. A revision was filed with High Court assigning the order containing respondent number 3. Kumari Raki was entitled to maintenance only till she attained majority and not thereafter. The High Court, although accepted the legal position at 125 CRPs, a minor daughter is entitled to maintenance. From her
Precisely,
parents.
this is what I'm referring to.
Please, Miller. Only till she attains majority, but declined to interfere with the order passed by the family court, taking the cue from section 23 of Hindu Adoption Maintenance Act. Lordship may also note, my lord, this is a personal law. Under the personal law, there was the right under 20 subclause 3 of the Hindu Adoption
For the
Maintenance Act.
unmarried girl.
Unmarried girl till she attains majority or till she is financially independent.
Because she has a remedy under that court.
20 and 3.
Instead of relegating her from here to there, let there be a maintenance under 120.
This is what this bench said, my lord, this judgment said. But the Abhilasha's case is distinguished and said, no, it can't be done.
Let's see that.
Very well, my lord. The fact, now, can I move to that, my lord?
Yes.
The facts goes there on, my lord, and then coming to para 23. Judgment of this court in Jagdish Juktava is a sheet anchor for the learned counsel applicant. The question which came up for consideration for the court in so-and-so has been noted in para 3 judgment, which is to the following effect so-and-so. In view of the finding recorded and the observation made by the learned single judge of the High Court, the only question that has for consideration is whether the order calls for interference. This court answered the question noticed in para 4 in such a manner. Applying the principle of the facts and circumstances of the case in hand, it's manifest that the right of a minor girl for maintenance from parents after attaining majority till her marriage is recognized under section 20 subclause of Hindu Adoption Maintenance Act. Therefore, no exception can be taken to the judgment order passed by the learned single judge for maintaining the order passed by the family court, which is based on a combined reading of section 125 Code of Criminal Procedure Code and section 20 subclause of Hindu Adoption Maintenance Act. For the reasons aforesaid, we are of the view that on facts and circumstances of the case, no interference with the impugned judgment or order of the High Court is called for. In the above case, an order was passed by the family court by granting maintenance, which is based on the combined reading of section 125 CRPC and section 20 of the Hindu Adoption and Maintenance Act. Although the High Court and this court had declined to interfere with the order of the Family Code, taking a cue from Section 20 subclause 3 of 1956 Act under which the right of maintenance is given to the minor daughter till her marriage. But the judgment of this court in Jagdish Chuttawat cannot be read to be laying down a ratio that in the proceedings under
What is this case arising under what, which proceedings?
My lord, this is purely under 125 CRPC, my lord. The child is an Indonesian national adopted by the parents of Indian origin. One is the father is a Hindu, a mother is a Mohammedan. Their marriage is under Special Marriage Act. So the personal law of either parties will not be applicable to both of them. And the child continues to remain a Indonesian national. Is entitled to maintenance or the father to maintain her unmarried daughter as contained in Section 23 of the Act. The High Court in excess criminal revision jurisdiction can very well refuse to interfere with the judgment of the court below by which maintenance is granted to unmarried daughter. This court, while hearing the criminal appeal against our judgment of High Court, was exercising jurisdiction under Article 136 of the Constitution. And in facts of the case, this court refused to interfere with the judgment. But in refusal of the interference by this court, no ratio can be read in the judgment of Jagdish Duktawa as contempt by the Land Council for the appellant. Now coming to 34, my lord, the court has held para 34.
That is Noor Shah Khatun. 330.
Para 34, my lord. That your lordship is reading
That is
31.
a matter relating to the Muslim.
Muslim law.
There again, a distinction is wrong.
34, please, my lord. Again, the whole question is whether they have a right to claim maintenance in the Muslim law or under the Mohammedan law, under the Hindu law. 34, my lord. There may be a case where the family court has jurisdiction to decide case under 125 as well as a suit under Section 20 of 1956 Act. In such event, the family court can exercise jurisdiction in both acts, and an appropriate case can grant maintenance to unmarried daughter, even though she became major, enforcing a right in Section 20 of 1956 Act, so as to avoid multiplicity of proceeding as observed in Jagdish Juktawat.
So,
however,
this application is
the
filed where?
please, my lord.
Family court.
Magistrate.
I've seen. Where is it filed? No, that I've seen. Where is this file?
Under
Family.
125 in the family court, my lord. It's exclusively under 125.
No, but still not before the magistrate.
My lord,
Sir,
section.
under 125, it's a magistrate only, my lord. It will be a family court. At those times, my lord,
let's see the order.
magistrate exercising powers under Section 125.
My lord, if I may make.
That's what the distinction is. Now the 125 proceedings are initiated before the magistrate. Now in Karnataka, that's under
Family
family
court,
court.
family court.
So because family court has got the jurisdiction to decide an issue with regard to the maintenance of the daughter under the Guardians and Wards Act.
Either the personal law. Personal law,
That's a distinction at para 34.
Please,
Now let
Madam.
us see this order is passed by which
Lord,
court?
now, your lordship may kindly take and what is the final outcome in Section 13, para 39 and 40, my lord?
Yes.
We
No,
We
again
thus
we will-
accept
no, no,
the
again we will
submission of
read
the learned
34.
counsel for the appellant that a proposition of law, an unmarried Hindu daughter can claim
Council will
maintenance.
read 34 again.
Please, my lord.
Yes. And we'll understand what it is at 34 again.
There may be a case where the family court has jurisdiction to decide under Section 125 of CRPC as well as a suit under Section 20 of 1956 Act. In such eventuality, the family court can exercise jurisdiction under both the acts, and in appropriate case can grant maintenance to an unmarried daughter even though she became major, enforcing a right under Section 20 of 1956 Act, so as to avoid multiplicity of proceeding, as observed by the court in Jagdish Juktawat.
Yes.
However, the magistrate in excess of powers under 125 cannot pass such an order. In this case, before us, the application was filed under
So now
125.
what is your submission as far as 34 is concerned?
Lord, in this case, whether does the child have right under 20 subclause 3?
My lord, that would be going to the merits, my lord.
Oh, 34.
Please, madam.
The ratio that is now laid down by the apex court.
If the
As far as Jagdish
Juktawat
Juktawat is
case-
concerned, it is upheld.
If the family court has jurisdiction under both the provisions,
provision.
then it could grant the relief in either instead of going for multiplicity proceedings.
Exactly.
Now, if that is the question here, my lord, now in this case, my lord, this child does not, personal law is not applicable to the child.
What is she? What?
The Indonesian.
No, my lord, she's an Indian national. She was adopted in Indonesia as a minor. She, at the age of 1.5 years old, she was brought to India, my lord.
No, my lord.
She's a Hindu.
Let the facts be clear. Let me just pass
We'll
on
go
her.
to the
Let me pass on her passport which says which is her nationality.
No,
and
even this must disclose all that, like what the petition that is
It has
filed.
not been discussed, madam.
Give that.
She's not a Hindu, she's a born Indonesian child born there. They adopted the child there. And she's now a child of Indian origin, that's all. The passport very clearly says that nationality is in Indonesian.
No, she's
Even today.
adopted by the Indian parents.
Indian parents.
Then
Now,
what
one
they
is a
will-
Hindu, one is a Muslim. They got married in a special marriage act. Personal law is not applicable to them. It's only under section 18. The personal law is not applicable to them, my lord. So other 20 or Hindu law, modern law, both the laws are not, personal laws are not applicable to them.
My lord,
Under section 18 of the Hindu, of the Special Marriage Act.
Yes.
my lord, the question of whether the personal laws would be applicable would have to be looked into at the time of the thing, because there is also a pleading by the petitioner themselves wherein they state that marriage has been done under personal law, then the husband is converted to Islam as well. It is a pleading of the petitioner themselves. my lord.
Husband is a Hindu.
Hindu.
Wife is a Muslim.
Yes, my lord.
Married under the
Special
Yes, my
Marriage
lord.
Act.
My lord, but then the very fact that that cannot be looked into at the question of maintainability, my lord, because that would have to be gone into at the time of trial, and merits of the case would have.
It's already decided.
My lord, but then the question as to what because there cannot be an.
Very simple. It's very simple issue now. Now, their contention is a major daughter is granted maintenance, which she is not entitled under 125. Both of you are relying on this judgment.
Yes, ma'am.
It is made clear that when a family court has a jurisdiction to deal with both under the Hindu guardianship and that and 125, then though she is major, then she is entitled.
Yes, ma'am.
No, even that further, no evidence, nothing is required. Now, if you are a Hindu, then section 20 of the Hindu Minority and Guardianship Act will apply. Is it your case that you are a Hindu?
Yeah, my contention is I am a Hindu.
Where did you say, where is that petition that's filed for maintenance? What is your contention?
Annexure B, my lord.
That is filed by the mother.
My lord.
The child herself has filed a petition.
Yes, my lord.
Where is that?
She was major, page number 49, Annexure B.
49.
49.
Let's see.
So that is not their pleading that I am so and so, I am a Hindu. It does not say. The petitioner submits that what are by the following Hindu religion and continue to practice Hindu till date. That's what she's pleading. But then now that is not the contention, my lord. Now whether that is right or wrong, section 18 of the Special Marriage Act very clearly says once there is a marriage, it's only the Special Marriage Act will prevail. Personal law will not be applicable to them, my lord.
Use the Act, Special Marriage Act.
Allah, Special Marriage Act.
Special marriage. Section, ma'am?
18.
The daughter herself has filed a petition.
She has filed a petition.
I was under the
My lord,
impression
she has
that
not filed against the father. Father has enough assets and he is to be capable
My lord,
of
that
taking
would
care.
all be going to the
All
merits,
that they
my
are
lord.
looking into, my lord, is that she has, actually the mother is unwell. She had fallen and had an accident. Now she has a kidney issue, which is continuation of a persistent problem. She is a chronic patient and she requires the money. There's a house that he has gifted the father.
how much is the maintenance granted?
Maintenance has not been awarded at the stage of maintainability. That matters come before your lordship, my lord.
Yes, let's see.
Section 18, my lord. Effect of the registration of marriage under this chapter. Subject to provisions contained in subsection 2 of section 24, where a certificate of marriage has been finally entered in marriage certificate book under this chapter, the marriage shall, as on the date of such entry, be deemed to be a marriage solemnized in this act, and all children born after the date of ceremony of the marriage, whose names shall be entered in the marriage certificate book, shall in respect deemed to be and always be deemed legitimate children of their parents, provided that nothing contained in section is construed as conferring upon any children rights or in or on property of the persons other than their parents in case where both, but for the passing of that such children would be incapable of possessing or acquiring such rights by reason of not being legitimate children of this their parents. Effect of marriage and undivided family, etc. So now, Lord, there are judgments in the under this section 18. Once they are married under the Special Marriage Act, then the religion of the parents will not be applicable to either which. Neither the Hindu law will be applicable nor the Mohammedan law will be applicable to them.
Then it is applicable to them.
That's why they have come under 125. Under 125, she ought to have pleaded Your lordship, may kindly permit me to take your lordships to section 125. She ought to have been pleaded, it's maintainable only when there is uh, a physical or mental abnormality. Now that is not their pleading. It is not her pleading that I have physical disability, section 125, my lord.
It doesn't say so.
That is, please, my lord, subclause B, my lord. May I just read B of 125, my lord?
C, 125C.
B, my lord, is C, my lord, please, my lord.
Is
Is
legitimate or
legitimate
illegitimate minor
child not being married daughter who has attained majority where such child is by reasons of physical or mental abnormality or injury unable to maintain itself. Now, this is not her pleading. I have physical or mental abnormality. I am major, but I have this abnormality.
Is legitimate or illegitimate child not being a married daughter who has attained majority where such child is by reason of any physical or mental abnormality
Or injury is unable to maintain itself. She claims here, my lord, that this is not her pleading that I have physical disability, I am not able to earn my livelihood. That is not her case. She says, I am until 2017, they were 16, few months ago, they were all together. She, the mother, has actually came back from Indonesia, resigned her job, take care of this child solely because there is a responsibility of having adopted the child.
So, as per those judgments, which person law will apply to them? Nothing will apply.
In this case for her?
Not in this case. I'm saying generally, you're saying,
Please,
as per
my
the
lord.
judgment, the parents are married under the Special Marriage Act, then the children will.
Children
It's
will-
all about what is the.
What they want to follow thereafter, we don't know. But this is in her case, she has not declared that I am a Hindu. She has not declared I am a
Just so
Hindu.
you read somewhere that she says, I'm a.
Nationality is an Indonesian. That's here she's
So I'm
saying.
professing
But in the
Hindu religion.
passport, in her pleading, she
In
has
the
said.
pleadings.
In her pleading, she said that's what it is. But that is not true. And now if you take their own contention, our contention, my lord, that they followed, there was a nikah and then he converted. Now whether we
No,
don't
that's
even
the
know.
issue to be decided now, which has to be decided by the trial court by way of evidence. No, already there is a pleading saying that she is a Hindu. You say that she is not Hindu. Parties are married under the Special Marriage Act, and she's an Indonesian citizen, or whatever you're saying. Well, that both of you have to prove it. But once it is proved, and she is a Hindu, then as per the judgment of this case, the family court can decide.
Question also, my lord, would be is that whether the when she says, my lord, that now that she is employed, again it becomes a
Not academic one, but that few months, few years where she was not employed, 18 to 21. That time she was 18, she was studying.
even in her pleadings, it's her father who has to take care. Now he is the one who has adopted. In the adoption deed, it's very clear, my lord, that the question is, they both of them have taken the child in adoption, but she resigned.
That is on the merits of the matter, whether she is entitled. No, the issue is on the maintainability of the petition, considering her age, 125. Now, once the court decides that aspect of maintainability, then comes the question, considering the financial position of the mother, and when the father is already having enough resources, and as you say, he is the one who has adopted, why should the mother pay the maintenance but not the father? That has to be decided based on the merits of the matter, based on evidence.
But when we say that she's a major and she's already working, again the question of
3 years, who will answer from 18 to 21? 3 years when she was not earning. That time mother or whoever, I'm not, this
She has not made the father a party. Even the father would have been a necessary party.
Also when you can say that before the trial court, before the family court, saying that I'm not, this is my position, health issues, father is hale and healthy and he is earning, I'm not in a position, then the court will decide that also. Because whoever it is, that 3 years period, that is, so she's entitled. As
So
per the
let them
judgment.
say from when she's employed, when she completed her graduation also.
My lord,
Before the court, all these things, before the family court. Because any of this court cannot go into what is the entitlement and all. Please come.
But again, the question would be, my lord, then whether now that she's an Indonesian national, how will which law will be applicable? That's what.
For that, it has to be decided if you're saying the maintenance.
Let that question also be open.
Everything open. All those things open for the
My
court to
lord,
decide.
let the question be open. My only submission with regard to that point, my lord, is when the parents have adopted, both parents who are Indian nationals are adopted as per the Indian Citizenship Act, any child, whether adopted or not, would be able to take the passport of the Indian embassy, that is the Indian nationality. If the mother is, if they either born to Indian parents or the mother.
All that.
I leave that.
Reserve the energies
Yes, my
before
lord.
the trial.
I leave that to your
Family court. Order is it?
My lord,
It's 46 annexure A, my lord, but operative portion is in page 42.
The
Order of
upgrade-
page 38. It starts at page
The
38.
daughter has filed a petition seeking maintenance against the mother under 125 CRPC before the family court at
Bangalore, my lord.
before the principal judge, family court, Bangalore.
Fifth
In that-
additional, my lord. Huh? Fifth additional.
Fifth
principal.
additional judge, family court. In that, the has raised the issue with regard to maintainability. The contention of the mother is that the daughter is a major daughter. As such, she is not entitled to claim maintenance from the mother. The court had held that the petition filed by the daughter is maintainable against the mother. The mother, whether capable or not, will be considered at the time of the trial. And accordingly, that petition is, the court has held that the petition is maintainable and dismissed the application filed by the mother. Learned counsel appearing for the petitioner, relying on the judgment of the Honorable Apex Court in case of Abhilasha.
This is Parkash, 2021, volume 13. SEC.
Abhilasha versus Prakash and others reported in 2021-13 SCC 99, relying particularly on paragraph number 38,
34, 35 and 38. my lord.
particularly 34, paragraph number
34, 35 and 39.
34, 35 and 39 submits that the Honorable Apex Court had considered the judgment of Jagdish Juktawat and held that when an application is filed under 125 CRPC before the magistrate cannot consider the case of a major daughter for maintenance. But when it is filed before the family court, and when the family court has got the jurisdiction to decide the case under the Guardianship and Wards Act, Hindu Minority and Guardianship Act, then consider the judgment of Jagdish Juktawat will apply. It is submitted that by the land counsel for the petitioner that both the mother and father of the respondent herein are married under the Special Marriage Act. In that case, the petitioner who is adopted, who is an Indonesian citizen, who was adopted by the father, she cannot be a Hindu.
My lord, in regards to that, adopted by the mother and father, my lord, both the parties.
Adopted by the mother and father cannot be a Hindu. When once the personal law do not apply, even though the family court has decided this application under 125, but as the personal laws do not apply to the respondent herein, the respondent daughter, the Hindu, as she is not a Hindu, as it does not apply to her, the court cannot decide the application, cannot decide the application filed by her is not maintainable, and the judgment of the apex court in Jagdish Juktawat will not apply to the facts of the case, and it is submitted that the application is not maintainable and the court ought to have allowed the application. Next para. Learned counsel appearing for the respondent daughter submits that she is adopted. The father is a Hindu, mother is a Muslim. Though both of them are married under the Special Marriage Act, the daughter has stated that she believes in Hindu religion and she's a Hindu. Once she is a Hindu. The Hindu Minority Guardianship and Wards Act will apply. And the case of the daughter will squarely fall. The judge, as per the law laid down by the apex court in Jagdish Chuktawat's case, which is clarified in Avilasha versus Prakash, referred Supra. He submits that all those issues are on the merits of the matter, and at this point of time, those issues cannot be decided. Next para. The Hurdle and Counsel on either side, there is a material on record. The daughter, who is aged 18 years, has filed a petition seeking maintenance against the mother. Admitted facts are mother is a Muslim, father is a Hindu, daughter who is adopted is an Indonesian citizen. According to the mother, she is not keeping well and she is not in a position to pay. And the daughter who is major is not entitled for maintenance. And she can't seek maintenance under 125. The trial court has said that it is maintainable. And the judgment, which is referred to Supra in Abhilasha and Prakash, which has considered Jagdish Juktawat's case, is clear that a family court, if it is entertaining a petition on 125, and even a major daughter's entitlement can also be decided. Now the council's submission is that the personal laws do not apply to the daughter as the parents are married under the Special Marriage Act. All these issues are left open to the parties to lead evidence, and the court is at liberty to adjudicate on the same. At this stage, under this backdrop, just on the ground that an application is filed under 125 CRPC, the court cannot say that the issue is not maintainable. In the light of the above discussion, this court is passing the following order. The writ petition is disposed of, leaving it open to both the parties to lead evidence with regard to the with regard to the religion of, with regard to the personal law, which personal laws will apply to the daughter, whether the mother is capable of paying maintenance to the daughter.
And the obligation of the father, my lord.
And no, that you have to. Now that I will not, whether the.
You have raised that, my lord, that question.
That will be decided, whether the mother is capable, and all other issues relevant shall be considered by the court. Accordingly,
The mother is suffering from chronic disease, kidney disease, my lord. It's not something as illness which can be curable.
The daughter is 5 is because the father is also sick, my lord. It's there in the petition.
So, which year is this?
2017, my lord.
17 matter, my lord.
20, as far as this is a matter of 2017, no, in the contentions of the petitioner, already she is employed and she is earning. Then counsel for the respondent submits that they are restricting their claim for maintenance from the date of petition till she
graduated.
Till she graduated, and all those details when she has graduated, when she is employed, and all will be placed before the court.
Sorry, my lord, if I may, but could it be changed till she was employed, my lord?
That's what I said.
My apologies, my lord. My apologies.
That's what till she employed, not graduated, till she employed, and when she is employed, all those details will be placed before the court. Yes.
Lord, her ailment would be mentioned.
17.
Sickness, chronic disease.
The
Chronic kidney disease.
mother is suffering with chronic kidney disease. Then, as this is an application next in the order portion, as this is an application filed in the year 2017, the family court shall expeditiously dispose of this petition.
Till number 45. CM for petitioner. 45.
For the petitioner, my lord, I seek for a short adjournment. Seeing there has some personal inconvenience, it may be taken up tomorrow, my lord.
Give the order sheet. How many times it is adjourned? 23/7/2025. Finally, 2 days time is granted to comply with the office done by the officer and so. Now they are complied with.
Yes,
When do you want?
tomorrow, ma'am.
Tomorrow.
Cell number 46.
The request of learned counsel the petition tomorrow. Yes, 46.
46,
46.
cell number Sappa.
I am challenging the impugned order A number 3 of the passed by the principal family judge in Bangalore. Page 10. Sorry. On 9, 10.
You're for the wife or husband?
Husband,
How much is granted? 40,000
40,000.
per month.
A number filed under section
20,000 for respondent and 10,000 each for the two children. What is your income?
No income.
No income, court grants 40,000.
Kindly
to the
see,
order.
kindly see the page number 34, my lord.
Page number?
34.
No, no, let us read the order. What is the basis for the court to pass this order? Come to.
9, para number 9, my lord.
Please read.
15.
Regarding interim maintenance, there is a claim of rupees by respondent and a contention that she incurred huge expenses and so. You have not filed your statement of other.
State objection.
You have not filed.
Not filed
Why?
objection. But some inconvenience not filed.
Then
and
your
made.
inconvenience, you will pay for your inconvenience.
Also.
No,
So
when the law
what happened, my
says,
lord?
when the law says,
Only 2 dates was given.
you know, why it will give 100 dates. Now this court has
one day-
directed all the courts not to give more than one adjournment for statement of assets and liabilities.
Kindly see the, my lord, page number 34.
No, please tell the court, why should we do the exercise again? When you are supposed to file the statement of assets and liabilities, when you have not filed, why the adverse inference cannot be drawn as per the judgment of the Supreme Court?
The respondent, my lord, respondent.
I'm asking about you. What about your statement of assets and liabilities?
No income is only a second PUC. I am not
For
employed.
that also there is a procedure to tell that
Not
it is
employed.
only you don't have
But,
any income.
But respondent is residential property is there in father name, petitioner father's name.
2024 matter. It is coming up to, when did you file this petition? You filed this petition on 3/4/2024. It is coming up before the court after 1 year, 3 months. And that too, last time when this court has directed the matters to be listed, 1 week time is granted. You have not complied the office objections from 24 to 25. Why should we interfere with the order now? What is the stage of the case before the family court?
Evidence, posted for evidence, further evidence.
You complete the evidence. Let this order remain. Are you paying or not paying?
I am not paying. Why means I am not employed. This is all properties petitioner's father's name. No opportunity was given to me.
If you want stay, you have to pay the amount. If you don't want stay, there is nothing to consider. I will dismiss.
Some 25%.
No 25%. Half of it we will consider. Not 25%. How many lapses on the part of your client? You don't file state.
No opportunity was given to my client.
To show where opportunity is not given.
Opportunity means objections and assess and liability.
Let's
The respondent simply filed the assess and liability. So many properties in name of the petitioner. Petitioner, no one properties own.
Why do you blame the court? Why do you blame the court? The court had granted 40,000 as maintenance. The petitioner husband has failed to place his statement of assets and liabilities. When the order is passed on 1/3/2024, till now, he has never taken any steps to get the matter listed. Till 23/7/2025, an order is passed by the court. Till such time, he has not even complied with the office objections, nor he has no stay is granted by this court, and he has not complied with order of this court or the order of the family court. In these circumstances, this court is not inclined to go into any other aspects. The the petitioner shall pay an amount of rupees 20,000 by 5th of every succeeding month, and the arrears at 20,000 shall be paid within a period of 8 weeks from today, or else the writ petition itself stands dismissed.
Cell number 40, notice.
Note, the petition is permitted to take out hand summons on the counsel appearing for the respondent before the trial court. Yes.
Cell number 47,
Notice to the respondent before the trial court, hand summons. And file a memo
What
to
would
that
you take documents
effect
with this?
by 19th of August. Yes, yes.
Give me the copy.
47.
Huh?
I filed an affidavit.
47,
47.
47.
Blood affidavit copy is given to me, no blood, I look into it.
Submitted as per the counsel for the respondent submits as per the order passed by this court is filed the affidavit before the court, and the same is served on the counsel for the petitioner. Counsel for the petitioner seeks time list when
But 3 weeks, my client is in Maharashtra, I'll get in.
Maharashtra, the letter will not walk from here to Maharashtra.
Blood.
Let's do smarter next week.
Blood 3,
One submission, sir. In connection with the affidavit, I want to file a memo of documents with respect to IT and TDS. I'll place it
File before the court with the.
Copy is out to the office.
Sir, is
2 weeks time maybe.
this is smarter on 21st of August.
Great.
Yes, next.
Cell number 48, Rajkumar MD, petitioner.
Lordship, I represent the father. The two prayers that I'm seeking before this honorable court is to expeditiously dispose of an application.
Which application, IA.
Application
When was
and
it filed?
also the proceedings before the lower court. Proceedings was filed in the year 2022. Application was filed in the,
No, 22, no, this rejected, next.
the
Next,
application
IA
may,
is when?
the application may at least be considered. Your
When was it filed?
Lordship. 29/10/2024.
2910, what is that application?
Your Lordship, that application is seeking modification of the visitation order which was already given by the lower court.
Where is that?
Lordship,
Where is the
page
prayer?
number 69, Your Lordship.
No, prayer, come to the prayer.
21, Your Lordship.
The present writ petition is filed, seeking the following prayers. When counsel for the petitioner submits that there may be a direction to the family court to dispose of the matter as expeditiously in a time-bound manner. The MC is, what is this?
Lordship.
MC is of the year 2022.
Yes, Your Lordship.
As there are several cases which are much older to this case of pending, there cannot be any direction to the family court to
Your Lordship, it's
dispose of
not a
the-
family court, it's a rural, second additional senior civil judge, Bangalore Rural District.
Oh, it's Bangalore rural.
Yes, Your Lordship.
Then tomorrow, get the status. Rural. Come in. This RNS says there is no rural family court. Get the status of the cases in that court. Then we will pass orders. Tomorrow.
Please.
I thought it is Bangalore urban.
No, Your Lordship. The Bangalore.
Yes.
Great, Your Lordship.
Cell number 49,
The petitioner
Yes.
application for interim custody has been rejected, but the visiting rights have been given, my lord. My grievance is that, my
Notice,
lord.
notice to the respondent. Hand summons.
Yes.
Shall file a memo to that effect by 12th of August. If the memo is filed, list the matter immediately.
cell number 50, 50, Gaurav Singh Gaud,
For the petitioner. This is the WP file against the impugned order passed in the execution petition before the family court. Now, the impugned order is at the page number 163 only.
163.
Only 63.
Yes.
Now, the first aspect that has to be considered here is the petitioner is a citizen of USA, Your Ladyship, and she is residing in USA. Now, the Wakalatnama was duly executed in USA, and it is forthcoming in the Wakalatnama as well that it is executed in USA.
You are for the husband or the wife?
And for the wife.
What is this injunction? Let us see first. Come to the order.
Yes, sir. Now, the first aspect.
Hence, the JDR was restrained through the orders of this court. JDR is the wife.
Yes.
is restrained through the order of the court on IA number 4 in miscellaneous by way of ad interim injunction. On pursuing the case filed before the Family Court of the State of New York and Order 21 for the execution of the terms of settlement arrived between the parties in miscellaneous number so and so, which is a compromise terms arrived between the parties by modifying their own terms of settlement. Hence, the JDR is hereby directed to comply the terms of compromise. Who filed the MC?
MC was filed by both the parties. It's a mutual consent.
It's a mutual consent divorce.
Yes.
Obtained when?
In 2018 year.
Decree
Then when is the
2019.
modification of that?
2019, my lord. MC
when-
decree.
When is the modification of that?
On 9/10/2020 year.
Modification. Then when did you file the petition in USA?
There was a petition that is filed in USA that is on 26/6 to 2024 year.
Why should you file a petition after obtaining a decree here? Mutual consent decree.
There were a serious sexual allegations against the husband here.
So
So the only consent here is the mother was not ready to send the children to India. Because even in the terms of the compromise, nowhere it states that the children has to be sent to India.
let's see the then if there is nothing in that, why would the court insist for it? What is the petition that is filed before the courts in US?
It is for the sole custody of the
Or
children.
you filed a petition for custody?
Custody of the children. For
So
fair,
let us see, come back to the miscellaneous or where the terms of the compromise were changed.
yes.
Let's see page number.
It is page number 84 here. In this case, clause A, your ladyship, the petitioner was.
Petitioner means who? Husband.
Yeah, petitioner is the wife here, your ladyship. The petitioner will relocate to USA.
No,
along
MC is filed by you.
Yes.
So petitioner will relocate to the USA.
USA along with the 4 children. Custody of all the 4 children was given to the mother here. Now, coming to clause C, the children shall spend their entire part of school vacations with the respondent. In the event the respondent is unable to travel to USA to have the children's interim custody for any part of their vacations, he shall intimate. Nowhere in this term it says the children has to be sent to India, your ladyship.
We'll read it again. The respondent will have daily access to children over telephone, video call for at least 1 hour. Time and duration of such interaction will be decided upon by the parties. The petition will ensure such daily interaction if the respondent desires it. During the weekend, the duration of the call shall be for 2 hours each day. One telephone instrument for such communication, pay the monthly charges for the same. The children shall spend their entire part of school vacation with the respondent. It is there.
Yes, your ladyship. In
See.
the USA, your ladyship. Not, it doesn't say that children has to be sent to
Read
India.
it. Read it. Let's read it.
The children shall spend.
No,
their-
first, the children shall spend their entire part of the school vacation.
With the respondent. It is,
Next.
in the event the respondent is unable to travel to USA to have the children's interim custody for any part of their vacations, he shall intimate the same to the petitioner at least 1 month prior to the commencement of the vacation.
Now, then if the respondent visits the USA, shall have interim custody. Then what else is decided? Agree to revert the joint physical custody of children will live with each parent for 3.5 days. Even the respondent relocating to, so given the nature of responsibility and sufficient travel. Now, where is the execution petition?
It is in page 123 here. Starts from page 123.
We'll continue after lunch.
One small request, my lord. Serial number 55, my lord. I have a little inconvenience in the afternoon. Tomorrow, my lord. It's not that I want to seek a.
Atro principle. No
Yes.
adjournments in the afternoon. Now, once you start, everybody will start the
No,
adjournment.
my request, my lord. Tomorrow, my
I'm
lord.
not entertaining any other adjournments. Please
Please.
do not make. 55, when do you want?
Tomorrow, my lord.
Tomorrow, yes.
Great.
I am appearing for the respondent.
Your lordship.
Field number 3 passed over matter.
Yes.
I oppose, Your Honor. I oppose unless there is an order vacated.
My client called me.
No, Your Honor, I have no information. Yes.
Both of them, they have.
We'll hear the matter.
Settlement.
We'll hear the matter.
Kindly tomorrow, I will find out the truth of.
How many times you will
No,
ask
no,
for
my lord.
adjournment?
Unless the stay order is vacated, I have no other option. Yes. Yes.
ಡೇಟ್ ಹೇಳ್ಬಿಟ್ರೆ ನಾನು ಬಂದಿದ್ಯೋ ಬಂದಿಲ್ಲೋ ಪರ್ಫೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬಿಡ್ತೀನಿ. ನಮ್ ಕಡೆ ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ಅಲ್ಲೇ ಹೋಗಿ ಕೇಳ್ಬೇಕು. ತಗೋತಾ ಇದಾರಲ್ಲ ಸರ್, ಗೊತ್ತು ತಗೊಂಡು ಎಲ್ಲಾರ್ನು ಕರೀತಾರೆ. ಹಾ ಅಷ್ಟೇ. ಹೇಳಿ ಮೇಡಮ್, ಡೇಟ್ ಹೇಳಿ ಮೇಡಮ್. ಏನ್ ಹೇಳಿ? ಒಂಚೂರು ಲಿಸ್ಟ್ ಕೊಡಪ್ಪ ಆ ಕಡೆ ಅಂದಲ್ಲಿ ಇದೆಯಲ್ಲ. 34 ಮಾಡ್ರಾ? 87 ಲಿಸ್ಟೇ ಅಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ಲ ಸರ್. ಸರ್ 34 ಅಲ್ವಾ? ಹೌದೌದು, ಎಲ್ಲ ರೆಫರ್ ಟು ಮೀಡಿಯೇಷನ್ ಆಗಿದೆ. ಡೇಟ್ 7/8 7 ಆಗಸ್ಟ್ 22nd ಮೇಡಮ್. 22nd ನಂಬರ್ ಹೇಳಿ ಮೇಡಮ್. ಮೇಡಮ್ 204 ಬಂದಿಲ್ಲ ಮೇಡಮ್ ನಮ್ಗೆ ಚೇಂಬರ್ ಇಲ್ಲ. ನಮಗೆ ಕಳ್ಸಿದ್ರೆ ತಕ್ಷಣ ಇದು ಮಾಡ್ತೀವಿ. ಕೇಳಿ ಅವ್ರು, ನಾವು ರೌಂಡ್ ಅಪ್ ಮಾಡ್ಕೊಂಡಿವಿ. 76 76 ಇದೆ ಸರ್, ಕರಿತೀವಿ ಮತ್ತೆ ಕಾಲ್ ಔಟ್ ಆಗಿದೆ ಸರ್. 7 ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಮೀಡಿಯೇಷನ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. 7 ಆಗಸ್ಟ್ 80 ಕರ್ದಿಲ್ಲ ಸರ್, ಕರಿಬೇಕು. 58 ಕರಿತೀವಿ ಮೇಡಮ್ ಮಧ್ಯಾಹ್ನ. 65 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಗಿಲ್ಲ, ಕರಿತೀವಿ ಮಧ್ಯಾಹ್ನ. ನಿಮ್ದು ಕರಿತೀವಿ ಮೇಡಮ್. ನಿಮ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಇಂದಿ ಲಿಸ್ಟ್ ಎಲ್ಲ ರೆಫರ್ ಟು ಮೀಡಿಯೇಷನ್ ಸರ್. ಮೀಡಿಯೇಷನ್ ಬರುತ್ತೆ ನೋಡಿ. ಮೀಡಿಯೇಷನ್ ಅಲ್ಲಿ ಲೋಕ ಅದಾಲತ್ ಅಲ್ಲಿ ಕೇಳಿ 7/8 ಬರುತ್ತೆ. ಫೈಲ್ ಹೋಗಿಲ್ಲ ಅಂದ್ರೆ ಕಾಯ್ಬೇಕು ಸರ್, ಸಿಗ್ನೇಚರ್ ಆಗಿರಲ್ಲ. ಮಾಡ್ಬಿಡಿ, ಕೊಡ್ತೀನಿ. ಅಲ್ಲಿ ಬುಕ್ ಇದೆಯಲ್ಲ. 63 ಕರಿತೀವಿ ಸರ್, ಮಧ್ಯಾಹ್ನ ಕರಿತೀವಿ. ಗೆ ಬುಕ್ ನೋಡಿ ಮೇಡಮ್, ಆ ಕಡೆ ಬುಕ್ ಇದ್ರೆ ನೋಡಿ. ಅಯ್ಯ ಅಲ್ಲೋ, ಇಲ್ಲೇನ್ ಮಾಡಕ್ಕಲ್ಲ, ಹೋಗುತ್ತೆ ಸರ್. ಸೈನ್ ಆಗ್ಬೇಡ್ವಾ? ಸೈನ್ ಏನು ನಾವೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಮೀಡಿಯೇಷನ್ ಏನ್ ಮೇಡಮ್? ಇಷ್ಟ ಆಯ್ತು. ಅಲ್ಲೊಂದ್ ಸ್ವಲ್ಪ ಇದೆ ನೋಡಪ್ಪ. ಡೇಟ್ ಎಲ್ಲ ಬಿಟ್ಬಿಡಿ. ಡೇಟ್ ನೀವು ಬರ್ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ, ಸೊ ಅದನ್ನ ಟಿಕ್ ಮಾಡ್ಬಿಡಿ. ನೀವು ಟಿಕ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಬರ್ದಿದ್ದೀರಲ್ಲ ನೀವೇ. 56 ಅಲ್ಲ ಮೇಡಮ್? 56 ಕರಿತೀವಿ ಮೇಡಮ್ ಮಧ್ಯಾಹ್ನ. ಅದೇ ಮೇಡಮ್, ನೀವು ನಾವು ಕಳಿಸಿರ್ಬೇಕು ಅಂತ ಬುಕ್ ಬರ್ಬೇಕು, ಬುಕ್ ತಗೊಂಡೋಗಿದ್ದಾರೆ, ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ. ಇದೊಂದು ಫೈಲ್ ಬರ್ಕೊಂಡ್ರೆ ಇದು ಇವ್ರಿಗೆ ಹೋಗುತ್ತೆ.
ನಿಮ್ಮಿಬ್ರಿಗೂ ಹೋಗ್ಬೇಕದು. ನೀವು ಹೀಗೆ ಆಮೇಲೆ ನೀವು ಅವ್ರು ಕಳಿಸ್ತೀರಾ? ಅವ್ರು ಕಳಿಸ್ತೀನಿ. ಹ್ಞೂ ಆಯ್ತು, ಓಕೆ. ಓಕೆನಾ?
ನಾಳೆ ಕಲೆಕ್ಟೆಡ್ ಕೇಸ್ ಇದೆ.
ನೀವು ಅಲ್ಲಿ ಚೇಂಬರ್ ಅಲ್ಲಿ ಕೇಳ್ಬೇಕಿತ್ತು, ನಮಗೆ ಬಂದಿಲ್ಲ. ಅವ್ರ ಕಡೆ ಯಾಕೆ ಇತ್ತಲ್ಲ ಕೇಳಕ್ಕೆ ಆಗಲ್ಲ, ಅವರು ನಾವು ಕಳಿಸ್ತಾನೆ 7-8ಕ್ಕೆ ಸರ್. ಅಲ್ಲಿ ಲೋಕ ಅದಾಲತ್ ಅಂತ ಬ್ರಾಂಚ್ ಇದೆ, ಅಲ್ಲಿ ವಿಚಾರಿಸಿ ಅದೆಲ್ಲ ವಗೇರೆ ಹೇಳಿ.
ಡೇಟ್ ಮೆಟರ್ ಎರಡೇ ಅಲ್ವಾ ಮ್ಯಾಮ್ ನಾನು ಬರ್ತಿದ್ದು? ಡೇಟ್ ಮೆಟರ್ ಎರಡೇ ಅಲ್ಲ?
3 ಟೋಟಲ್ 3.
Court officer,
ಇದೊಂದು 3.
court officer,
ಸೈನ್ ಹಾಕ್ಬೇಕಾ ಮ್ಯಾಮ್?
ಸೈನ್ ಹಾಕ್ಬೇಕು. ಎಲ್ಲ ಆಯ್ತು ತಾನೇ? ಸಿಗ್ನೇಚರ್. ಕಾಲೇಜ್ ತಗೊಂಡು ಇಲ್ಲಿ ಕಾಲೇಜ್ ಕಮ್ಮಿ ಆಗಿದೆ.
court officer,
ಅದೊಂದು ರಿಸೀವ್ ಮಾಡುತ್ತೆ. ಇದೊಂದು ಫೈಲ್ ಇದೆಯಲ್ಲ, ಎಷ್ಟು ಇದೆ ಹೇಳಿ ಅದು?
3607.
ಹೌದೌದು, ಅದೇ ಅದೇ. ಈಗ ಮಾಡ್ಬೇಕು ಸರ್, ಹೋಗ್ಬೇಕು. ಟೋಟಲ್ 2 ಯಾತ್ರಿ ಹೋಗ್ಬೇಕು ಬೇಜಾರು. ಏನ್ ಕಟ್ಟೆ ಎಲ್ಲ ಕಟ್ಟೆನಾ?
Any of the matters are listed more than 100. ಅವಾಗೆಲ್ಲ ಕೊಡಿ ಸರ್.
Yes, what is this execution petition?
So my lord, the parties have 4 children. Mutual consent divorce happens in Bangalore. Both parties are residing in Bangalore. We agree that we will have joint custody and joint guardianship. 2 years later, the mother files a miscellaneous petition to modify the arrangement arrived at earlier. I, as the father, I enter
Where
appearance.
is that modified
Yes.
compromise petition, page number?
Modified compromise petition is at page 83 of the writ petition. I think my lord had gone through it just a little bit earlier.
That's the same one.
Yes,
In
so
that
that's
it
the
never-
first modification. Now in that first,
No, as far as this is concerned,
Yes.
it never speaks about children coming to India.
Well,
It is about exercising the visitation in the US.
It's silent. It neither says
No, it
in
is not
US.
silent, it is very clear.
May I?
Yes, you can read.
Please, madam.
Regarding custody, you can read.
Yes. So
Yes.
regarding custody, point C says the children shall spend their entire or part of school vacations with the respondent. It doesn't say either in the
Then
US.
read it. Read
Yes.
the next
Thereafter,
one.
it says that if he
In
cannot come
the-
to US.
No, no, in the event, the respondent is unable to travel to the, first of all, it said how you spent.
Yes.
Where you spent is the next. So
Correct.
it is very clear.
Very well. I'll accept
Nowhere,
that.
nowhere it says about India.
Very well. I'll accept that. So in 2021, I enter into this compromise and the mother and the 4 children relocate to America. Thereafter, the mother remarries. Now there is a step parent involved. 4 children are over there. In 2022, all 4 children travel to India for their summer break. They spend their summer vacation here. In 2023, I travel to USA. I exercise my visitation there. So by conduct and by consent, 1 year the children have all come here. 1 year I have gone there. Your lordship may appreciate it is far more cost effective for father to go there on one return ticket.
Unfortunately, we cannot appreciate something which is contrary to the agreement. And then, where is that execution of something which is not at all there on paper?
Conduct. May I please show?
Not the conduct, how the court had ordered for execution. Where is that order?
I will. May I please ask your lordships to just go to page number 93 of that petition?
Hmm.
Page number 93 is the petition filed by the mother in the US.
Hmm. Anyway, that will not go.
Yes.
What is the execution of this order?
So now after the compromise is done, the 4 children are there. 1 year they come here, 1 year I go there. Now in 2024 January, there is a change of circumstances. The change of circumstances is that my eldest child, who's a boy, eldest child leaves America and comes to India and starts living with me. He is about 15 years of age at that time. Now he's about 16 years of age. Now this is necessitated because he has some grievances about the step parent. So I travel to America. I have a discussion with the mother, and further to the discussion with the mother, the eldest child comes to India. Now there is a material change in that compromise that we have recorded before the court. Earlier, it was all 4 kids with the mother. I'm here. I will get access to them. If I cannot travel to America, I will let her know.
Understand that.
Yes.
What is the execution you wanted?
So now, prior to the execution being filed, in fact, 6 months prior, I had evinced in 2023, I had traveled to America, I exercised my summer vacation. At that time, I evinced to the children and to the mother that the next year they would travel to India. This is agreed upon. In furtherance of it, I booked the tickets. I booked tickets for the 4 children to travel to India. January 2024, my son comes with me. In June 2024, my lord, I arranged for a caretaker to travel to America. This is all with the consent of the mother. She asks me for the dates. I give her the dates. 28th of June, they're supposed to travel to Bangalore. 15th of August, they're supposed to go back. On the 28th of June, on the day of the departure, she reneges and says, I will not send the children. She takes recourse to law in America. She obtains an interim order there in New York, granting her interim custody of the children and granting me supervised visitation only in America. Now, at this point in time, though I may wish to spend that time with my children, I also have to take care of my eldest son who is here, who's admittedly got certain learning disabilities. So I am now precluded from traveling over there. I have made arrangements for 3 children to travel here. I've paid for a caretaker also to go. So that is what I initially sought to execute.
No. What is not, there should be an order to be executed.
Yes.
You cannot seek execution of arrangement, conduct. No. What is executable is a order or a decree or a compromise. As per the compromise, there are no terms that the children have to come to India. Whatever, if she accepts, you accept, that is between you. There cannot be any execution of understanding.
I mean, I would venture to say that the clause says if I cannot travel to America,
She will not come. That's not it.
no, it
Show
says
to the
I
court.
shall inform her a month in advance, so for her to make alternate arrangements.
Come, let's see that.
Please.
See that. At least make the court understand where it is.
I mean, sometimes when people make
Well, intimate
these,
this, what it says is, if you're not able to come, if you intimate them, they will make their own arrangements to go somewhere. That's what it means.
arrangements mean, I mean, it's regarding
What
my
it says
custodial
is, no,
rights.
read it.
Yes.
The children shall spend their entire part of the school vacation with a
Yes.
response. In the
Yes.
event the respondent is unable to travel to the USA,
Yes.
to have the children's interim custody for any part of their vacations, he shall
Yes.
intimate the same to the petitioner at
Yes.
least 1 month prior to the commencement of the vacation to enable the petitioner to make alternative arrangements is not to come to India.
Yes.
Alternative arrangement is so that it's a holiday time, they will make some other arrangements for their vacation.
I
So,
would-
now where is the order of the court to execute?
My apologies to interrupt, my learned friend. I may kindly request clause D on the same page.
Yes.
Kindly be read for us. Because my learned friend is reading.
I've seen that, I've seen that.
Cannot be read in isolation. Please.
Yes, yes, I've seen that. So now what is the order?
My lord,
Order impugn.
In order impugned starts at page number 63. The portion, more specifically the one under challenge before this honorable court, is at page number 64. Ma'am. Your ladyship may kindly, if I may kindly invite your ladyship's attention at paragraph 3 at page.
So we'll see the order from the beginning.
Please. It starts at 63 from before.
No,
the
before
parties.
that, what are this advocate, what is that recorded? Let's see, this
This is the appearances and the
advocate for DHR, so and so.
appearance in section 13 application, which is the filed before the honorable family.
Hence, JDR is directed. The letter addressed by the JDR to the DHR through her email shows that she is not ready and willing to comply the terms of the settlement arrived between them in miscellaneous number 67. Hence, JDR is hereby directed to act upon the terms of settlement arrived between them. So and so by sending the child, what is this order? Who passed this?
So, honorable family court. Ladyship, the impugned order goes further after the due dates. Assigned after 4 days.
How is she able to read something which is not there on the paper?
if I may, my lord, please.
Yes.
As far as the settlement was concerned, the settlement was arrived at when the parties were living in India. They had a certain understanding. Now that settlement, as far as visitation and custody, your lordships may agree that it is not set in stone. It provides a general marker beneath which we should not fall, but that should secure the custody and the welfare of the children. Now in 2021, after the relocation to America, the conduct of the party shows that the children traveled to India. And more pertinently today,
That's not law. That's not the law. Yes.
I agree with what your lordships are saying, but I ask your lordships to also consider this one fact, which was about the handover of one child who is now in my care and custody. Now, the oldest child's vacation.
Yes, if it gives, considering the welfare of the child,
Yes.
which keeps on changing,
Yes.
you have something else. Your remedy is not to file an execution on a compromise where the terms are not that. Execution, the executing court cannot go beyond the decree or the order. How can the court interpret something?
This was agreed upon between the parties, my lord. It was agreed upon between the
I
parties.
think you know what it is. Agreement between the parties is not the executable decree. What is decree is executed.
I agree.
If both of you are agreeing, agree and do what you want. The courts will not interfere. This kind of entertaining the petition itself is wrong by the court.
We are faced with a peculiar situation now where the
Peculiar
children.
situation, that's what I said. If it is a peculiar situation, it requires change or in the interest of the minor,
Yes.
your remedy is not executed. Execute something which is not there on the paper. Yes.
Just one submission on that.
following from the same intent which has been highlighted by the Honorable Court. If I may kindly invite your ladyship's attention on page number 124, where the prayers of the execution petition. itself are
120?
mentioned. Page number 124 of the petition.
Precisely, that is what I wanted to see.
And
124? Oh, this is attachment and sale of immovables.
Prayer number prayer number M, really, at the bottom of the page, to direct the judgment letter so and so to be present along with the minor children before the Honorable Court and direct handover of the custody. My first and foremost at the outset ground on the maintainability of this execution petition is this prayer itself, which has been taken into the consideration in the order which your ladyship just read right now, and in the impugned order. Impugned order straight away, without even going to the merits of the terms of the compromise decree, directs me to send 3 children who are there in USA, as well as tells me to comply with those terms. To what terms, which particular clause of that particular compromise decree, nothing it mentions further. The second point on that, the sub point which further comes for the consideration of this honorable court, your ladyship, is the second which this honorable court rightly pointed out, the welfare of the children. Now, all the subjects which are standing before this honorable court, except of course excluding me and my learned friend here, all are US citizens. None of them is an Indian citizen as on date. Neither the husband nor the mother. All the 4 children are US citizens as of now. Some are naturalized, some are by birth. 2 are by birth and 2 are naturalized citizens. For exercising a jurisdiction by the learned family court who has already transferred all the petition and hand over the custody of the children way before in 2019 with the compromise decree.
No, in the execution, court issues an injunction.
No.
Where is
I file a miscellaneous.
Yes,
I file a miscellaneous. So what happens is 28th of June, the tickets are booked for the children to travel here. I'm
So
informed.
miscellaneous is filed in which case?
I filed a miscellaneous before the family court. A second miscellaneous.
MC petition.
Yes, a second miscellaneous arising out of the MC. And your lordship remembers that the first MC, I'm joint custodian, joint guardian. I have equal time with the
Can you,
children.
as far as that order of the family court is concerned, no, that's not before this court. We'll not go into it. This execution itself is not maintainable. I will allow their petition by dismissing your execution petition.
May I try to convince or persuade your lordships that at the end of the day, I am the joint legal guardian and custodian of the child. That has not been modified.
What is that I'm going to observe in this is, you are seeking execution. Execution of what? Is execution of a compromise that is arrived at between the parties.
Yes.
That compromise do not say that the children have to come to India. When there is no such clause, where is the execution, where is the violation? You are only pointing out at she not coming to India or she not sending the children to India. That's not part of the compromise. So for that reason, and for this present along with the minor children before this court, that execution the court cannot do. And I'll also make it clear that if there are any changed circumstances and you want the welfare of the child is at stake, any appropriate remedies that are available to you, you can have it, but not execution.
May I attempt to persuade your lordships that at the time that I entered into this compromise, it states very clearly that this agreement shall remain in effect until it is modified. There is a clause to that effect, that the compromise
Then you
miscellaneous.
Seek for modification of it.
Indeed, I have indeed sought for modification. The
That's what. Let's not expand the scope of the writ petition.
I will appeal to your lordships only to this extent. I have one child with me. His vacations
I'll
are.
tell you, there is a procedure, there is a place for agitating the issues. Now, what is before this court is this. This order that's passed by the court it's contrary to law. And the judge has not even appreciated what is there on the paper. This is passed on 19/4/25.
Yes. So previously in the last summer holiday, which was in 2024.
This order and this order and also 1 minute. This is page number 58 order. And where is the compromise?
Compromise starts at 83 onwards.
83. This compromise, both take its rocks, and now at 4:45 I'm going to the family court. Give it to me. The mother is before this court, agreed with orders passed in execution number 181 of 2024 dated 19/4/2025 by the third additional principal judge, Family Court, Bangalore. The father and the mother have entered into both of them have entered into a compromise and initially into a compromise, and thereafter a modification, the said compromise is modified. That compromise, as per the said compromise, uh, 83, page number 84, clause A, B, C, D to clause A to D are relevant for the purpose of this petition. Extract that clause. It is the case of the father that, as per the terms of the compromise, in the year 2022, the father has traveled to US.
2022, the children came to India.
Children came to India. 2023, the father has traveled to the US. And in 2024, though he has made arrangements for travel, they have not come. And in fact, in between, as the mother remarried, the elder son was not comfortable and he came to India and staying along with the father.
India.
It is a submission. It is the case of the father that as the parties, like 1 year he has gone, 1 year they have come. They have come. The mother now has failed to comply and she has not come to travel to India, nor she has sent the children. The mother, having obtained, having entered into a compromise, has filed a petition in the US and sought and had sought for custody, exclusive custody of the children, and also had obtained an interim order, whereby what is the order? What is the order? US court?
The interim order was for sole custody.
Huh? What it says?
Granted primary residence of the minor to proceeding to wit Rudra Rakha, born on so and so, and supervise visitation with the minor child to the respondent.
The mother is granted priority. What is that? Primary. Primary residence of the minor children. And the father has a supervised visitation with the minor children in the USA. It is then the court, by order and then the respondent mother has raised objection with regard to the maintainability, because there is no order by the court, as per the compromise, that the mother has to send the children to India. As such, this execution is not maintainable. After hearing both the parties, the court has passed the order whereby the court observes that in miscellaneous number 67 of 2020, the mother was restrained by order dated 12/7/2024 from pursuing the case filed before the Family Court of the State of New York. The execution petition is filed under Order 21/11 of the CPC for the execution of the terms of settlement arrived between the parties in miscellaneous number 67 of 220, which is a compromise terms arrived between the parties by modifying their own terms of settlement in FC number 51668 of 2018. Hence, the JDR, that is the mother, is directed to comply the terms of the compromise arrived between them in miscellaneous number 67 of 2020 and to report compliance by 5/7/2020. Then directed the matter to be called along with miscellaneous number 76 of 2024 by 5/7/2025. The next paragraph. When counsel appearing for the petitioner submits that, petitioner mother submits that the court had passed this order, had exceeded the jurisdiction conferred on the executing court, it is submitted that there is no such direction, there is no such term in the compromise decree that the children will come to India. It is submitted that considering the welfare of the child, the, the mother had to file a petition in the US. The court, without even looking at the compromise petition and the compromise that is entered into between the parties, had directed the petitioner mother to comply with the compromise decree, wherein the relief that is sought by the father is to get the three children to India. Next one. Land counsel appearing for the respondent father submits that now one child is with him, the other three children are in the US. It is very difficult for him to travel leaving this child who is having some difficulties. It is submitted that the the conduct of the parties shows that it is agreed between the parties that 1 year they will come and 1 year the children will come and 1 year the father will be going. But contrary to that, she has failed to send the children. Now he cannot travel as one child is already with him. It is submitted that considering all this, the court had rightly passed an order and no interference is called for. Anything
May I
else?
also? Clause F of the settlement agreement.
Clause F also you extract.
Clause F, my lord, talks about the fact that I may have the
In the event
opportunity.
respondent relocating to Massachusetts, the agree
That's
to
D,
revert
my
the
lord.
joint physical custody and the children will leave each parent for 3.5 days or 1 week, which shall actually be decided. That is
F,
also there.
that's E, my lord. That's E. The next one, my lord.
Given the nature of the respondent's vacation,
Yes.
he has an opportunity of traveling to various parts of the world
Yes.
for varied experiences, which should be beneficial to any or all of the children. The petitioner and the respondent agree that the respondent shall have the right to take any of all the children
Yes.
on such trips.
Yes.
So what? It
My
is
lord-
not that, then go and take them to, get them to India.
As a matter of fact.
If she were to
Then-
permit, I'll be
no,
happy to
F-
travel.
F also you extract in the terms.
I will be
There's a
happy to
habeas
travel to
corpus.
America to bring them here because my father is here. I mean, grandparents' rights also.
Let the heard the land councils on councils on either side produce some material on record.
There's a habeas corpus petition which is pending. That number may kindly be recorded and that fact has to come.
Huh?
PPHC 55.
Who filed the habeas corpus petition?
They filed a habeas corpus
Petitioner before this honorable court has filed against the respondent.
to try to get custody of the older child
That
back
is, how
over
is
there.
it concerned with this execution?
On the same paragraph, what your ladyship indicated, for the eldest son had been retained in India without the prior permission of any of the parents.
That is a contested
Fact
fact.
may kindly be recorded.
It is
Contest-
submitted that, it is submitted with the land council for the petitioner mother that the boy is with the father without that, as he has been in the custody. Now is with the father as such. She has filed an application, filed a writ petition of a habeas corpus writ petition, which is pending consideration before the division bench. Next, heard the councils on either side, there is a material on record. There is in undisputed facts in this case are the parties have entered into a compromise. A compromise petition is filed. Thereafter, a modification petition is filed. This court in the preceding paragraphs, what are the terms of the compromise are recorded. Then when it comes to the execution petition, in the execution petition, what is sought by the father is that the page number is to direct the judgment debtor to be present along with the minor children before the court and direct handover of the custody to the decree holder. When an execution petition that is filed is seeking execution of a compromise decree that is entered into between the parties. To file a petition seeking execution, first of all, it is the burden of the decree holder to say what is the violation of the judgment and decree that is sought to be executed. Nowhere he says what is the as per the submission of the land council for the father, the violation is as per the agreement, as per the understanding between the parties, which is not part of the decree. The mother has come once to India and the father has gone the next year. So the third time the mother has to come. This court is not able to appreciate.
That is not my submission, ma'am.
Hmm?
That is not my submission.
You said
It is
so.
not that I'm saying, both of us have agreed.
Both, that's what I'm
Both
saying.
of us
Your
have agreed.
submission is,
Yes.
you went once, she came and you both, it's
And the
your
next year, we
understanding.
both
That's what-
agreed. I have it on record that she has agreed. And lastly, the
Even that
violation,
agreement is also not executable, as you know.
the violation that I'm contending is that there is an undertaking that the children will spend their entire vacations with me. Now, for 2 years, they have not
No,
spent
no,
with
no,
me.
you don't go again to that. I
2
understood
years,
the
my lord.
argument. Yes.
2
the-
years in a child's minority, they don't see the father for 2 years.
What did you write? Parties and travel, and later, as she failed to do so, he has filed this execution. Whatever of the submission and the application that is filed is beyond the scope of the execution. The family court, without even appreciating what are the terms of the agreement, what are the terms of the mutual consent, the decree that's passed by the court, without even looking into anything, just like that, passed an order directing the mother to comply with the order. It is settled law that the executing court cannot go beyond the decree. Now, these kind of private understandings between the parties are not executable. Even that aspect, the court has not even gone into, and entertaining this kind of an execution without any basis is most unwarranted. Accordingly, the objection with regard to the maintainability of this execution raised by filed by the mother is allowed. If the father has any grievance, or that the welfare of the minor or the welfare of the children is at stake, and under the law he is permitted to file any application in that regard, he is always at liberty to file, but he cannot seek execution of something which is not there on, which is not, which is there is no order to the effect. In view of the same, the appeal is, the petition is allowed
Great.
Cell number 51.
by this, call the password.
Passover matters. Cell number 3, Passover.
Yes. No password. How many times, what is this? Morning Passover, afternoon. Compromise will not be from one side. Compromise will be with the. He says, last occasion, please understand, Mr. Counsel, last occasion also when the matter came up, the same submission he made, he denied. Considering that, I said today morning, very same submission. Then Passover, again another Passover.
Runner, even though matter is compromised in case, he cannot avoid paying maintenance to the client. Wife, she is suffering from 2 years.
Ask him to come, call the matter immediately after he comes, or else end of the list, I'll take up and I'll decide the matter today.
Yes, ma'am. Yes, ma'am.
Cell number 42. 42. Passover 42.
Take it.
Kiran Michael Perez.
Who's that? Morning, the council sought for a Passover. Afternoon, when the matter is called, no representation. List this matter for dismissal tomorrow. Yes, next.
Serial number, continuation of the list, serial number 51. 51. Yamkaraju.
How much is, and the wife is seeking enhancement?
Yes.
Yes, let's see. Where is order? 70? How much is about it? 25,000. To the wife? Child. Huh? So what is the salary of the husband? What is the salary of the wife? Then why the court has rejected her case?
She owns 51 acres of land and she has a 2,000 square meter, 5 sites, my lords. And,
On her name?
yes, everything on her name itself. She has her own building in Sanjay Nagar, 51 acres, 2,000 square meter, 5 sites.
You file your statement of assets and liabilities? As per that, what are you doing?
Yes, I have a small restaurant here.
Mm.
After partners also. Within which I have to maintain.
You file your income tax returns?
No. I have filed before the trial court.
Not here, I'm asking before the trial court.
There I have filed.
They also support that they also say that you're earning 50,000 per month, even as per the income tax returns.
They disputed.
Not they, documents. Huh? What do you say?
They have not furnished their income tax returns. They have furnished is that the firm's income tax account is
Bank
personal.
statements, yes, fine.
My lord, no, that is also incomplete, my lord. Only one sheet of that particular year he had furnished. Unfortunately, I'm not carrying it, but he had not produced this one.
What is his income?
No, he is owning, as on the date when we filed assets and liabilities, I had a knowledge that he is only having one restaurant, non-vegetarian restaurant, which is running in the posh locality of RMV second stage in 80 feet road. Subsequently, I have also learned that he has another restaurant in the Jakkur. It's a non-vegetarian restaurant. Apart from that, one vegetarian restaurant in Rajaji Nagar. Now, my submission to your lordship is, his turnover in each restaurant is about 2 crores. His turnover. Now, he has not produced the income tax returns of the firm and his individual income tax returns before this on.
Have you please put all these facts in the form of an affidavit?
In assets and liabilities, at that time, what I had knowledge is about 40 lakhs of his income.
No. Whatever you are saying,
Yes.
in the form of an affidavit and file before the court, we'll ask them to respond.
Definitely. Can I point? Now, ex parte order was granted to him to pay 10,000 per month. He did not comply that. After a year,
We will decide it.
Please.
Then counts for the respondent file submits that the husband has having 2 crores, minimum 2 crores per annum. Income from one restaurant is 2 crores.
Turnover of the.
His turnover is 2 crores per annum, and he has suppressed several factors and filed his statement of assets and liabilities. They will be liabilities. The same is denied with the land counts for the petitioner, then counts for the respondent, and then the respondent shall file, shall state all these facts in the form of an affidavit, so that the petitioner will get an opportunity to respond to the same. When can you file?
In 1 week's time.
This is a matter on
Next Tuesday.
12th of August.
Highly obliged.
Yes, next.
Grateful.
51.1 may be directed to take notice.
In 51.1, Mr. Kemperazu is directed to take notice, and the counsel for the petitioner shall serve the copy of the
That is
petition.
selected 50.
That's what I'm saying.
Yes.
To asking him to take notice.
Yeah, I've served last date.
Already served?
Already.
GNWC, in GNWC petition, visitation rights is ordered to me in 2023. They're not showing me the child from last 2 years.
First of all, we'll decide this.
Yes, ma'am.
Yes.
For admission, serial number 52, Kalpana PB for petitioner, B Pradeep. Appellant, Pradeep.
It's a quick case for remand, my lord. My lord, it's a claim petition filed by the petitioner, the
Where is
legal heirs
Pradeep?
of the deceased, my lord.
What is happening? Insurance
Claim
counsels are not to be seen in the court. The
Now
other day also, all the matters are
Now
listed.
6 courts are there, madam.
So tell the Chief Justice that he should be given to one court. Take all that matters to one court.
At least
Wherever
2,
the
3
cases
courts.
are posting, we are not getting any. But it is posted and we have to appear. That is the another problem we are facing.
It is
Yes.
from one end to another end, my lord. That's another issue also.
Yeah.
My lord, it is a case of death, my lord. Death of a husband. Wife and children are the
Why it should be
claimants.
remanded?
My lord, page number 22, my lord.
No, why can't it be decided?
My lord,
That claim petition is dismissed.
dismissed on
Implication of insured vehicle.
Uh-huh.
Implication of the vehicle.
When is the accident?
2016 is there.
No, date. Let's read
12/1,
let's
2000.
read that particular paragraph where it
My lord,
refers
page
to
number.
the accident. The
My
way
lord,
of
the
the,
accident is admitted. The court holds it affirmative that the deceased died due to the accident involvement of tractor. But as there is a discrepancy between the FIR and the charge sheet, the court
come
comes
to that paragraph.
Yes, my lord. Paragraph
17.
number 22, my lord.
17.
22.
22 onwards. As noted above, page number.
No, Mr. Shivanagowda,
From
there are no
17
matters.
onwards it is.
There 2023, there are no matters of your Sriram General Insurance.
It is.
How many are there?
That we will check it out.
They can give a list.
That I will.
One day, on Thursday, I will take
I
up
have
next Thursday.
instructed some of the petitioner advocate also to search those cases and furnish to us. We will
No,
dispose,
whatever.
get it disposed
No,
of those.
whatever your officer says, if you give the list next Thursday, every Thursday, I will take up insurance matters.
Definitely.
So we can dispose of those matters on Thursday.
That's
By
what-
Thursday, prepare the list next Thursday.
Next Thursday, definitely we have.
Yes,
My lord, paragraph number 22, my lord.
yes.
As noted above, PW1 is not an eyewitness to the alleged accident.
Who is PW1?
By the wife, my lord.
Wife.
Though the respondent number 2 has denied the involvement of the offending vehicle in the case, the petitioner has not examined at least the eyewitness who
What is
witnessed the
this
accident.
finding? If the respondent is denying, he should only prove that.
I should prove the accident. My lord, it has so happened that the tractor was involved in the accident, my lord. In FIR, it was a new tractor. Hence, there was no number as such on the tractor.
1 minute. Accident had taken place on what date? Give the dates. Dates are important here.
11,
My
12.
My lord, accident.
12/1/2011.
11, my lord.
12/1/2011. What is the time?
The time is at night, my lord.
Time was not mentioned in the judgment. He was proceeding in a motorcycle.
1 PM, my lord.
1 p.m.
Yes, my lord.
1 p.m. or a.m.?
No, no.
PM.
PM.
According to them, it is PM. 1 PM.
1 p.m. No,
My
when
lord.
the FIR is registered?
FIR is registered on the same day, my lord.
Time
Yes,
is
my lord, yes,
important. When is it?
My lord, the occurrence of accident is 12/1/2011 at 13 hours.
That is one of them.
That is
1
one.
p.m.
And information received on 18 hours, 12/1/2011 at 18 hours.
18 hours means 6 o'clock.
6 o'clock.
6 p.m.
Yes, my lord.
Hmm.
In the FIR, my lord, the tractor, Mahindra tractor, the chassis number and the engine number is written.
Hmm.
P1275.
Hmm.
Whereas, my lord, while while filing the charge sheet, the chassis number is written as Mahindra D1275, but the engine number is written as NLW 182.
So now the discrepancy is on the engine.
Yes,
Chassis
ma'am.
number is one and the same.
Chassis, this
Let's
make,
see no, please come to the finding.
make
I
number
understood,
is correct.
Come to the finding. 21. Paragraph.
Twenty-two, my lord.
No, it says the petitioners could have examined the investigating officer who filed the charge sheet against offending a vehicle,
Yes,
which
ma'am.
is not the vehicle mentioned in the first information
Correct.
report.
That is the case. Crux of the
FIR is filed against which vehicle?
It is
What is
filed
the number?
against
It has a number.
tractor trailer. There was no number as such. Number plate was not there because it was a
No,
new
on
vehicle.
what basis the court is saying that it is a different vehicle?
Yes, my lord.
Basing on the chassis and engine number, the vehicle was, according to them, vehicle was seized and it is in the police station. But chassis was filed in a different. If that is the chassis registered vehicle for the vehicle involved in the chassis as the chassis number was not placed defined in before in the chassis. What they say that wrongly they have given the track. Now they are saying that according to them, immediately after the accident, they have lodged the
Now
complaint against the.
Now, if this order is set aside and the matter is remanded, how will you prove it?
My lord, there are two things, my lord. In FIR,
Accident
whatever
has
the
happened in
chassis.
the year 2011.
Yes, my lord.
We are in 25.
No
Yes, my
polystat.
lord.
What
It
you
has-
will prove?
It has so happened, my lord, the codes got changed and it got renumbered and
Let's
all that
accept all
happened.
that. Let's accept all that.
Yes,
Now
ma'am.
I will set aside this order and remand.
Yes,
How
ma'am.
will you prove? Where is the vehicle? Where is the number? Where are the records? 2011.
Records.
You can't.
It is not.
You cannot. It's a futile exercise doing it. Which year is this appeal?
Appeal is 23 only, 24, ma'am.
You know, when is the order passed?
The order passed in 2020, 22, my lord.
MBC of 2014 is disposed of in 2022.
22.
Why this much delay?
My lord,
2014, almost 8 years.
yes, my lord.
Not examined.
Hmm?
Not adduce the evidence.
We will adduce the, I mean, it has so happened.
Purpose, I'm telling you, like court has nothing. I can remand, but there is no purpose. You just tell one good reason why if the matter is remanded, what will you do? The evidence, what they're saying, you cannot adduce. In the year 2025 of an accident of 2011, where will you examine the investigating officer? What will you do? Whose purpose would be served? Then what happened that personal accident coverage, whatever that is there to your vehicle, you might get it, nothing else.
My lord, then I will go on to the merits of the matter itself, my lord. My lord, I think the LCR is before, LCR is before this court. If I can.
What merits? This is only the merits. Unless and until the accident is proved, nothing else, nothing can be
That's what,
done.
my lord, I may be given an because since it was a death
If
case
it is,
and you know.
if it is
the-
a case and there is a scope for any
Please, I can
compensation.
examine the eyewitness, my lord, who has. My lord, admittedly, my lord, it was a new vehicle. It did not had the vehicle number, my lord. The number plate was not there. So hence, the Mahindra tractor
Whom you
D1.
have examined?
My lord,
You
I have
examined the
only
wife.
examined the wife. my
Wife is not an eyewitness.
Yes.
Now, to prove that, either you have to examine the eyewitness, you have to examine the investigating officer to clear this discrepancy.
Yes, my lord.
That you cannot do now by sending the matter. Without doing
My
it,
lord, I can do. I mean, the investigator officer can.
what he will remember 2011 and 25?
Seeing the records, my lord, and he can always say how this vehicle came to be.
What do you say,
After
Mr. Srinagoda?
investigation, how this vehicle came to be.
The documents in order to decide the case, all the documents are in order in the court. According to that, the vehicle number, which is mentioned in chassis and engine number, which is mentioned in the FIR and seized by the police, is not the vehicle chassis. What else it is required to adjudicate the matter, Malad?
And the investigation officer has to say how that
How will he
chassis
say?
number.
How will he say? You have to call him and ask
Yes,
him.
my lord.
You didn't. Now, what will he say now? He will remember what has happened in 2011. Whether he is alive or not, also you don't know. Please come.
Definitely, my lord, he may, my lord.
No remand.
I will take a.
No remand.
I will
It's
take a
just waste
chance,
of-
my lord.
It's just waste. No
Since
chance.
it's a case of
Agreed
death,
with the
my
order.
lord.
I know, but you cannot do it. Agreed
My
with the
lord,
orders
my lord,
passed.
otherwise also, my lord, kindly look into, only 2 points I'll mention, my lord. Kindly look into the FIR, my lord. It is Mahindra tractor D1 275. Even in the charge sheet also, it is the same make. It is the same number, my lord.
Where do you get that?
That is a charge sheet.
No, it must have been recorded in the order.
Exhibit P4, my lord. Yes, my lord, it is recorded in
Where
the
is
order
that?
also.
From the order, you please point out.
Yes, my. My lord, page number 20, my lord.
20, yes. 20 are all judgments. Are you referring to the internal pages?
My lord,
The running page?
Judgment page number 20. my lord.
Yes.
In that, my lord,
Yeah, read paragraph
the learned
19.
counsel for the respondent.
No, read from the paragraph top.
Yes, ma'am. The respondent number 2 has categorically denied in a statement of objection that the offending vehicle has not been involved in the case, and it is a defense of the respondent number 2 that offending vehicle was implanted in the subsequent to the accident. The learned counsel for the respondent number 2 during his argument pointed out that the FIR statement exhibit P2, it was stated that there was no number plate to the tractor. So Mahindra D1 275 vehicle bearing number, chassis number so-and-so, engine number so-and-so was involved in the accident. None of the witnesses who have given the statements before the police have given the tractor number. However, after lapse of 12 days, it has been implemented. Implanted. The IMV report exhibit P5 at first time the registration of the offending vehicle as well as the chassis number were mentioned. So if P5 is the IMV report, my lord. IMV report it is mentioned. Even in charge sheet also it is mentioned D175. Kindly peruse the charge sheet exhibit P4, my lord. So this being the fact, my lord, the tractor as such is there.
Who is the owner of the tractor? Now if these numbers change, owners will also change.
Not only that, my lord, when the vehicle was immediately after the accident, after 6 hours or one day, the vehicle was seized by the police. It was in the custody of the police. If that being the case, man, how the registration number will become to them?
No, the
To
registration.
the police.
Then what is the number of that vehicle which is there in the?
Unregistered vehicle. It is only a temporary registration. But the police have filed the charge sheet against to the registered vehicle. When his custody, the vehicle was there. Without production of that vehicle registration, how the registration will be given, my lord?
No, the registration was done, but only that number plate was not reflected in the vehicle.
Oh.
So the
vehicle is in the custody of the police.
Yes, my lord. So
And
they filed the
have
charge sheet.
Yes. So they have registered a complaint, not against that vehicle, but against some other vehicle.
No, the same vehicle. Same vehicle, my lord. Mahindra D1 270.
Every tractor, everything of a particular company, because if it says number so and so, will not be the same vehicle. All Mahindra tractors, wherever they are found, they are not the offending vehicles.
My lord, if that is not so, if there is a discrepancy, then I should be allowed to go against this vehicle.
That is who stopped you from doing it?
My lord, that is why I let
You
the
should have
matter.
done it that time. When you know a particular vehicle is seized and they have to file a charge sheet against the vehicle that is seized, which is lying with them. And because for some reason they gave some other number and you kept quiet. That mistake, you can't change it now.
My lord, at least if the matter, that is why, my lord, if the matter is remanded back, then at least I can implead them, and this is a death case, my lord.
If you feel that you can do, you please do. Agreed with the orders passed in MBC number 235 of 2015 dated 23rd September 2022, whereby the court had dismissed the claim petition. As the offending vehicle, as a vehicle is implicated in this case, the claimant is before this court. In this case, the husband of the claimant had died in the accident. The claim petition is filed seeking compensation of an amount of rupees. How much is claimed? Seeking compensation. The ground on which this petition is dismissed is that the vehicle which is seized by the police in the accident, immediately after the accident, and the case again, the vehicle against which the charge sheet is filed, they are two different vehicles. The court has observed that the claimant ought to
10
have
lakh.
examined.
10 lakh.
10 lakh. The court has observed that the claimant ought to have examined the investigating officer or the high witness in support of their case. The court has observed that except examining PW1, who is the wife of the deceased and who is not an eyewitness, he has not taken any other, the claimant has not taken any other steps to prove the accident in the light of the fact that the charge sheeted vehicle and the vehicle involved in the accident is not one and the same. Land counsel for the appellant submits that there is no dispute about the accident and involvement of a vehicle which is a new vehicle, which has a temporary registration. It is submitted that if not on this vehicle, They are entitled for compensation against the other vehicle which is involved in the accident. This is an accident that has taken place in the year 2011. That whatever the submission of the council, it should have been done long back when the matter is pending, not in 2024. It is a submission that if the matter is remanded, she'll be able to adduce the evidence. The court has
The
its own
court
doubts
determines the
about,
compensation also.
court has its own doubts about how the claimant will be able to substantiate its case by producing the evidence. However, considering the fact that this is a case of death, the order impugned dated 23rd September 2022 in so and so is set aside and the matter is remanded to the court for fresh consideration. The registry is directed to send the entire record along with the copy of the order. Yes,
All of the contentions kept.
that's what it is.
Yes.
Yes,
Case number 53. 53 urgent, 54.
yes, 54. Give it.
IS Pramod Chandra.
No representation. This is a matter for dismissal on 6th. Yes,
Number 55.
something mention is made in the morning about 55. Adjourn, next.
Number 56. Case
56.
number 56.
For petition, Lord.
Rudra Papi.
Yes.
Not, the order passed by the trial court is in Kannada document.
Is in Canada. It is submitted that the impugned order is in Canada. Land council shall file the translated copy of the same when? When?
3 weeks, my Lord, kindly.
This is a matter on 22nd.
Apply.
Case number 57 urgent, 58. Case number 58.
I pay for the petitioner, my lord.
Gowda.
Raised for adjournment for 2 weeks, my lord.
My lord, this is a 2023 matter. It has been served in.
At least for 3 days.
There is no representation on behalf of the respondent. Learned counsel is present. That is on 16/7.
In the last date.
Then, at the request of learned counsel, the respondent posts this matter on 16/7. So, how many times you will ask adjournment?
Your lordship, this is the first time regular counsel.
Who said this is first time? I'm reading from the order.
Lordship, I got the things today itself. Regular counsel mother is in some health issues. It seems henceforth he could not attend.
Matter on 5th, no further at the request of learned counsel, the respondent, no further adjournments will be granted.
Case number 69. KS Bhimaya for petitioner. Anand Muttalli for respondent.
No representation on behalf of both the parties. This is a matter for dismissal on 13th.
And also on the last
There
date
was
had
a-
passed a peremptory order indicating that if the petitioners do not make the payment, the interim order will stand vacated. They've still
Not
not
paid.
made any payment. The
We'll
arrears,
dismiss it.
No, actually, when the interim order was passed, I have paid, the amount has been paid. But from December onwards, he could not make the payment of 15,000 rupees per month. He has
How much
not-
how much of the arrears?
and, my lords,
2
towards the
lakhs has
arrears,
been paid and the monthly 15,000 was being paid from the
So like
date.
it's how many months?
only from April till December 2024, he has paid 15,000 per month.
That's what I'm
Out
saying.
of the
from December.
arrears, out of the arrears, he's paid 2 lakhs out of the 9 lakhs. So 7 lakhs from the arrears is still pending. And from December till now,
What is
1
the
lakh
order-
5,000.
What is the order of the court?
Ordered
At
directly
15,000 arrears. How much it
15,000
comes?
15,000 per month as well as 9 lakhs arrears ought to be paid.
Where is
That's
that
still,
order?
My lords, the first order is of,
First order.
yes, ma'am, 26th April 2020,
What it says?
26 March 2024.
Subject to the condition that the petitioner husband shall deposit an amount of rupees 2 lakhs. by
That I have
26
My lord,
deposited.
that subsequently, that he had deposited the 2 lakhs. Subsequently, my lords modified the
Where
2
is that
lakhs.
order?
2 lakhs to read as 9 lakhs. That my lordship had directed on 9/7/2025.
No, 2 lakhs had to be deposited and we
Yes.
have deposited.
It is only what you sought as a correction in the order.
Yes.
Yes,
Not an order that it should be 9
We have
lakhs to be paid.
deposited the 2 lakhs, my lord.
You
Then he
understand
started
that?
paying
That day,
15,000.
That day, you only sought for the correction in the number,
Yes.
not a direction.
My
So
lord.
the 2 lakhs is deposited
Yes,
or not
my lord.
deposited?
Yes, my lord, but if the 2 lakhs is to be read as 9 lakhs, then he ought to pay
I
the
never
entire.
said that it should be read.
My lord, even otherwise, he's not been paying the 15,000 on a monthly basis.
We have to go step by
Yes,
step.
Step by step.
Okay.
Yes.
So first is the clarification. I have clarified.
Yes.
To be vacated, interim order to be vacated, interim order is 2 lakh arrears,
Yes.
15,000 per month.
Yes.
According to them, till December they paid, according to you also, it paid. So what is the outstanding from December to now?
1,05,000.
1,05,000, when is he going to pay? Or else
My
I'll
lord,
dismiss the writ
he
petition
has
itself.
agreed to pay 25,000 per month. He is not able to pay it. That's the main problem. He says he will pay 25,000 per month.
Then if he's not able to pay as per the interim order, what is that we can
No,
do?
15,000 he is paying, my lord. He
Because
he
that
could not
arrears-
pay it because of, there was some problem in his,
So that 1 lakh, what he says is every month he'll pay 10 lakhs more.
10,000 extra and he will complete it. With that, he will definitely, he wants to pay 25,000 so that it will be, cover the whole thing.
Let him pay 30,000.
Yes, my lord. Your lordship may
Let him pay
make an order.
30,000 also. From this month, he'll continue to pay arrears. 15 is the monthly payment.
Yes, ma'am.
Another 15 he will pay.
Yes.
Not, but the arrears technically from the date of the application that has been filed.
But that, for the reason
Yes, ma'am.
why the court
Because
has
that is-
granted 2 lakh, it has its own reasons.
Yes.
That has to be decided on the merits of the matter. Please come. This court on 22/7/2025 has passed an order that if the interim, as per the interim order, if the amounts are not paid, the stay granted by this court will be vacated. Will be vacated on the day. Today, when the matter came up, Learned Counsel submits that. As per the order passed by this court, then amount to arrears, an amount of rupees 2 lakhs is already paid. But when it comes to 15,000, from the date of the order till December, they have paid. From December, due to some, his financial reasons, he could not pay. It is submitted that whatever the arrears from December to at present are concerned, every month, along with the 15,000 that is ordered by the court, he will be paying an extra
Another.
15,000 and he'll complete the arrears.
Yes.
List this matter next month. When is the date? 5th. List this matter on 7th. We'll see whether
September.
he'll come up with 30,000 or not.
This 7th of August, my lord. Okay.
List on 7th. Because that day you have to pay 30,000.
Yes, ma'am. I will see.
Yes, next. Yes, next.
61. Sir Chandrasekhar K. 61.
For the petition.
Ashok Patil.
Yes.
Last day I filed a memo for calculation. Respondent for verification.
The outstanding is there for the last 7-8 months, my lord.
How much? It comes to
10,000
how
per
much?
month, about 80,000 rupees.
Remaining 7 months balance is 70.
Tomorrow day after will be one more.
80,000 he is saying. Maybe, that may be 10 years.
Then
maybe
decide,
that-
that's
that-
it, whatever.
So what your client is going to do? It's an writ petition,
The
interlocutory
interim order,
application.
may not based on interim order, 20,000 was awarded all totally. 5 for the 2 children, 5 each, and 10,000 for the wife. Now, in school children's education, the school fees and all had to be paid. I had to borrow money from elsewhere to pay.
First of all, comply with impugned order, interim order, or else we have to, no other option but to dismiss the writ petition itself.
For 2 weeks time.
Yes, it will then counsel the
The date may be
respondent
fixed, but not by that
When
date. to
counsel
pay
for the
the
respondent
balance.
submits that an amount of rupees 80,000 is outstanding, the counsel for the petition seeks 2 weeks' time. This is matter on 20th of August. by 19th of August, if the arrears of 80,000 is not paid on the day, this court will not, on 18th, this court will not consider the matter on the merits and it will be dismissed alone on this ground.
Number 62.
Interim order earlier granted is extended. Yes, next.
Number 62.
Yes.
Harish Kumar Gowda.
For the petitioner, ma'am.
Who appears to the respondent? No representation for the respondent, counsel for the petition. Interim order is complied with?
No, my lord, interim order is it's a stay of further proceedings, my lord. I'm not challenging the maintenance, my lord.
What is this?
My lord, the respondent filed the application under 91 of the CRPC calling the call
No
records.
representation for the respondent, counsel for the petition is present. The interim order earlier granted is extended until further orders. This is the matter on 2nd September.
Till number 63. Vijay Kumar K for petitioner.
Since from
Reddy.
long 8 months, they have not paid interim maintenance. It comes around 56,000. There was a conditional
As per-
stay granted by
But
this.
as
honorable
per
court.
the instructions, my lord, of the petitioner, last only 3 months has not paid, remaining all rest of the
As per
amount
my
paid.
comes to how much? 3 months.
21,000, 7,000 means 24,000.
As per my instruction from client, madam, 56,000 is the arrears.
It's not 23,000. It is 21,000.
20, yes, if 7, as per the order, my lord, is to 7,021.
How much is the maintenance granted?
7,000, my lord.
15,000 per month, my lord, as granted by the trial court. My lord, husband is the working as a
This court,
garage.
this court made it 7,500.
7,500.
7,000. How much
Since from
according to
8
you?
months, my lord.
How much according to you?
56,000.
Huh?
56,000.
Land counsel for the respondent submits that there are arrears. The petition has failed to pay an amount of rupees
56,000.
6,000. According to the land counsel,
3
only
months.
3 months
Three
is,
months was-
3 months, only
We
3
will
months
clarify.
maintenance or in arrears. The counsel for the respondent shall file a calculation memo to the land counsel for the respondent within 2 days from today. And whatever is the admitted arrears shall be paid by 11th of August, or else the stay granted by this court stands vacated. This is
Already
the
it has
matter
been
on
vacated,
12th.
my lord.
Huh?
Already it has been vacated.
Vacated?
Yes.
No, it is there. It extended on 24/7. Yes.
Till number 64.
This is the matter on 12th. Yes.
Number 64. Venkat Reddy SK for petitioner. Raghavendra S for respondent.
Petitioner, my lords.
Yes.
This is the matter, my lords.
Hmm.
The petitioner is challenging the maintainability of the maintenance petition filed before the family court under the provisions of DB Act, my lords.
Hmm.
This lordship had heard me. Lordship can recollect. Initially, the respondent herein had filed a petition under the provisions of Family Courts Act, DB Act, and 125 of CRPC. We raised an objection regarding the maintainability, and the family court held, since 125 of CRPC is invoked, in view of the settled principle, family court can entertain the petition.
So whatever the provision of law they have quoted,
Yes.
the court can consider it under our provision 125 CRPC.
No, what happened further was subsequently that 125 came to be withdrawn by the petitioner, the respondent hearing.
Withdrawn. Because it is entertained.
In the first instance, when we raised the objection, family court held that this petition survives on the ground that since 125 of CRPC is invoked. Subsequently, petitioner withdraws 125 provision. And that is why I filed one more application.
Now the order is passed under the DVC Act.
Now the petition survives only on the provisions of Family Courts Act and the reliefs under DB Act. 125 is withdrawn. Now I have come before this honorable court because my IA seeking maintainability came to be rejected by the family court, and that I have assailed.
Where is that? We'll see that order.
Yes.
Every matter 10 times to be heard, every time it has to start from the beginning.
Yes, I understand. Madam.
That's the whole difficulty.
Yes.
Waste of
Ink
court's
page
time.
22, the impugned order starts. Madam.
22.
Ink page 22. And I have produced the petition at annexure B, ink page 31. Madam.
Yes, what do you say? How is it maintainable?
Yes, my lord. Last time, my lord raised this question, whether TV Act can be applied to the family courts. That was a simple question that my lord also
DV
asked.
Act applied to the family courts. If you're seeking the relief under DV Act, which is the court competent to deal with it? It's a magistrate court, but not the family court.
On that only, my lord, last time also I gave the case laws. Then my learned friend was online, so my lord did it.
Yes, where is that case law?
Please, my lord.
Let's see. You've given it, you've filed along with or?
Illa, my lord. I'm giving it now, my lord.
Yes,
Already
take
I've
it.
served the copy to this.
Take that, take that.
Please.
So before the family court, I mean, nothing is pending. You
Nothing.
gone to the family, no MC, nothing is
No,
pending.
no.
You went to the family court, you filed an application under 125 under the provisions of the DVC Act. Then you withdrew the petition under 125.
No, my lord.
No, that's what his order says.
My lord, I filed it under
Petition
section
filed a
7.
No, no, petition filed a memo seeking to withdraw, delete provision of section 125 CRPC on 3/4/2021, said application and allowed and ordered to delete section 125 of CRPC. So the present petition is only under section 7(1)(f) of the Family Court Act, read with section
Yes.
21D and 20C of the.
Yes.
So the substantive provision under which you're seeking maintenance is under the protection of women,
DV Act.
the DV Act.
No, my lords. No, my lord. That's what I'm going to make a submission. Page number 59, Lord,
Of your paper.
Of the paper,
Uh,
where the deletion came to be done on 4/9/2021, my lord. It's very long back. In the page number 58, last two lines, the learned counsel appearing for the petition has filed lengthy objections and has contended that if this petition in section 125 is deleted, then the petition does not survive for the same, liable to be dismissed. This was 2021. This is the contention taken by. In this case, Lord, it is filed under section 7, read with 20 subclause 1D and 20 subclause 3 and 26 of DV Act. And petitioner under 125 will be registered as criminal miscellaneous proceedings, but on going through the petition, it shows that it is only ancillary section incorporated along with Family Courts Act and Domestic Violence Act. The other objections raised by the respondent can be decided while hearing the matter on the merits of the case. At present,
to go to the family court for seeking a relief under Domestic Violence Act.
my lord, Family Courts Act has provisions.
So according to you, every person who requires a relief under the Domestic Violence Act, instead of going before the magistrate, they should come to the family court, invoke section 7(1)(f) and file a petition.
No, my lord, that is not permitted. The scheme of the law of DV Act is section 12 alone I can go to magistrate. Section 12 and 18 to 22 are totally different. Even the language of the law is also different, and the whatever that we seek before the court is also different. That is been held in these cases, my lord.
I'm asking why you shouldn't go to the magistrate court when you can straight away seek a relief from there.
My lords,
When there is a remedy available to you straight.
Here, my lord,
Why
here.
you want all this interpretation?
Yes, my
Because
lord.
your advocate is practicing in, your means your client's advocate is practicing in the family court. So anyhow, you will get that relief into the family courts. Generally,
Certainly
that's how
not,
it
my lord.
happens.
Certainly
If
not, my
you,
lord.
if you know your advocate friend is in civil court, it becomes a suit. If he's in high court, it becomes a writ petition.
I'm not.
Give that,
Not
give the judgments.
Lord, Family Court Act, my lord, why people approach
We'll
family
straight
court?
away look at the judgment.
Please,
then you
please,
can make
please,
submission.
please, my lord.
Yeah, this one, yes.
My lord, this is a case. It's a division bench matter, my lords. At page number 4, para 3, last 4 lines, which is confined in this case. The question to be addressed by this court is with regard to maintainability of the petition filed invoking the provisions of section 7 of the Family Courts Act. Can provisions of section 18, 19, 20 and 21 of DV Act be clubbed or not? This is the only question, Lord, that was raised, which is also my case. 7 read with DV provisions. Here is also case, rejection ke they filed an application. Then court framed the issue that this requires to be considered. My lord, the contentions raised by the husband in this case is para 4, my lord.
Yes.
On appearance, petitioner husband appeared and submitted on the application the provisions is referred to above for written petition on the ground that in case respondent wife is permitted to claim the relief as provided in the provisions of 18, 19, 20 and 21 of DV Act, the provisions of section 12 of DV Act would not only be rendered redundant, but the petition would also become not maintainable. It would create very incongruous position for the reason that the order passed under the Provisions Domestic Act is appealable before the trial court, whereas the leave granted under Section 7 of the Family Code is appealable before the dishonorable court. It was further contended that the relief is as sought for cannot be claimed in the first instance, but it can be added by way of amendment. This is also one of the contention taken, my lord. And the term magistrate, how it is defined as the DV Act is also been narrated in para 7, my lord. Para 8, my lord, two judgments which my learned friend has quoted in para 16 of the writ petition is being discussed here also. Para 8, my lord. That is Raju Narayan Swami and Neetu Singh. Lord, can we kindly see para 10 only, they have the discussion is on the language of section 12, 18, 19, 20, 21 is entirely different. Under section 18, 19, 20, 21, the destitute wife is entitled to claim independent reliefs in terms of protection, residence, monetary and custody orders. It goes like that, my lord. In this case, para 11, an amicus curiae was appointed, Mr. Ashok Kini. My lord, at page number 8, amicus curiae submits a report saying that section 26, page number 8, first line, my lord. Section 26 do not denude the family code from exercising jurisdiction in respect of relief as sought under section 18, 19, 20, 21 of the Act.
To para 13.
Please, my lord.
Para 13.
Yes, my lord. Yes. In para 13, their lordship referred to section 7 and para 14, section 12 of magistrate.
13 on perusal of the extracted reliefs. Read
Yes, my
it.
lord.
I'm
Yes,
saying read from there.
My lord. It would be evident that the petition is not confined to primarily relief under section 18, 19, 20, 21 of the Act, but also for realization of the amount due from the husband for the past maintenance, partition of the scheduled property, and various other reliefs. It would also be appropriate to extract the provisions of section 18. Then it goes with section 7, my lord, section 7 of the, which deals with jurisdiction. Subject to the other provisions of the Act, a family court shall have and exercise all the jurisdiction
This is a
exercisable.
far-fetched interpretation.
Please, my lord.
This is a far-fetched interpretation of section 7.
Yes, my
I'm
lord.
not,
Anyhow,
I'm
my lord,
not
section
even
12
like
is
that.
also done.
I'm not
Kindly
even
see
like that.
para 16, my lord.
Yes, I've seen the manner in which this judgment is going. Not that's not permissible.
No, my lord. Section, para 16 provides for doctrine of election. One thing, my lord. And, my lord, I have sought under section 7, subclause 1F, which provides for maintenance. And my prayer, my lord, is also a 20.
The whole purport of section 7 is altogether different. So that all the relief, all the whatever or the disputes between the parties to settle all that and come under the purview of the family court. That doesn't mean that what you quote a provision of the Domestic Violence Act and what is exclusively available to the court, to the party, because section 7 says all the reliefs between the parties. So I will file an application under section 7 invoking the provisions of the Domestic Violence Act. If that has to be interpreted, no one has to file any application before the magistrate. Everybody can come to this family court under 7.
Lord, I humbly submit, my lord. In fact, Bombay and other states, they are transferring magistrate cases to family courts. I have that judgment also. I will place it on record. Things are changing, my lord, because of Section 9 of Family Courts Act. My lord, Family Courts Act is not adversarial. It is inquisitorial per se, where it is a judge-driven, because we have to seek a permission to even to appear before the family court. The chances of settlement orientation, because it is internationally acclaimed. And 14, my lord, provides leniency towards the evidence collection. And 20, overriding effect. And 8 clearly prescribes that no other jurisdiction comes. And 7 subclause 2 provides for magistrate is defined. And the family court is also, judge is also a magistrate, comes under section subclause 7 subclause 2, my lord.
Family court judges or magistrates?
No, my lord. Yes, my lord. So 7 subclause 2 is also covered. I have the judgment on that also, my lord. I will place it on record, all the judgments.
You can place.
Please.
Yes.
Shall I make a synopsis and do it, my lord? All the judgments, because there are a couple of judgments.
Yes, you give your written arguments.
Please, my lord.
This is matter, nothing else to argue.
So-
You can give the written arguments. Heard, reserved, then counsel for the respondent submits that. He'll give with all the citations. He'll give the written arguments. When can you give? Give it to the court office.
Please.
Much obliged.
Within 2 days? Monday?
Wednesday, my lord.
Wednesday. Heard, reserved.
Much obliged.
Obliged.
Cell number 65. Tanuja for petitioner.
For petitioner, my lords.
Amaresh.
Yes. Yes.
My lords, this is a wife respondent petition, my lords. I filed application under section.
Seeking enhancement.
No, my lords. Under order 7 rule 11 AD, my lords, for rejection of the petition.
What is the petition filed?
Petition is filed under section 13(1)(1)A for cruelty, my lords. My lords, in the petition, normally, as my lords is well aware that only the petition amendments has to be seen if the petition has to be rejected or the plaint has to be
What is the order now? Rejected or not rejected?
rejected, dismissed.
Petition
The
is rejected.
the application is dismissed. Application is dismissed.
Your application for rejection is rejected.
Dismissed. Dismissed. Upon that, I have come before this honorable court. Only on the ground that the trial court observed that the trial is necessary for proving those contentions taken by the
Sir,
petitioner.
what are your contentions for rejection?
My lord, sir. My only contention is, my lord, sir, this respondent, she is a postgraduate working since from 2013 in Bangalore, and the marriage was held on 2/5/2018 with the respondent herein. And the respondent, before marriage only, he knows that she is a postgraduate.
Before hear your submissions,
Yes, ma'am.
please come to that IA for
Yes, ma'am.
rejection of the petition.
Yes, ma'am.
Page number.
My lords, my IA is at page number 33.
Let's see.
Shall I, ma'am?
Please read the affidavit.
My lord, sir, that for the reasons sworn to in the accompanying affidavit that this honorable court be pleased to reject the petition.
Come to the affidavit at page 34.
My lord?
Affidavit at 34.
Yes. Shall I read, my lord?
Read the affidavit, I said. At page
My
number
lord.
34.
Yeah, yes, ma'am. I am the respondent in the above petition. First and second para is, second para, from second para I'll go on, my lord. I submit that petitioner is my husband. He filed the case for divorce. The objections filed by me may be treated as part and parcel of this affidavit. I submit that the petitioner has filed the petition for dissolution of marriage under section 13(1)(1)A of Hindu
Is it
Marriage
for
Act.
rejection of plaint or you are filing an objection to the main petition?
No, my lords, this is for rejection of plaint.
Yes.
In para 4 of the petition, the petitioner has averred that.
Please come to that particular paragraph where the grounds are made out for rejection. This all looks like your objection for the main statement.
No, my lords, I have extracted the relevant paras.
Yes, is it a ground for rejection? All those things.
Yes, ma'am.
If she says something, is it a ground for rejection?
My lords, on the face of it, she is a graduate, postgraduate working in Bangalore, and thus respondent herein has contended that she is sadistic in character, which itself is the cruelty. And moreover, he wants to quit the job and he wants to reside along with them in a tiny village in his native. My lords, this itself is the cruelty, my lords. The one who comes with the court without.
I think this is an innovative ground for rejection of the petition. I've never seen like this.
My lords, I being accepting him as husband, and I filed my objections along with my counterclaim saying that I am willing to reside with them for restitution of conjugal rights.
Yes, please.
My lords, in para 17, it may be
I've
clearly.
seen, those are not the grounds. If the petition starts dismissing on this ground, no petition will survive. Agreed with orders passed in IA number 6 in MC number 4618 of 2021, dated 24 June 2024, whereby an application filed by the wife under Order 6 Rule 11A and D of the CPC.
7, my lords. Order 7 Rule
Order
11.
7 Rule 11A/D of CPC. The wife is before this court. The wife had filed this petition stating that.
Sorry, my lord, husband is filed a petition for divorce, my lord.
Husband has filed the petition stating that in the petition, he has referred her as sadistic tendencies and used to call her sadistic, which amounts to cruelty, and which show his attitude towards her. Further, the allegation of the husband that she frequently visited her brother's house situated near their house, she refused to cohabit with him and to have child, and she also refused to quit the job, does not amount to cruelty. It is an inseparable part of liberty of a woman to have reproductive choice, and she cannot be forced to give birth to a child. She, being the postgraduate in MTech, has been working as assistant professor in RR Institute of Technologies, Bangalore. Continuing her job also does not amount to cruelty. It is a case that they were residing in a separate rented house as agreed prior to the marriage, and the husband, without her knowledge,
Has vacated the premises, my lords, rental house.
without her knowledge and consent, vacated the rented house and shifted all the household things to his native place, including her educational certificates, clothes, jewels, and started insisting her to leave the job and to stay in his native place, which is nothing but short of cruelty. So the petition is, the husband's petition is manifestly vexatious and without merit. Since the petition does not disclose the cause of action to seek decree of divorce on the ground of cruelty, the husband, being wrongdoer who has subjected her to cruelty, is debarred from entitling the relief of divorce. Hence, it is prayed to dismiss the petition by allowing I number 6.
My lords, one submission, my lords. According to section 23(1) subclause A, it is very clear of the Intermarriage Act that one who comes to the court, shall I read, my lords?
I think that is not all. This petition has to be dismissed with cause for wasting the court's time.
I would like to make one submission, my lord.
Yes.
Based on this, there is a stage for cross-examination since from almost 3 years pending
There is
before
no
the trial
stay,
court.
my
my
lords.
lord.
I am cross-examining.
3 years,
the
my lord.
witness.
Order sheet, I'm ready to produce before this court, my lord.
Then
He is suffering.
We'll impose cause.
Please, my lord.
My lords,
We'll impose cause on this petition.
no, my lords, I am
Where
postgraduate
are the-
working.
no, no,
See,
no, where
my
are
lords,
the-
it is for cross-examination tomorrow.
Matter.
I am
This is-
cross-examination. I am cross-examining the
One
witness, my
minute.
lords.
One
And
minute. This is matter tomorrow. By tomorrow, then council shall place tomorrow or day after.
I have a copy of the certificate
please.
copy, my lord.
Please give it.
I'll highlight it to this court, my lord. This is a
When is
date
this?
where
When is
2030.
the-
Tomorrow is for the cross-examination, my lords. I am going on with the cross-examination.
24th of June, 2024 is the order. This MC is filed in 2021.
My lords, retaining all my gold jewels, all my educational
That is a
certificates.
That is the merit of the case, my lord.
Harassing, my lords. He is harassing like anything.
Kept
He is
by-
spoiling the life of a woman who has been postgraduated. By
Whether
consent
the man
only,
is-
yes.
Whether the man is spoiling the life of women or women is spoiling the life of man. Both of them have come to the court. There is a
Yes, my
procedure.
lord. He has
They have
come to the court,
follow.
my lords. I
They
have
can
the-
have,
I have given him the option that I am ready to rejoin
They
it.
can have their own reasons. When they have filed the petition, they have to go. Nobody has any right to waste the court's time. It is man or woman, it doesn't matter to the court. Who has wasted the time has to pay for it.
My lords, I have not sought any stay of
I'm
this
looking
out
at
of
it.
this.
I'm looking at
And
it.
I am going on with the cross examination, my lords. And till today, he has not paid a single pay, my lords. I am earning myself and I am taking care of myself on the basis of my salary.
During pendency of the proceedings, my lord, one or the other application has been filed, my lord. Kindly look into the application filed by the petitioner
No,
in
you're
this, my lord.
saying
Other
that-
applications, my lord. Since from 2013 or
No, I-
2023 onwards, it's going
If
for
both
cross
of you
examination.
argue at a time, what I
Sorry, sir.
expect in this court is court has all the patience
Sorry,
to
ma'am.
hear to both the advocates.
Sorry.
Only my difficulty is I can't hear both people at once. What I am asking you is, you said after this petition is filed from 2023, they are not proceeding with the cross examination.
The stage is for cross examination, my lord.
You have shown me this, you have
No, I'm-
placed this, where from you get the further proceedings? This is only till 21/9/2023. Where are the
During-
further proceedings?
That is what I'm saying, my lord. In between, they filed another application before the same court.
Yes, what did you write? No, before that? Cannot seek the, and the same has to be rejected. The husband has taken objection to the same and filed his objections. The court, by order impugned, had dismissed the petition and has observed that in paragraph number 5 of the petition, the petitioner had specifically averred that on the date of marriage, nuptial was arranged so and so in the house of the respondent, but she complained that she was not happy with the marriage and refused for consummation of marriage and asked for 6 months' time to accept the petitioner as a husband, and her behavior continued the same. Petition amendments clearly make out with regard to the cause of action for filing the petition. On the other hand, there is no law barring the husband from filing petition under section 13(1)(1)(a) of the Hindu Marriage Act. As per the petition amendments, marriage between the husband and the wife is solemnized as per the Hindu customs and rituals, and the photograph substantiates such rituals having followed. The respondent had admitted the contents of paragraph number 2 and 3 of the petition with regard to the solemnization and registration of the marriage. Though the application is filed under Order 7, Rule 11A and 9D, there is nothing to make out that the husband being, the petition is being barred by any law. If the contention of the applicant is looked into, whereby she had stated that husband had made allegations against her, saying that she is sadistic and treated the husband with cruelty. So in turn, this has caused mental cruelty to the wife. It is a contention that the governments of the petition is manifestly vexatious and without merit. So if at all the contentions alleged in the petition are without merit, it has to be brought out by means of evidence and proved by preponderance of probability. Whether the petitioner himself is wrongdoer is also to be established after a full-fledged trial. Hence, the application filed by the petitioner, by the wife, is dismissed. Learned counsel appearing for the petitioner, wife submits that all the allegations that are made does not amount to cruelty, and according to them, there is no cause of action for filing the petition, and the same has to be dismissed. The land counsel appearing for the respondent submits it's a MC of 2021. From 2021 till 2025, the wife, one after the other, is coming up with the applications and but not proceeding with the trial. It is submitted that this is one of such vexatious petition filed by the wife. Next, having heard the counsels on either side, peruse the material on record. The present application is filed under CPC. So is filed under Order 7, Rule 11, A and D. Order 7, Rule 11A and D reads as below. It's to extract entire Order 7, Rule 11. CPC. What is there? Why CPC will not be there in the court?
They have given the new edition that about the FBA Act.
So and so. This, the extract that part. This court, for the first time, has coming across an IA seeking rejection of the plaint at the threshold, saying that what are all the allegations that are made or not or will not amount to cruelty, and in fact it amounts to cruelty on the imposed on the wife, and the wife wants the court to decide the application and say that as the husband has called a statistic and he has stated about made several amendments, and as such that does not amount to cruelty, and there is no cause of action for the husband. This is a novel ground invented by the wife, and on these grounds, if the applications of on these grounds, if this application under Order 7 to 11 is allowed, every petition has to be dismissed. If at the threshold, if the court has to decide that whether the said allegations amount to cruelty or not, there is no need to conduct a full trial. Order now, this application is filed under A and D. So Order 7, Rule 11A says where it does not disclose a cause of action. According to the wife, the cause of action, what is shown by the husband, is not a cause of action, and it is not cruelty. Hence, on that ground, it has to be dismissed. Then the D is where the suit appears from the statement in the plaint to be barred by any law, where it is not filed into, where the suit appears from the statement in the plaint to be barred by any law. Under which law the present petition is barred is not stated. On the face of it, this application that is filed by the wife only is an vexatious application, only for the purpose of dragging on the proceeding. This kind of an application is filed, and the court was right in dismissing the petition. Hence this writ petition is dismissed with costs of rupees 10,000 to be payable to the Advocates Association.
My lords, the cost may be kindly waived because no maintenance has been paid by the respondent, my lords hearing. My lords, I filed application also, even the court has not seen the application also, my lords, and moreover, he is harassing me like anything.
Yes.
My lords, cost may be kindly waived, my lords.
Yes, yes.
66.
My lords, I have the option of filing, and according to
court has the option of imposing
my lords,
the
cost kindly, my humble
what
submission
is
is,
this kind of, like anybody will file that kind of an application. What is that application?
my lords, there was an option, I saw several.
Option
My lords,
is-
Honorable Supreme Court has passed several judgments on this, so finding out that I have filed this application
now-
saying that.
If the Honorable Supreme Court has passed several orders, if by this order of the court is wrong, you can question it before the Honorable Supreme
My
Court.
lords, my only submission is kindly waive the cost, my lords.
So that your client will be careful in trying all these kind of petitions again and again.
My lords, I apologize for that, kindly, cost may be waived, my lords.
No cost. Yes, next.
Number 66.
21, there can't be any direction.
66.
I'm
Balakrishna,
appearing for the petitioner in this
Which
matter,
one?
my lord.
But I filed a memo of calculation the last day.
The memo of calculation filed by the my Lord Fund on the last date of a hearing, that is total dues are 7 lakh, arrears
7
are
lakhs 10,000.
7,10,000.
This is matter on 29/7. By the time the petitioner shall get clear instructions about when and how the amounts will be paid.
Yes, today I'm tendering DD for rupees 3 lakhs.
What is the amount?
7,10,000 total arrears.
That is in the 125 proceedings. Yes.
No, what if 125 is before this court? We are
Here,
not-
my lord, they come up with the application challenging the impounding of passport. Never appeared before the.
The executing court,
Never
the
challenged.
challenge in this petition is that the executing court has passed an order to impound the passport.
Before the executing court, what is the amount? Amount,
Yes.
for what execution is filed? They
Execution.
filed an execution petition for
Yes.
recovery of
Yes,
some
yes.
amount. What is that some amount?
Yes, my lord, it is there in the petition.
Application was filed in the year 2021 for rupees 2,30,000.
Yes.
That was filed on 16/7/2021. My application was the filed in the 2019, ordered in the year
So-
2021.
So as far as, so from there, how much it will come?
Now 7,10,000
Yes.
till today, 10,000.
So
And-
let him say what is that he's going to do.
Yes, now today I'm tendering
Hmm.
DD for rupees 3 lakhs, my lord.
Hmm.
So rest of the arrears of amount I would pay within 4 weeks.
Within 4 weeks.
Yes, yes, my lord.
We'll record that undertaking. Take that DD.
Lord, one more order in which he has to pay. My difficulty is
No, please understand.
securing his presence.
Whatever that is under
So
the
like-
sun, the court can't, whatever is before the court,
Yes,
the
yes, my
court
lord.
can take care.
Yes.
Now, in execution, court has passed an order. But the court has a power to impound the passport is the first aspect.
Lord,
So
he is
please tell
not.
the law in execution of proceedings under 125 or in MCA, whether the court had the powers to impound the passport.
Lord, the conduct of the petitioner. Lord,
Law.
As per
We are
the
on law.
Passport Act, Lord, the Passport Authority,
Not Passport
on the base
Act.
of court order,
Not Passport Act, you have to come to the court, to the, which court has passed the order. So that's why you know what is law.
Yes.
Please go into that, not go, don't go to that. Now what we do is, we'll grant a stay on
Yes,
this order.
yes, ma'am.
And the DD you have given.
Yes.
I'll list this matter exactly after 4 weeks.
After 4 weeks.
By that date-
I will pay the arrears of maintenance, my lord.
That what are the entire amount is 7 lakh
7,10,000.
10,000.
One-
3 lakhs you have paid. In
Yes.
next 4 weeks, you are going to pay another 7 lakh, 4 lakh
So
10,000.
another 3 lakhs I will pay.
No, you said the arrears.
4
next
lakhs,
to-
10,000.
I will try to settle the entire arrears.
No, they should, because the order is a conditional order.
Yeah, yes, my lord.
I'll say, if not 4 weeks, we'll grant you 5 weeks entire amount.
Lord,
The-
one more, my apprehension is,
Hmm.
Lord, he is in sitting in abroad. Execution court has taken all the coercive steps issuing NBW, FLW, and securing his properties.
Then we'll
Finally
do one thing,
impounded.
we'll do one thing.
Lord,
No.
Yes.
3 lakhs you have paid. Now I'll fix a date, appear before the executing court. Whatever is the security,
No,
surety
no.
for your appearance, please execute before.
No, your lordship, now the petitioner is
What
in,
is the undertaking that he will not
No,
leave the country?
no,
again?
he is in Dubai.
He is in Dubai.
Yes, he is working there, my lord. Now, because of impugned order, he is not able to renew his passport. No, he can't come down to India now. That is the problem.
Hmm.
Now, thing is, my lord, arrears is 7 lakh.
We'll do one thing.
Yes, I will pay within 4 weeks arrears of
No, pay that
maintenance.
3 lakhs,
Yes.
whatever you're saying for the remaining.
Yes,
Let him, you get an affidavit from him.
pardon, my lord.
Get an affidavit from him.
Yes,
I will pass an order.
Yes.
Before passing an order.
Yes.
Whatever you are submitting that he will do so and so by so and so.
yes.
For that, you get his affidavit. Let him file an affidavit before
my
the court.
difficulty to.
Allah, affidavit for what purpose, my lord?
Stating that I will
Yes.
be depositing so and so amount. by
Yes,
so and
I
so.
will pay it. It is my undertaking. It is my undertaking before this court.
Not give the undertaking to the court.
Now, on behalf of my client, I am giving the undertaking.
Cannot, for those the kind of things are.
Yes,
party
it
has
is, it's my instruction. It's my instruction.
instruction, but I want an undertaking before.
Yes, my lord, yes. Within 4 weeks, I will pay the balance. Yes.
He will record it, but within 2 weeks, I want his affidavit to be on record, that he will be paying the entire amount by
Yes.
so and so date. I'll
Be-
record
Because
it.
he is in Dubai,
10 days.
it's finding difficult to get the affidavit also.
What, no
that's what.
difficulty, there they can get it within no time, that's not the
Yes.
difficulty.
While sitting in Dubai only, he filed a petition, Lord. Then how can he show the affidavit, the writ petition? One more thing, one more submission. I am not coming the way of that undertaking.
One more thing is divorce has been granted. In that also 10 lakhs has been awarded. That amount, Lord, even if it is
You please
impounding
ask
order
your
is,
client, you please ask your client anything she wants further.
that is what
Everything,
I
no,
was
no,
conveyed him
no,
the,
no, everything you write on a paper and we'll ask him to file affidavits for everything.
please. For executing this order also, I have difficulty.
No, he has to file separate proceedings
Once it
if that
impounding
is the
order
case.
is stayed.
My instruction is there, that my lord.
What
She
the
has
court-
married second time.
What the court is saying, both of you are not understanding.
Yes,
I said he cannot ask all that.
yes, my lord, yes.
They understand, Lord. Once it is impounding order is
Then I
stayed.
will not pass this also. I'll straight away set
No.
aside this order. Yes. The land count on the last occasion, the matter is adjourned. The petitioner as matter came up on 17/2/2025. On the day, this court has adjourned, the writ petition is filed, questioning the jurisdiction of the court in impounding the passport in the process of recovery proceedings, in the execution proceedings. This court has directed the petitioner to, the landed council to find out about when and how the amounts will be paid. Land counsel for the respondent wife submits that the outstanding amount is 7,10,000. Today, when the matter came up, land counsel for the petitioner has given a DD for an amount of rupees
3 lakhs.
3 lakhs to the respondent, counsel for the respondent. It is submitted that he'll be paying the remaining amount of 4,10,000 in the next 5 weeks.
Yes.
5 weeks. In that regard, within 2 weeks from today, that is by 13th of August, an affidavit shall be filed before this court by the petitioner that he will be paying the amount within 5 weeks from today. Considering the fact that on instructions, the land counsel, the petitioner submits that the entire amount would be paid. There shall be stay of all further proceedings pursuant to the order dated so and so. List this matter on to that I said the date, no, 14th, 13th. List this matter on 13th.
Then number 67 adjourned.
13/8, my lord.
38.
13/8, 2 weeks. That day you will be.
Before that, I have to file the affidavit. That's all.
Yes.
Much obeyed.
68, Vijeta Nayak for petitioner.
I appear for the petitioner. Your Lordship. The
Appear for
petitioner
the
herein is the
respondent.
husband and the respondent is the grandmother, Your Lordship. The petitioner is gainfully employed and the respondent grandmother is around 62 years and she herself is dependent on her or other daughter, Your Lordship. Now, after the death of the petitioner's wife, she died in 2023 because of cancer. After that, he becomes the natural guardian of the child, of the girl child who is 4 years, Your Lordship. So he had sought for custody of the child for at least on weekends from 6 p.m. Friday to 6 p.m. on Sunday. But the learned trial judge had given only for 1 hour visitation in a month, that is every third Saturday, which was later, that was challenged over here, Your Lordship. And an interim order came to be passed wherein the petitioner was allowed to see his daughter in the Bangalore Mediation Center on the 1st, 3rd and 5th Saturday.
When the mother died.
2023, Your Lordship.
How old is the daughter then?
Daughter is 6 months, 6 months.
Now, in
2.5 years.
Then?
Yes.
Now she is?
4 years.
So what is the difficulty?
May, please.
I'm relying on the judgment of the Honorable Supreme
Let's
Court.
not go into the judgments on all these aspects. Let's see what the factually it is. Yes.
The fact is, the respondent in the present case is getting rents and also earning income from the agricultural property. That is the first defense to her contention that,
We are on visitation, where from
no,
the.
no, because she made a submission that I don't have any
Not
income.
go, that
Please,
will not, only we are on the visitation.
please,
Why not at the place?
yes. I have no objection to the visitation right to be modified as regards an application has been filed. I have no objection to give visitation rights on first Saturday, third Saturday and fifth Saturday.
Not in the mediation center.
It's
In the mediation center.
Yes, yes.
So why you have no, like, they are the grandparents?
Yes.
They're the grandparents.
Yes.
What will happen if the child goes to the grandparents?
May I please just refer to the judgment passed by this court in an habeas corpus that was filed by the petitioner in 2023.
Please refer to the parties on as with their capacity, not petitioner and respondent, so that I can understand who are there.
The father,
Because-
Father filed the habeas corpus.
yes,
Yes.
Because the respondent was just not allowing the
One minute,
petitioner to
that's
see
in
the
case of
child.
this
Your
nature, two things are required to be. Custody is lawful, second. Who filed the habeas corpus?
The petitioner,
the father.
father.
You are appearing for the grandparents.
For the father, your lordship. I'm appearing for the father.
You
He
appear
being
for
the
the
national
grandparents.
guardian.
Grandmother.
Now the child is with the grandmother.
Yes, she
Yes.
does not even allow her she is.
It is
for
not
very
so.
long, she has not been allowing the father to see. He being the natural guardian, your lordship, what should he do? She makes all wild allegations against the father that the child will not be safe with the father.
That is what
The Honorable
this court-
Supreme Court has time and
No,
again held that the
this
father
court
is the
has
natural
held-
guardian, your lordship, after the death of the mother. And the respondent herself, she is an old lady, she's around 62 years. She is herself is dependent financially, she not independent, she is dependent on her other daughter, your lordship.
May I please. The reasons have been given in the order.
In a habeas corpus petition,
Please, my lord.
is not
Because-
maintainable, then will
No,
not
no,
go
no,
into the.
it is not so. The reason why the visitation rights were given is for a specific reason. Because after the death of the mother, the husband never visited the child.
Because he has never visited the child, he should never visit.
No, no,
Isn't
no.
so?
I'm not saying that he should not. He can. On 3 occasions,
Please understand that
Please.
grandparents will not be ever with the child.
because
So father is the next generation. So anyhow, she lost the mother. Mother is not a kind of suicide. She had died with cancer.
yes,
So why not the grandparents leave the child to have the bonding with the father?
no, in fact, at the time of the death, he never, at the time of during the treatment, he never visited the wife and the child.
All wild allegations.
It is
That's
not wild,
that
it is a fact.
It may be
The fact has been put forth
Maybe a fact. Let's accept that it's a fact.
because
Why the
safety,
father?
safety,
What safe?
safety,
How?
safety
what
of
are
the child, because she cannot get accustomed with a new environment. That is the reason.
No, if this kind of visitation is permitted, she will never be accustomed to the father.
No, definitely.
That's not the way.
No,
That's not the way.
because she's
No,
just
she should-
not
she
even
should-
4 years old.
She's
So
four, she's
that's the
completed
reason that this is the formative stages of life, that she should have the company of the father. Maybe let's say that he's a bad father, bad husband. But why should we think that he's a bad father?
No, I will not comment on that. No father may not be bad. Under the circumstances, present circumstances, the child is accustomed of living with the
Children are very flexible. It's only how we make them understand.
definitely. But shall I take instruction
Please
tomorrow?
take instructions and tell them that this visitation, now he has also, they have the paternal grandparents, the father is there. Let
Yes.
the child enjoy, have the
Please.
best of both the worlds.
Next week.
Not next week, we'll have it on Friday.
Friday.
Please, get instructions by Friday. This is matter on Friday by the time.
Please,
the-
Monday.
Monday. List this matter on Monday by the time the instructions, the land council, the respondent shall get instructions. Yes, next.
Cell number 69.
Obliged.
Jaya Prakash.
My Lordship,
One Nimisha.
as per the court order, the lower court order has been complained, my Lordship. The arrears was 6 lakh.
No, my lord, the order.
Yeah, he's asking for that order. Yes.
The arrears was 6 lakhs 90,000, my Lordship.
Where is the counsel for the respondent? Huh? Amount received?
Yes, ma'am.
Land counsel for the respondent submits it as per the interim order. The amount is paid. This is matter for hearing.
And there is a slight chances of settlement, my Lordship.
Shall we refer it to the mediation? Where the parties stay? Bangalore only?
Bangalore.
It is submitted that there is a likelihood of settlement. Both the parties shall appear before the Bangalore Mediation Center. What are those dates? 8th? 7th of August.
Much
Yes.
Serial number 70, 71 adjourned, 72 for judgment, 72.
I appear for the respondent in this matter, Lord.
Yes. Interim order, earlier matter, interim order earlier granted is extended. Yes, 72.
72.
My lords, this matter was listed for orders, my lords. There was an arrears of 8 lakhs.
Come to the court and argue. List this matter after 4 days on 13th of.
My lords, arguments were concluded, my lords.
73, final hearing.
Interim order is there in that extent. Yes, final hearing matters.
73, final.
Tomorrow is Thursday.
Tomorrow is
All
Friday.
these matters only tomorrow, all MFA matters.
73.1. I have a problem because this insurer has made an attempt to ascertain the death certificate of the deceased. We could not locate, madam. Nobody is there in the particular location. That is the problem.
What do you want? What do you want?
I'm helpless. I'm in a helpless position, madam.
That's what we'll see. What is that helpless position? If I hear the matter, then I'll know. We'll have it. All these MFA matters will come tomorrow in the list. Because Thursday only MFA. Don't post other matters except date given matters. Yes. And ask them to come. Let me tell that what is the list. Already there are enough number. Some more. It's a batch is there on 77, I think. Yes. What is this 81? Not 81, 80?
Serial number 80. I am for the respondent, my lord.
Not 80, 79
But
also.
I am for the petitioners, my lords, in this case. In this case, my lords, it matters request.
79.
Something you have to increase the sound that is reduced. Sound is reduced.
ಅವರು ಕಿಸ್ತಿದ್ದಾರೆ.
My lords, serial number 80, my lords.
Yes.
My lords, I am for the.
79, serial number 79.
Sorry, my lords.
Yes, 79, who appears?
Yes, Satiraj.
Yes, 79. List this matter on 3rd of September. And then what about 81, 80?
80, my lord, in this case, only, my lord, the wife has received only 30,000. The court has ordered maintenance on 20,000 to the wife, 6,000 to the child, and also the school expenses 1 lakh. Till
Yes,
today,
Mr.
my lord,
Mohan,
I
whether
have
the
received
interim
only.
order is complied with or not?
My lord, I need to find out instructions, my lord. Only the one thing I would like to just place you before lordship is that, my lord, before the trial court in a span of 30 days, the entire petition got over, my lords. So I had appeared before the trial court and had said that I'm willing to take back the wife. And the matter was adjourned for a week, my lord. Then afterwards, my mother falls sick, and within 1 month, I go back and the judgment has been.
Is there any scope for settlement?
My lord,
She wants to join.
my lord,
That is on record, my lord.
Yeah, my lord, he filed, my lord, conjugal rights, my lord. I filed, my lord, maintenance. My lord, even though matter has been referred to the mediation, he is not appeared. Thereafter, my lord, he himself, my lord, appearing before the court, he is not engaged in any counsel trial court, my lord. He absent, my lord, he order sheet. My learning firm produced order sheet. He never appeared before the court. Only appeared only one time, my lord. He
I
himself.
asked you whether there is any scope for settlement or not.
She is, my lord, not ready to go to, my lord.
Not ready. Then one simple answer. Why you are hesitating?
Even
to
my
say
lord,
that?
regarding
No,
the.
please ascertain what are the arrears as per the interim order, and that has
Yes,
to be
ma'am.
cleared.
Yes, my lord.
As per the interim order passed by this court.
No,
Look
interim
at
order not yet passed. This matter is coming, my lord, second
for
time.
25 matter. Then we'll hear it on Monday.
Please, my lord.
List this matter on Monday. Both of you are there.
Please.
Yes, 81. 81 is done. Yes. You were not there. Both of you. What to do?
You finished drafting the terms and
It
conditions.
is
ma'am.
done.
It is done
Only
one point
I think I have a meeting now, tomorrow morning I'll take up.
tomorrow morning.
List it as for.
Your Lordship, can it be 2:30 tomorrow?
Why?
Tomorrow, Your Lordship, some other matter.
Can you, list it at, matter at 2:30.
2:30, yes. My lord, if my lord can just intervene and request the child to meet the father. He's come all the way from Gujarat. If they can spend some time tonight for dinner tomorrow morning, please, if they can request them without the intervention of the mother. That's all we are requesting. Let me spend some time with the child.
You have to request her and you have to see that it is done.
In some mall.
You know what is the responsibility?
Yes.
Yes. Where is the passed over matter?
Passed over 3.
This matter, list it as item number 1 tomorrow.
Already there.
Lordship, that is nothing, maintenance is awarded,
This court has to.
maintenance is awarded,
They are talked from 9:30 to 1:30.
no information, my lordship, no information.
I'm not
No,
coming in the way.
they are avoiding to pay maintenance, that's
Mr.
all.
Counsel, please don't shout. Don't shout, I can hear.
No, it is not.
You have a mic also, why are you
Sorry.
shouting?
Allah, your
Please
man,
wait.
kindly see.
Mr. Counsel, when I say please, we should stop.
Lordship.
Don't you have instructions from your client?
No, no.
Why have you called?
Yes, I called.
When you called?
Yesterday night.
Today, when they're saying the
No,
the
Lordship, she
mediation
would
is.
have informed me, 100%, she said that it's there in experiment.
Mr.
I'm going to
Counsel, when
inform.
repeatedly they're saying,
No,
why
Your
can't you
Honor,
call your client?
not at all. No,
This is a matter
It is-
tomorrow.
Yes. I'm ready.
Item number 1.
ready, Lordship, that is, I see,
This is
some, serial number 3, amma, serial number 3. ನಾಳೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. Top of the list means number 1.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಮೇಡಮ್ ಲಿಸ್ಟ್ 37 ಮೇಡಮ್ 37 ಲಿಸ್ಟ್ 2
Madam, list 175.
In chamber ಇದೆಲ್ಲ ಅದ.
ನಾಳೆಗೆ ಸರ್.
ಎಲ್ಲ ನಾಳೆ.
In chamber ಅಲ್ಲ ಅದು.
MFM
42 ಅನ್ಸುತ್ತೆ.
42 ಅವ್ರಿಗೆ ಅವರು ನಮಗೆ ಹೇಳ್ಬೇಕು.
42ನೇ. ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಬರ್ದ್ಬಿಟ್ರೇನೋ ಅವರು ನಾಳೆಗೆ.
ಹೌದು. ಆನಂದಿತಾ ಚಕ್ರವರ್ತಿ ಅವಳು.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 37.
ಬರ್ದಿದ್ದಾರೆ ಆಲ್ರೆಡಿ.
ಮೇಡಮ್.
ನೋಡಿ ಮೇಡಮ್.
ಮೇಡಮ್.
ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು. TS ಬರ್ದಿರ್ತಾರೆ ನೋಡಿ ಮೇಡಮ್. TS ಇವಾಗ ಸೈನ್ ಮಾಡಿಸಿದ್ರಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಡಿಸ್ಮಿಸಲ್ ನಾಳೆಗೆ
ಮೇಡಮ್ TS ಬರ್ದಿರ್ತಾರೆ ನೋಡಿ ನೀವು ಸೈನ್ ಮಾಡಿಸಿದ್ರಲ್ಲ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 37.
ಇದು 3 ಟಾಪ್ ನೋಡಿ ಏನ್ ಮಾಡೋದು ಇದು ನಾಳೆಗೆ ಅಂದ್ರ
ನಾಳೆಗೆ ಡಿಸ್ಮಿಸಲ್ ಕ್ಯಾಪ್ಷನ್ 2:30 ಲಿಸ್ಟ್ ಮಾಡ್ಸೋಣ ಅಷ್ಟೇ.
ಇದು ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಂತ ಹೇಳ್ತಾನೆ ಅದನ್ನ.
ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಅದು ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್. ಇದು 2:30 2:30 ಅಲ್ಲಿ ನಾವೇ ಹೇಳ್ಬಿಟ್ಟು ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಬೇಕಷ್ಟೇ 2:30
780 ಸರ್.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 9 ನೋಡಿ. ಲಿಸ್ಟ್ ಎಲ್ಲ
ಹೌದು 780
ಅವಳೇ ತಾನೆ ಮಾತಾ ಸಲ್ವಾ
ಮೇಡಮ್ MF ಏನ್ ಮಾಡೋದು?
ಸೀರಿಯಲ್ ನಂಬರ್ 42ನೇ ತಾನೆ. ಇರೇನ್ ಮೈಕಲ್ ಪೆರೆಸ್
ಮೇಡಮ್ 74 ಮೇಡಮ್.
ಇರೇನ್ ಮೈಕಲ್ ಪೆರೆಸ್
ಸದಾ ಇವಾಗ ಬೋರ್ಡ್ ಬೆಂಚ್ ಅವ್ರನ್ನ ಕರಿ ಒಂಚೂರು.
ಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ ಹೇಳಿ, ಸೀರಿಯಲ್ ನಂಬರ್
ಇದು
ಹೇಳಿ.
ಡಿಸ್ಮಿಸಲ್ ಗೆ ಕ್ಯಾಪ್ಷನ್ ಬರ್ದ್ಬಿಟ್ಟವ ಅವಳು.
ಲಿಸ್ಟ್ ನಂಬರ್ ಹೇಳಿ.
ಡಿಸ್ಮಿಸಲ್ ಅಂತ
ಹೊರಗಡೆ
ಅನಿಸ್ತಿದೆ. ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ನಲ್ಲ ಡಿಸ್ಮಿಸಲ್ ಎಲ್ಲ ಇರ್ಲಿ ಬಿಡಿ. ನಾನು
ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಆಫ್ 18 ನಾ?
ಆಯ್ತಾ? ಇಲ್ಲಿ ಬರ್ದ್ಬಿಟ್ಟವಳಲ್ಲ. ಲೇಟರ್ ಸಬ್ಮಿಟೆಡ್ ಅಂತ ಬರೆಯೋ.
ಬರೋದೇ ಇಲ್ವಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
55 ಇಲ್ಲೇ ಬರೀಲ್ಲ. ಅಲ್ಲಿ ಬರೀರಿ ನೆಕ್ಸ್ಟ್ ಬರೀರಿ. ಅಲ್ಲಿ ಸೈನ್ ಬೇರೆ ಮೇಡಮ್ ಬೇರೆ ಇಲ್ಲ ಇವತ್ತು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
ಈಗ 2:30 ಕ್ಯಾಪ್ಷನ್ ಇಲ್ಲ ನಿಮ್ಗೆ ಏನಾಗಿದೆಯೋ ಅದು ಬರೀತೀಯಾ?
ಮೇಡಮ್ NFS ಏನಾಯ್ತು ಹೇಳಕ್ಕಾಗತ್ತಾ?
ದಿಸ್ ಮ್ಯಾಟರ್ ಟುಮಾರೋ 2:30 ಅಂತ ಹೇಳಿದ್ರು. ಇದನ್ನ
ಇಲ್ಲೇ 230 ಅಂತ
ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಇದೆ.
ವೈಟ್ನರ್ ಹಚ್ಬಿಟ್ಟು
ಅಲ್ಲ ಇಲ್ಲಿ ನೋಡು ಟುಡೇ
ಮೇಡಮ್ ತಾವು ಬಿಡುವಾದಾಗ ಒಂಚೂರು ಅಟೆಂಡ್ ಮಾಡಿ ನನಗೆ ಮೇಡಮ್.
ಅಲ್ಲ ಈ ಕ್ಯಾಪ್ಷನ್ ಅಲ್ಲೇ 2:30ಗೆ ಹಾಕ್ಸ್ತೀನಿ ಬಿಡಿ. ಯಾಕೆ ಸುಮ್ಮನೆ ತಲೆನೋವು? ಇದೇ ಕ್ಯಾಪ್ಷನ್ ಅಲ್ಲೇ
ಇಲ್ಲಪ್ಪ ಅದೆಲ್ಲ ಬರ್ದು ರಿಸೀವ್ ಮಾಡಿ. ಮೇಡಮ್ MFA ಕೊಡೋದ್ ಬೇಡ ಅಲ್ವಾ?
ಇಷ್ಟೆಲ್ಲಪ್ಪ
ಅನಿತಾ ಮೇಡಮ್ MFA ಕೊಡೋದ್ ಬೇಡ, ನಾವೇ ಬರೆಯೋಣ. ಮತ್ತೆ ಸೈನ್ ಎಲ್ಲ ಹಾಕಕ್ ಟೈಮ್ ಆಗಲ್ಲ.
MFA ಎಲ್ಲ ರಿಪೀಟ್
ನಾವೇ ಬರ್ಕೋತೀವಪ್ಪ. MFA ಫೈನಲ್ ಇಯರ್ ಹೇಳಿದ್ರಲ್ಲ ಅದನ್ನ ಮಾತ್ರ.
78, 79 ಎಲ್ಲ ಕೊಡ್ತೀನಿ. 79, 80.
73 ಇಂದ 78
ಒಂದ್ ನಿಮಿಷ ಇರೋ. 68 ಆಯ್ತಾ?
69 ಆಯ್ತಾ?
73 ಇಂದ 78 ವರೆಗೂ ನಾವು ಬರ್ಕೋಬೇಕು.
72 ಕೊಡಿ.
72 ಇಂದ 72 ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ.
73, 74, 76.
73, 74,
74 ಏನಾಯ್ತು ಮೇಡಮ್?
77, 78, 79,
80 ಇವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ.
80, 79, 80 ಎರಡು ನಿಮ್ಗೆ ಅಲ್ಲೇನು? ಹಾ 79, 80 ಬರೀ. ಇನ್ನು ಉಳಿದಿದ್ದು ಬರ್ಕೊಳ್ಳೋಣ. ಇದು ಇದ್ರೆ ಬಿಡಿ 2:30 ಲಿಸ್ಟ್ ಮಾಡಿಸ್ತೀನಿ. ಅವಾಗ ಬಂದು
ರಿಸರ್ವ್ ಆಯ್ತಲ್ಲ
ತಗೋ
ತಗೊಳಪ್ಪ ಸೈನ್ ಮಾಡ್ಬಿಟ್ಟು.
ಇದು ಮಂಡೇಗೆ ಹೇಳಿದ್ರು.
ಯಾವ್ದು?
183 ಲಿಸ್ಟ್ ನಂಬರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 80.
ಸೀರಿಯಲ್ ನಂಬರ್
80 ಮತ್ತೆ 79.
ಅವ್ರಿಗೆ ಹೇಳಿ ಇದು ಅಪ್ಲೋಡ್ ಮಾಡೋದು 2:30ಗೆ ಅಂತ ನಾನು ಹಾಕಿಸ್ತೀನಿ ಬಿಡಿ.
ಹಾ ಅದು 79 39 ಅಲ್ವಾ ಮೇಡಮ್?
ಯಾವ್ದು?
79
79, 39,
80 48.
48.
ರಿಸರ್ವ್
ಕೊಡಿ ಅದು ಸೈನ್ ಇದ್ರಲ್ಲ.
ಇದು ಬಿಂದ್ಯಾ
ಮೇಡಮ್ 74 ಯಾವತ್ತಿಗೆ ಹೋಯ್ತು ಮೇಡಮ್? ಕೋರ್ಟ್ ಆಫೀಸರ್